are agreed upon by the majority's judges. And when Sovin reported to Justice Peters for the details of her assignment, he gave her perplexing news. He said, "We have 4 votes for vagueness," she recalls. I said, "You must be kidding. Vagueness?" And he said, "That's what we got 4 votes for. Now go write it." Vagueness was a doctrine courts had developed, so part of the general constitutional principle that citizens are entitled to fair treatment under the laws, which requires, at a minimum, understanding what it is that a given law prohibits. A statute could be overturned on grounds of vagueness. The U.S. Supreme Court had ruled many years earlier. If persons of common intelligence must necessarily guess at its meaning and differ as to its application. Now, Sovin was being told to write an opinion explaining why the old California abortion law was unconstitutionally vague, which seemed to her both preposterous and ultimately self-defeating, since all it promised to produce was a more carefully written law that kept abortion illegal. She had her orders. She had done her research. She had once read a local newspaper columnist define legal precedent as one court taking in another court's laundry, which struck Sovin as a useful metaphor, each court examining what the previous court had placed into the bundle. And that was when I decided to pack it, Sovin recalls. I was really resolved to give them a big bunch of laundry. Into the theory that Sovin didn't believe, it had never seemed to her an exceptionally vague law. It said abortion was illegal unless the same is necessary to preserve her life. And moreover, the law that contained that line wasn't even in the statute books anymore. The law clerk packed the theory she did believe. We have no standard definition of necessary. We have no enlightening definition of preserve. We have no clarification on how immediate is death supposed to be, etc. All this went into the opinion, explaining vagueness, why the law was impermissibly unclear. Then startlingly, 24 paragraphs into the text, it reads, "Moreover, a definition requiring certainty of death would work an invalid abridgment of the woman's constitutional rights. The rights involved in the instant case are the woman's rights to life and to choose whether to bear children. The woman's right to life is involved because childbirth involves risk of death. The fundamental right of the woman to choose whether to bear children follows from the Supreme Court's and this Court's repeated acknowledgement of a right to privacy or liberty in matters related to marriage, family, and sex. That such a right is not enumerated in either the United States or California constitutions is no impediment to the existence of the right. It is not surprising that none of the parties who have filed briefs in this case have disputed the existence of this fundamental right." The language kept appearing. Crimson shirts amid the plain white sheets, all the way through the People versus Velas void for vagueness opinion. The great and direct infringements of constitutional rights, an invalid infringement upon the women's constitutional rights. The pregnant woman's right to life takes precedence over any interest the state may have in the unborn. At first, Sovin wrote it into footnotes, but her senior clerk at the court had taught her no, either put it in the opinion or take it out entirely. So she put it in. And even when her drafts were reworked by others, the constitutional rights language stayed. I knew exactly what we were doing and what I wanted this to be used for, Sovin recalls. And when it was done and published, she was quiet about it, watching to see what would happen. Just sit back, Sovin remembers, and wait for the apples to fall. The ruling was issued in September 1969, and the apples began falling almost at once. This is the first state Supreme Court decision in the history of the nation which declares unconstitutional any anti-abortion statute, wrote Keith P. Russell, a Los Angeles obstetrician who had helped found the California Committee for Therapeutic Abortion. In an elated letter to his fellow signers of the medical school dean's friend of the court brief, he continued, "It is a landmark decision. In voiding the pre-1967 anti-abortion law, the California Supreme Court has pointed the way for approximately 40 states with virtually identical laws allowing abortion only to save the life of the woman, to have their laws declared unconstitutional, or to reform such laws by legislative action. Legal attacks have already begun in other states." The legal attacks were gathering both in state courts and in federal courts. And on November 10th, a U.S. District Court judge in Washington, D.C. delivered the next surprise. Because it was impermissibly vague, the judge had declared unconstitutional the felony abortion law of the District of Columbia, which had been challenged by an indicted physician and permitted abortion only when necessary for the preservation of the mother's life or health. The ruling, pending a Supreme Court appeal, made Washington, D.C., at least temporarily, the only jurisdiction in the United States with no statutory restriction on abortion by physicians. And in St. Louis, during the early months of 1970, Frank Sussman studied the printed opinion in Bellis and led off his complaint, the causes of action under which the Missouri abortion law might be found unconstitutional with vagueness. Number 1, said sections 542.380, 559.100, and 563.300 of the Missouri Revised Statutes, 1959, as amended, challenged herein are unconstitutionally vague and uncertain on their face. But that was not nearly enough. If a judge was going to be asked to stretch, to read between the lines and fit together new ideas, it was important to offer him considerable stretching room. Missouri judges were not like California judges, to understate the situation almost comically, and Sussman assumed he was going to have to mention, at least in passing, every argument that had so far been raised in the abortion briefs prepared by his colleagues in other states. Number 2, said statutes challenged herein on their face and as applied deprive plaintiffs of the right to privacy in the physician-patient relationship, which is protected by the 1st, 4th, 5th, 9th, and 14th Amendments to the United States Constitution. Privacy, that was number 2. The Bellis opinion had talked about privacy even as it was supposed to be talking about vagueness. The privacy cases U.S. Supreme Court decision called Griswold versus Connecticut were by the close of the 1960s being examined by abortion lawyers as another promising route to the overturning of abortion laws. A former Supreme Court justice named Tom C. Clark, who had resigned from the court in 1967, wrote a 1969 Law Journal article exploring the developing doctrine of the right of privacy and its possible application to abortion law challenges. And although Clark's article was not exactly a call to arms, He concluded by arguing that trying to change abortion law case by case in the courts would be slow, expensive, and possibly disastrous. It was read in some quarters as a signal from an extremely well-placed source that the Supreme Court might consider this an approach worth pursuing. State prohibitions on abortion as impermissible encroachments on the personal privacy guaranteed by the U.S. Constitution. The very idea that the Constitution contains such a guarantee, that constitutional protections encompassed, as the Bellis opinion had put it, a right to privacy or liberty in matters related to marriage, family, and sex, was in itself less than a decade old. The phrase right to privacy had been introduced into legal discourse more than 80 years earlier. But for many years it was invoked principally to describe a person's right to fend off unwanted intrusion by other persons, overly aggressive newspaper reporters, for example, or advertisers trying to use a personal photograph in an advertisement without the subject's permission. It was not until 1965, in a case involving the sale and use of contraceptives, that a Supreme Court ruling first gave the word privacy the meaning that now appeared to hold such interesting potential for abortion law challenges like the one Frank Sussman was trying to assemble. Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? Justice William O. Douglas wrote for the majority in that 1965 case, Griswold versus Connecticut. The very idea is repulsive to the notions of privacy surrounding the marriage relationship. We deal with the right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is coming together for better or for worse, hopefully enduring and intimate to the degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. Yet, it is an association for as noble a purpose as any involved in our prior decisions. The Supreme Court's ruling in Griswold v. Connecticut was the culmination of a long campaign to permit the use of birth control in a state whose criminal code prohibited it. Before 1965, the Connecticut birth control law was among the most restrictive in the United States. It banned not only the distribution and purchase of contraceptive devices, but also their use. Any person who used a contraceptive in Connecticut was guilty of a felony. It was, as one of the Griswold Supreme Court opinions was to observe, an uncommonly silly law. Condoms could be purchased legally under the fiction that they were to be used for the prevention of disease. And it was widely understood that women could sometimes obtain contraceptives surreptitiously from private physicians. But the Planned Parenthood League of Connecticut could not by law perform what was in those years the principal function of any Planned Parenthood clinic, which was to provide women with birth control devices. During the late 1930s, Planned Parenthood did dispense contraceptives at a few Connecticut clinics, but in 1940, when the Connecticut Supreme Court upheld the state anti-contraception laws, the contraceptive service ended for the next 25 years. A detailed account of the early Connecticut legal battles and their impact on subsequent cases appears in David J. Garrow's Liberty and Sexuality, The Right to Privacy and the Making of Roe v. Wade. For some years before 1965, Planned Parenthood had worked in Connecticut as an odd combination of lobbying organization and jitney service, making futile feints at the legislature and ferrying station wagons full of women across state lines to be fitted for diaphragms. The shuttle runs had been started up by Estelle Griswold, the League's energetic executive director, who had seen both the practical and public relations merits in driving carloads of grown women into New York and Rhode Island, where artificial contraception was legal. You could really publicize that in your pamphlets, Griswold recalled in an oral history many years later. I had a drawing made of a group of women in a car waving flags and going toward Fort Chester, New York. It was Estelle Griswold, according to a legal legend, who first brought together two Yale professors with a common distaste for the Connecticut birth control law. Lee Buxton, the recently appointed obstetrics and gynecology chair at the university's medical school, and Fowler Harper, a popular law school professor who was known as an outspoken liberal. Catherine Rohrabaugh, a Connecticut attorney who worked on the case with the Planned Parenthood League, recalls that the collaboration was said to have begun over Griswold's martinis. She was notorious for her martinis, Rohrabaugh recalls. She put Lee Buxton and Fowler Harper in touch with each other, gave them each a drink as the story went, and left them to their conversation. The product of that 1957 cocktail party conversation was a constitutional attack 7 years in the making. The Supreme Court had never before addressed what appeared to be the central question presented by the situation in Connecticut. Did a state legislature, presumably expressing democratically the will of the community at large, have the right to criminalize the use of birth control by married couples? Or did the U.S. Constitution contain some overarching protection that prevented states from enforcing laws which intruded so directly on the privacy of married couples? Was there a personal right of privacy that in certain situations outweighed the state's right to control the behavior of its citizens? It took the Connecticut attorneys 2 separate tries to bring these questions directly to the attention of the United States Supreme Court. Their first lawsuit, brought on behalf of Dr. Buxton and of 2 married couples, complaining that the anti-contraception law kept them from receiving proper medical treatment, was dismissed by the court on the grounds that since the law was almost never enforced, there existed, in legal terminology, no controversy, no actual circumstances warranting Supreme Court intervention. But the ruling was a close one, 5-4, and in their dissenting opinions, Justices William O. Douglas and John Marshall Harlan argued that the court should have taken on the married couple's complaints, and that the Constitution did protect what Harlan called their right to enjoy the privacy of their marital relations, free of the inquiry of the criminal law. Even though the framers of the Constitution never wrote the word privacy into their written guarantees of individual protection, Harlan argued in his long and influential dissent in the first Connecticut birth control case, Poe versus Ullman, the idea of a right to personal privacy in intimate decisions involving marriage and family was implicit in various Supreme Court rulings dating back to the early part of the century. In the 1920s, for example, the court had ruled that states could not intrude into parents' relations with their children by forcing the children to attend public rather than private or parochial schools. In the 1940s, the court had ruled that the right to marry and procreate was so very basic that states could not require the sterilization of convicted felons. These and other rulings could be drawn together, Harlan argued, to prove that marital privacy was indeed a right protected by the Constitution, a qualified right to be sure. I quote him here, "I would not suggest that adultery, homosexuality, fornication, and incest are immune from criminal inquiry, however privately practiced," Harlan wrote, "but a right nonetheless." That's a quote from Harlan, not me. 5 years after that encouraging but ultimately fruitless set of Supreme Court opinions, the Connecticut birth control advocates came back to the court for their second trial. As set up for the new challenge, Estelle Griswold and Lee Buxton had opened a well-publicized contraceptive dispensing clinic in New Haven and cooperated eagerly in their arrest 10 days after opening day. Now there was an indisputable legal controversy. 2 individuals arrested and convicted of violating the Connecticut law. Griswold and Buxton were fined $100 each, and in June 1965, the Supreme Court handed down the ruling that formally gave new constitutional meaning to the term right of privacy. The Connecticut law was unconstitutional. Justice Douglas wrote for the majority because it intruded upon the zone of privacy created by several fundamental constitutional guarantees. We do not sit as a super legislature to determine the wisdom, need, and propriety of laws that touch economic problems, business affairs, or social conditions. This law, however, operates directly on an intimate relation of husband and wife and their physician's role in one aspect of that relation. Douglas' majority opinion in Griswold was to become famous among many generations of law students, chiefly for the elegant and somewhat mysterious vocabulary it used to identify the places in which this zone of privacy could be located in the Constitution. The Constitution's Bill of Rights, Douglas wrote, contains certain penumbras formed by emanations from those guarantees that help give them life and substance. And what exactly was a penumbra? Apparently, it was a semi-shadow. One law review author wrote after the ruling, having consulted his Oxford English Dictionary, the partially shaded region around the shadow of an opaque body, where only a part of the light from the luminous body is cut off. Like a shadow, in other words, Douglas' zone of privacy was a kind of shimmer reflected off brighter and more directly visible portions of the Bill of Rights. The First Amendment, for example, which guaranteed freedom of association and privacy from government intrusion. Douglas concluded his brief lead opinion with a rousing tribute to marriage. Quote, "A coming together for better or for worse, hopefully enduring and intimate to the degree of being sacred." And in a more businesslike concurring opinion, Justice Arthur Goldberg elaborated on the applicable protections of the Ninth Amendment, which declares that the people retain rights besides those explicitly and specifically named in the Constitution. Although the Constitution does not speak in so many words of the right of privacy in marriage, he said, "I cannot believe that it offers these fundamental rights no protection. The fact that no particular provision of the Constitution explicitly forbids the state from disrupting the traditional relation of the family, a relation as old and as fundamental as our entire civilization, surely does not show that the government was meant to have the power to do so." Legal scholars had exceedingly mixed reactions to the Griswold ruling during the first years after its release. Douglas' penumbra metaphor was subject to particularly biting attack, but the principle was now set. The Constitution protected a zone of privacy that included the right of married people to use birth control. Married was a crucial part of the Griswold ruling. The opinions made repeated reference to the sanctity of the husband-wife relationship and said nothing about the state's power to keep unmarried people from buying or using contraceptives. But among those interested both in birth control and abortion, the potential next steps were compelling to imagine. In June 1968, the North Carolina Law Review published a long article about possible constitutional routes to the dismantling of state abortion laws, and privacy led the list. The values implicit in the Bill of Rights suggest that the decision to bear or not bear a child is a fundamental individual right not subject to legislative abridgment, particularly in light of Griswold versus Connecticut. It is an anomaly that a woman has absolute control over her personal reproductive capacities so long as she can successfully utilize contraceptives, but that she forfeits this right when contraception fails. Clearly, no government is permitted to compel the coming together of the egg and the sperm. Why then should the state sanctify the two cells after they have come together and accord them, over the woman's objection, all the rights of a human being, in essence? The author of that law review article was a 27-year-old University of Alabama law professor named Roy Lucas, who in 1968 was working hard to establish a name for himself as one of the nation's leading scholars on abortion law. Lucas was an ambitious young man, possessed in those years of such an earnest passion that in both demeanor and physical appearance, he reminded Uta Landing, the German-born woman who became his first wife, of pictures she had seen of the young Robert Kennedy. They had met while Lucas was traveling in Scotland on a fellowship break from his studies at New York University Law School, and Landy remembers that even during the early months of their courtship, they talked at length about social issues and the pressing importance of changing abortion laws. Landy recalls, he had known a woman who needed an abortion during his previous student years. I believe he accompanied her to Puerto Rico and felt that it was absolute travesty that women had to go through this. He believed women should be able to have an abortion like any other surgical procedure, that first of all, it should not be illegal, and secondly, it shouldn't be a big deal. He would say to me that human beings are meant to control their lives. Landy herself was uneasy about abortion, as they argued. She had been raised in an intellectual German Catholicism, and she still had a feeling that a person had no right to interfere with a pregnancy that had apparently been ordained by fate. But Lucas would prod her, teasing her when she went to Mass, quoting the great philosophers, and calling the Catholic Church the thought police. By the time they came back to New York so that Lucas could finish his final year at New York University before accepting a teaching job in Alabama, he was fired with excitement about his coming career, Landy recalls, and had ideas of one day becoming a Supreme Court justice. He began making contact with some of the older attorneys and physicians who had formed the Association for the Study of Abortion. And he had begun to envision his North Carolina Law Review article, which Lucas had written in tougher form as a student essay in law school, as the first offering in a sequence of materials that would bring a major abortion law test case before the U.S. Supreme Court. In subsequent years, Roy Lucas was to become a controversial figure in abortion law circles, alienating many of his colleagues during increasingly bitter struggles over money and public recognition. And the earliest unpleasantness appears to have begun with that article. Some abortion lawyers insisted afterward that Lucas' long and carefully annotated study was the principal early roadmap to constitutional attack on state abortion laws, while others, particularly some of the women, would tell interviewers that they never even read Lucas' piece as they were working up their cases. But Frank Sussman certainly read it. By the end of 1969, Roy Lucas had moved back to New York and was hustling foundation money to start up a full-time abortion law concern, and with a weighty institutional name, the James Madison Constitutional Law Institute. He had begun sending sample briefs to attorneys all over the country. The reactions to Lucas' offerings were mixed. Margie Pitts Haynes, who had begun working in Atlanta on the Georgia case, was referred to the James Madison Law Institute. Rather brusquely, she recalled in an interview before her death in 1994, when she asked the ACLU National Office for help. So she contacted Lucas, and what she received in the mail was some medical articles and a copy of Lucas' law review piece. And a bill for $25, Haynes recalled, and I said, well, screw this. It wasn't any help at all. Frank Sussman had a different feeling about the Lucas material. When he studied it at his St. Louis law office, the suggestions in Lucas' writings looked to Sussman like perfectly respectable arguments. Here was an attorney who had already looked up scores of cases, read a lot of law review articles, and thought through a variety of different ideas that might be offered to the federal courts, starting with privacy and moving on to vagueness, equal protection, discrimination against the poor. In all candor, I'm not sure there was that much research in our briefs as opposed to a great deal of plagiarism, Sussman recalls. Roy Lucas had already done it. There was no point in reinventing the wheel. Into Sussman and Thayer's opening complaint went causes of action 3 through 13, throwing dice, as Sussman recalls, trying anything that might make sense to a judge. The abortion law deprived doctors of their right to practice proper medicine. The abortion law deprived women of Eighth Amendment guarantees against cruel and unusual punishment by forcing them to bear every child conceived. The abortion law violated guarantees to equal protection by discriminating with no compelling justification against different classes of people. The abortion law infringed upon freedom of speech, freedom of religious belief, due process of law, and a nod here to the insistent law clerk at the California Supreme Court, the fundamental right of a woman to determine for herself whether to bear children. But plausible arguments by themselves are not enough to bring a legal case, as the Griswold lawyers had learned. The case needs plausible people too, the parties who are said, in what is sometimes a fiction created for the purposes of a lawsuit, to be approaching the court with a problem that affects them directly and immediately. Finding the right people had for some time been a sticking point in abortion litigation. Arrested abortionists were one source of lawsuit. State statutes could be challenged as unconstitutional when they had been invoked to arrest doctors like Leon Bellis in California, or Milan Vujic, the Washington, D.C. gynecologist, whose indictment had led, at least temporarily, to the overturning of the District of Columbia's abortion statute. For some months, abortion activists like Larry Lader had been casting about to no avail for a physician willing to invite arrest deliberately by publicly arranging in an in-hospital abortion that would defy the law even while meeting the highest possible medical standards. Paul Shively, the San Francisco obstetrician whose legal difficulties following 1966 rubella abortions had galvanized medical support around the country, had been approached early on by a wealthy Missouri industrialist who had become a passionate convert to the causes of legal abortion and population control. Shively recalls that the industrialist offered Shively and his lawyer complete financial support, every penny their lengthy defense might cost, if Shively would demand a criminal trial and thus escalate the state medical board's charges against him into a public, full-scale legal challenge of state abortion laws.
Will you yield?
I will certainly yield.
Where should we go? Okay. Hello, my name is Martha, and I'm here to participate in the women's filibuster because I believe that a woman's right to choose is up to her and her family, and it has nothing to do with politicians. They should have no say in this matter whatsoever. These are our constitutional rights, and we want them, and we will fight to keep them. I'm going to continue reading from the book, Articles of Faith. Shively and his San Francisco colleagues, who were eventually cleared of the charges against them, all declined the offer. A life's career was too vast to gamble. And in these early years, only one other American doctor came forward in a sacrificial public flouting of the law. Jane Hudson, a 55-year-old obstetrician from St. Paul, Minnesota, who deliberately notified legal authorities before performing a hospital rubella abortion, technically illegal under the Minnesota abortion statute, on a woman who already had 3 young children at home. Hodgson, a lean and plain-spoken former Mayo Clinic doctor who had been the first woman elected president of the Minnesota Society of Obstetricians and Gynecologists, had grown weary of what seemed to her the hypocrisy of respectable doctors, herself included, who turned down abortion patients and then shrugged away responsibility when the same women turned up infected by street abortionists. She was indicted in May 1970 with her criminal trial set for that fall. From New York, at his Madison Law Institute, Roy Lucas was helping prepare her defense. In the wake of Hodgson's indictment, no other physician rushed to join her in some fraternal open defiance of his state's abortion law. Hodgson, should she be found guilty of violating the Minnesota abortion law, faced possible jail time and the loss of her medical license. But there was a second option that did not require arrest. An individual or group of individuals could approach a judge and ask for a declaratory judgment, a pronouncement on the validity of a particular statute, or they could ask for declaratory judgment and injunctive relief. Pronounce the statute unconstitutional, Your Honor, and then issue an injunction, a judicial order to prevent the state from enforcing it. Plainly, this was a simpler and safer route for any lawyer who wanted to test the law without imperiling some doctor's future. In Texas and Georgia, where the lawyers Sarah Wedgington, Linda Coffey, and Margie Pitts Haynes were working on their own lawsuits, women had seen the obvious choice as lead names in the declaratory judgment suits. The final hurdle in bringing a declaratory judgment and convincing the judge that the plaintiff, the person bringing the lawsuit, has what the law calls standing, which means the person must be directly and seriously burdened by the statute in the first place. And Weddington and Haynes had been drawn into the abortion issue by women's rights activists. It was not physicians' rights that interested them most. If the lawyer wanted to do what Abby Sobin had done, to find in the promises of the Constitution that fundamental right of a woman, then the plaintiff ought logically to be a woman, preferably a pregnant woman, a woman who could seriously contend that this very statute, at this very moment, was depriving her of the right to obtain an abortion with her own home state. In Texas, Wedgington and Coffey were introduced to a pregnant young waitress named Norma McCovery, unmarried and already the mother of one child, who brought them a convincing account of the economic and emotional hardship a second child would cause, they promised her to keep her anonymous, gave her the pseudonym Jane Roe, and prepared simultaneous complaints describing the dilemmas both of Jane Roe and of a second woman who was married and suffered from a neurochemical disorder that had led her doctor to advise her against both pregnancy and birth control pills. In Georgia, Haynes and her Atlanta legal colleagues found a pregnant young woman named Sandra Bensing, also unmarried and rejected for abortion by a hospital committee that was following the model penal code restrictions of the new Georgia statute. The Atlanta lawyers gave their plaintiff the pseudonym Mary Doe and joined this name to a list of individuals and organizations challenging Georgia's abortion laws. The New York and Ohio and Kentucky cases used pregnant women too, along with physicians and ministers and a social worker. The Illinois case used heads of medical school obstetrician departments as well as women seeking abortions. And New Jersey was to combine both doctors and women affiliated with women's organizations, so that the consolidated name of this case, YWCA versus Kugler, would convey at first glance the interesting, if slightly misleading impression that the Young Women's Christian Association was suing the New Jersey Attorney General for the right to legal abortion. Frank Sussman and Charlotte Thayer led their case with doctors. They wanted to bring the case in the U.S. Supreme Court where most of the abortion cases were headed. As the close of the 1960s, federally appointed judges were widely perceived as far more sympathetic to individuals' rights than most state judges, and the abortion challenges were going principally to 3-judge direct court panels, each formed specifically to hear a particular case. Now summoned only rarely, these 3-judge panels had for many years been conveyed in a salute to the gravity of the matter at hand, when a state statute was being challenged under the U.S. Constitution. Each panel held 2 district court judges and a U.S. court judge of appeals. Sussman was familiar with the St. Louis regional lineup to know they would have a far better shot at a sympathetic hearing if they filed their suit in Kansas City. So their lead doctor was Samuel Rogers, a veteran Kansas City obstetrician with teaching appointments at the universities of both Kansas and Missouri. Rogers was Black and deeply respected in the Kansas City Black community. He and a handful of other Black doctors had pressured the city during pre-integration days into including obstetricians and gynecologists training in the city's Negro hospital. And many years later, a major health clinic was named after him. He had handled his share of medical complications from criminal or self-induced abortions, and he was sympathetic to the aims of Sussman's lawsuit. But Rogers was under no illusion about why he had been asked to step to the head of the plaintiff's list. I wouldn't have been asked to be on it if it had been easier to find somebody, he recalls. It's as if the big-time doctors didn't want any part of it. Following Rogers were 3 other Missouri physicians, 3 representative Missouri women, 1 rabbi, and 1 Protestant minister. Under the title Samuel U. Rogers, John Danforth, Attorney General of the State of Missouri, Sussman and Thayer filed in May 1970 a formal complaint asking the U.S. District Court for the Western District of Missouri for a declaratory judgment and a permanent injunction against the enforcement of the Missouri abortion law. 4 months later, the district court threw it out. Interpretation of state law belonged in state courts first. The Rogers 3-judge panel ruled Sussman and Thayer would have had to bring their case to the state system. It was gloomy news. Other federal panels had assessed their judicial mandate differently. Roe v. Wade, the Texas case, had already been won in the U.S. District Court, and Doe v. Bolton, the Georgia case, had emerged with a largely favorable ruling from the District Court Round 2, which meant, since these 3-judge panel rulings could be appealed straight to the top, bypassing the Court of Appeals step, that both Rogers were probably headed directly for the U.S. Supreme Court. But Rogers v. Danforth was going to have to start again at the local level. So Sussman brought the case back to the St. Louis County Court building in Clayton, the only St. Louis area jurisdiction Sussman knew, where he was likely to draw the right kind of judge. He got him. Rogers v. Danforth was assigned in October 1970 to Herbert Lasky, circuit judge for the County of St. Louis. A co-religist, Sussman recalls with a small grin. Lasky was the only Jewish judge on the bench and looked to Sussman like a possible liberal abortion vote. Now the legal papers began to stack up in Lasky's chambers, and copies were delivered to Sussman's office one by one. Motion from the district attorney's office that the case be dismissed outright, motion denied. Motion for emergency judicial order because of the urgent situation of all women needing legal abortions, temporarily avoiding the state abortion law, but the case is being heard. Motion denied. Motion to let into the case another party entirely, one N.H. Thacker Jr., M.D., on behalf of the infant Doe and all of her unborn children. Motion granted. Sussman was nonplussed at the induction of Thacker into the abortion case. The notion of asking for guardians ad litem had spread around the country among attorneys who were trying to defend their state's abortion laws. And for public relations purposes alone, it was a clever maneuver, suggesting that the fetus required the same kind of grown-up protection the court might afford an abandoned child. The phrase, to defend the fetus, with its hints of threat to a helpless little person, appeared in every newspaper story about Thacker's guardian ad litem appointment. And in May 1971, as Rogers v. Danforth had been readied for its hearing before Judge Lasky, attorneys for the state presented the court with Exhibit A, Matt Thacker, and 16 pages of text with a 60-item medical bibliography expounding the circuit court on the nature of life before birth. From conception on the child is a rapidly growing organism. Exhibit A again. By the end of the 7th week, we see a well-proportioned, small-scale body. Sussman read with mounting uneasiness. What was he supposed to do with this? When one views the present state of medical science, we find the artificial distinction between born and unborn has vanished. Was he expected to argue these assertions in a court of law? The ears are formed by 7 weeks and are specific and may resemble a family pattern. By the beginning of the 9th week, the baby moves spontaneously without being touched. The whole thrust of medicine is in support of the notion that the child and its mother is a distinct individual in need of the most diligent study and care. Strategically, their big abortion case, only a week away from the scheduled day of argument, Sussman and Thayer were trapped. What they wanted from the court was a summary judgment, a ruling based solely on the information in the briefs already delivered to the judge. Summary judgment would mean no actual trial need to take place, no witnesses, no examination and cross-examination, no arguing over important facts. If they wanted to attack Thacker's exhibit, they would probably end up going to trial. And if they went to trial, Sussman would have to come up with witnesses to review propositions like from conception on the child is a rapidly growing organism. How the hell was he supposed to do that? Bringing in a scientist to argue about brainwaves, bringing in a metaphysician to argue about what brainwaves meant, or the conflicting definitions of individualism. It might take months just to figure out what a lineup like that was supposed to look like, much less how to make a useful sense of each witness's testimony. Frank Sussman has been practicing law for 3 years, but he had yet to try his first case, and he was not about to start with this. Courtroom trials were supposed to examine who was right and who was wrong. Sussman thought, not some philosophy case like the moment when life begins. So Sussman and Thayer, pushing for their summary judgment, took a small, wild gamble in the county circuit court that stipulated as to the truth of Exhibit A. A stipulation is an agreement for legal purposes. Okay, accepted, now let's get on with the matter at hand. In legal disputes, stipulating can save time and effort. Stipulation is a way of declaring to the court that both sides concede to a particular fact so that nobody needs to argue about it. Stipulating was the surest way to avoid a trial, as far as Sussman could see. It was a gamble, but so was the entire enterprise. Marching into the court with a lot of constitutional theories that some imaginative lawyers had worked up in their heads. Come now, plaintiffs, Sussman dictated in the weighty Shakespearean language of the court, and for the purpose of the pending motion, and for the purpose alone, hereby stipulate as to the truth and accuracy of the affidavit attached in Exhibit A. On May 20th, 1971, in his courtroom in the Clayton County building, with no jurors present and a court reporter transcribing the proceedings, the Honorable Herbert Lasky conducted his hearings in Rogers v. Danforth. May it please the court, Frank Sussman began. Miss Charlotte Thayer and myself appear here in the morning, not only really on behalf of the 10 plaintiffs in this cause, who are 4 physicians, 3 college men, 3 individual women of childbearing age and married, all residents of the state of Missouri. But in many ways, I think it can be honestly be said we appear here this morning in behalf of thousands of others, not the least of which, for example, are the 350 some odd women who have every month and who will continue every month to obtain abortions. Through the local services of Social Welfare Agency in the state of Missouri, known as the Clergy Consultation Service of Missouri, plus the hundreds of other women who obviously go through different channels. He strode right into the Exhibit A stipulation and delivered a nice rhetorical flourish or two. There have been some suggestions that there are facts in dispute as to when life begins. In effect, there is no dispute. Medical and scientific knowledge do not differ. Plaintiffs are more than willing to concede that the fetus is a living organism. Plants are living organisms. Other animals, egg and sperm in their own right, prior to conception, are living organisms. The problem of what is in dispute is merely a question of development. What do you call life? Are you talking about spiritual life? No evidentiary hearing before this court could ever help answer the question of when spiritual life begins. No other court in the abortion cases around the country had entertained serious legal argument about when life does or does not begin, Sussman argued, and surely this court did not wish to become the first. I have serious worries that in many cases it would resemble what it is now an infamous case of the Scopes trial, Sussman said, and what this court and what the participants would do would be inherent, unfortunately, more than the wit. Then Sussman expounded on what he hoped were some of his real arguments. The statute was vague. The statute denied freedom of speech to those who wish to advise on abortion. A fetus possessed no assertable rights under the law. He listed to the other side attorney, one for the county prosecutor's office, one for the attorney general's office, and one of them worked as legal counsel to the Missouri Catholic Conference, arguing before the court at some length and with repeated references to unborn children and the right to live on behalf of the fictitious infant. When they were finished, Charlotte Thayer got up for a heated last word. Surely none of us are supposed to be so absurd that we would claim this fetus does not have the potentiality of being born, she said, sounding angrier as she warmed up. I would point to the defendant's brief mention on page 12 thereof, the statement that this is a tiny human being, independent, as though he were laying in a crib with a blanket wrapped around him, instead of his mother. How absolutely absurd. This is no independent existing person. This is a human life that could premature into an individual 9 months after conception. We haven't removed the issue as to the right of a mother to determine whether this life that lies within her should mature into a human being. We have not destroyed the issue of question of abortion by agreeing to this. We think we have simplified the issue and gotten our sociological arguments and gotten down to the true facts. It was the Constitution that the court should be considering, Thayer argued, not philosophy or sociology or spiritual substitution. And I will tell you, said Charlotte Thayer, who was that morning the only lawyer in Judge Lasky's courtroom capable of becoming pregnant, that I am pretty bothered when we have people in the legislature sitting down there drawing statutes, and our doctors are supposed to be found by non-professionals telling them how to practice medicine and by telling a woman how she is going to make use of her own body. The judge thanked her, pronounced the hearing finished, and took Rogers for Stanford under submission. Now all they could do was wait. While these arguments had begun to take shape, these large and important debates about implicit rights and procedure in the shaping of the constitutional law, Judge Whitcomb, was for a brief and dismaying time a pregnant woman in the city of St. Louis. The universe, she would say many years later, remembering, works in strange ways. They had not wanted another child, not then, and probably not ever, although Judy had thought about this sometimes, what it might be like to have one more baby. Art had talked some months earlier about having a vasectomy, but he had never gotten around to scheduling the procedure, and while Judy's pregnancy test came back positive, she smoldered for a while. If she had made the damn appointment, they would not be sitting in the kitchen with their hands in their heads trying to make up their minds about what to do. Judy loved raising children. She truly believed she was good at it. The nurturing, the holding, and the people around her did too. Some months back, she had befriended a neighborhood teenager who was having trouble with her own divorced parents, and the boy ended up moving into the middle bedroom at Judy's home, an informal foster child. Then, a pregnant girl had found her way to the clergy service to Judy and Art's house, after the girl decided against abortion and put the baby up for adoption. She moved into Judy and Art's back bedroom for a while, a second informal foster child. So now there were 6 of them living together in the suburban St. Louis home. Judy and Art, their boys, and the 2 young boarders, and it was lively and loud, with good-natured teenagers slamming in and out. But they were stretched. Art working his newspaper route, and Judy working bread and managing one shift at the hospital and an unpaid second shift at the clergy service. And while they had a medical problem that was likely to complicate any future childbirth, an AO blood incompatibility between Judy and Art had forced both their sons to undergo a total blood transfusion shortly after birth. Judy's doctor had advised her, after her second son was delivered 3 weeks earlier by induced labor and transfused almost immediately, that if she got pregnant again, they might have to induce labor even earlier and take on medical risks of a seriously premature baby. So we looked at all of that, Judy recalls. We looked at where we were, we looked at what the quality of life was like. It was good, and we decided to go to Chicago. Thus, on the summer morning in 1970, one day after Art had his vasectomy, so that all the way up he sat in a small inflatable cushion and winced with every jostling cord, Judy and Art drove 300 miles to Chicago to break the law in the office of the corpsman. The midwife, Martha Vineyard, who could have accommodated Julie locally, but her procedures cost too much and took 3 days start to finish. A New York doctor might have worked Judy into the schedule, but the New York law was just cranking up and then a chaos of overbooking. Judy knew the corpsman would take care of her quickly. She knew precisely what the corpsman would do because she had watched him do it. And when they arrived in Chicago, Judy took out the telephone number and repeated step by step the coded signals of her own underground. Call the number, ask for Jimmy, wait for the callback. She felt like a fool. She was pregnant by accident. She was a nurse. She ran this illegal system. She sat there every week dispensing sage medical advice about birth control and responsible sexuality and how to avoid unplanned pregnancy in the future, blah, blah, blah. And here she was. And here was the mafia car to drive her through the streets of Chicago so as to disorient her before delivering her to an abortionist. It was a medical office this time, not an apartment building. The corpsman appeared to have come up in the world, some position allowing him into professional quarters, off hours, and when Art and Judy rang the doorbell, they were let in by a woman who smiled, as though she was about to ask for the insurance forms. Judy followed her into the procedure room. A calm had come over her, the narrow nurse's eye. I am observing this and can explain medically its every step. And when he came in the room, they greeted each other cordially and quickly so that they could get down to business. Judy undressed and lay on the table. Art stood by her head. She asked him how his vasectomy was feeling. A fierce, deep pain shot up inside her, and she pressed her hands on to her abdomen. I knew this. He doesn't use cervical anesthesia. Breathe, the corpsman said. Judy breathed. When he scraped, she could hear the sound of the grating as though it was sawing at something gritty. The pain was terrible, tighter than labor, stuck to a searing center that moved with the scraping. Right horn of the uterus, left horn. Judy could envision the anatomical drawing as though she were moving a pointer back and forth for her nursing students. At least labor pain came and went. Every woman she sent up here had to lie back and endure this. All those women, their feet in the steel stirrups, and this amazing pain. What must it feel like when an incompetent person did it? When he was finished, the pain stopped roaring, and Judy sat up on the table. He left the room. She climbed off the table to steady herself, put her clothes back on, and followed him into the other procedure room. She felt obliged for some reason to remain calm and wholly lucid, to keep behaving in the manner expected of a medical professional. She assisted nurse at the procedure table at the next two abortions. Afterwards, they went out to dinner in a restaurant, and Judy fainted in the bathroom. It was not much of a faint. She just felt an urgent need to lie down, and when she opened her eyes, she saw that she was on her back, looking up at the ceiling. When she went back to the dinner table, she told Art that she felt better. They spent the night in Chicago and drove to St. Louis the next day. She was never charged for the abortion. Art would make a mild joke about that. A long time afterward, that was the only clergy service payoff I ever got, a $250 abortion for free. He and Judy talked to each other during the drive home, small conversation, careful. Judy tried to see how she felt. What was it that she had lost? Already the word potential had carried her through some moments, and she found she was holding hard to it now. The death of a certain potential, a fantasy erased. She and her husband will have no more children. For a while, Judy would slump to something like grief, a mourning not for a person, but for an idea, a shadow, a not yet person. But she never wavered when she talked about it. This was a decision we made. That was how she would describe her abortion, her voice almost always firm. And as the months went by, that word too became essential to the lexicon. Decision, responsible decision-making, private decisions. It was right to have made the decision, Judy would say. What was wrong was the way they were compelled to behave once they had made it. Code names, unmarked station wagons, anonymous telephone numbers. It was as though Judy had stepped from the pages of Rogers v. Danforth or Roe v. Wade, skulking around the Midwestern states in their exercise of a woman's fundamental right to determine for herself whether to bear children. Judy didn't need a constitutional law professor to write some learned definition of fundamental for her either. You could look it up in the dictionary. Basic, underline, essential part. On June 7, 1971, three weeks after taking Rogers v. Danforth under submission, Judge Lasky made his ruling. It was 3 pages long. It gave everything, the entire case, to Sussman and Thayer. Broadest abortion ruling in the United States ever, Sussman recalled 2 decades later, with evident pleasure. He was in 2-week Army summer camp when the news came over the radio. Lasky had ruled that the Missouri abortion law was unconstitutional for every reason Sussman and Thayer had offered up. The law was vague, the law advanced no compelling state interest, the law deprived women of their rights, the law violated 5 different amendments of the Constitution. It was as though Lasky had decided to dispense with an opinion and to hand down instead a telegram that read, yes. The appeal would go straight to the state Supreme Court, a prospect so dispiriting that Sussman could see in the conservative 7-judge lineup perhaps one potential sympathetic vote. But there was bigger excitement outside Missouri, where U.S. District Court cases were churning their way through Missouri as the list of abortion statute challenges began to grow. From one judicial panel to another, the resolution of the cases varied as sharply as personal conviction on the morality of abortion. In Wisconsin, a court found the state statute unconstitutional, in a violation of a woman's right to refuse to carry an embryo during the early months of pregnancy. In Louisiana, a 3-judge panel upheld the state abortion statute, declaring in a majority opinion that contraception and abortion were different matters. The first contemplates the creation of a new human organism, the opinion read, but the latter contemplates the destruction of such an organism already created. Contradictory opinions issued from courts in Illinois, Kentucky, North Carolina, Ohio. The U.S. Supreme Court rattled both sides at once by delivering in April 1971 its ruling on the District of Columbia's abortion statute. The statute was not unconstitutionally vague and thus must still be enforced, the court ruled. But prosecutors should remember that the statute permitted abortions for the preservation of the mother's life or health. And health, the U.S. Supreme Court ruled in its District of Columbia case, was a term of considerable flexibility. The general usage and modern understanding of the word includes psychological as well as physical well-being, with the majority opinion by Justice Hugo Black. By general consensus, the court therefore managed to uphold abortion practice in Washington, D.C., already active in business in local hospitals and doctors' offices, while preserving, in theory, the statutory law that restricted it. The justices signaled, furthermore, that they do not intend to stop there. In May 1971, exactly 1 month after the ruling was handed down, the Supreme Court announced that it would consider the Georgia and Texas abortion case, Doe v. Fulton and Roe v. Wade. Now the stakes were very high indeed. Together with their small array of provisions and exceptions, the Texas and Georgia statutes encompassed all of what Judy and her counterparts around the country saw as bad abortion law. The Texas statutes read somewhat like Missouri's, exempting only life of the mother abortions. The state penal code made it a crime to administer, procure, or furnish the means for procuring an abortion, knowing the purpose intended. Georgia was a far more modern statute, adopted in 1968 as the model penal code language spread around the country. The Georgia law made abortion permissible after rape, forcible or statutory, and formally reported to some law enforcement agency, or to prevent serious and permanent damage to a woman's health, or to prevent the birth of a baby who would very likely carry some grave, permanent mental or physical defect. The Georgia abortion law included an assortment of procedural requirements, all of which made the statute stricter in practical terms than the now loosely interpreted older law from the District of Columbia. A prospective abortion patient had to swear under oath that she was a legal resident of the state. The abortion must be performed in a full-size accredited hospital, not a clinic or physician's office. The abortion required the written approval of 3 physicians and a medical committee from the hospital in which the operation was to take place. Both in concept and practice, the lawyers bringing the Georgia case were arguing all these obligations added up to a procedure so cumbersome, time-consuming, and restrictive as to manipulate out of existence the rights of an abortion applicant. Everything that had disturbed abortion activists about increasingly popular reform laws, the categories, the bureaucratic gauntlet, the written rules that work to accommodate the rich and shoo away the poor, appeared to be enshrined in the modern Georgia abortion statute. And by taking both cases at once, the oral arguments were scheduled back-to-back for the same day, December 13th. The Supreme Court alerted attorneys around the country that the justices intended to examine more than simple prohibitions on abortion. Could a state ban some abortions while permitting others? Could a state ban abortion outright? Could a state adopt laws that made abortion legal, but set up a half a dozen barriers between every patient and her abortionist? The legal work accelerated. Roe v. Wade's Sarah Weddington, stunned by the news that her first contested legal case was about to be heard by the Supreme Court, packed up and took an airplane to New York to spend the summer preparing at Roy Lewis's law offices. At night, with the window open to stale summer air and the noises of Manhattan street life keeping her awake, Sarah bed down in the lounge in the switched room of a downtown abortion counseling center. The first taxi ride of my life was in a car with a bulletproof partition between the passenger and the driver. A sign that said the driver did not carry more than $5 in change, and an enclosed money bucket on the floor front seat, wielded into transmission. Sarah wrote a 1992 memoir, A Question of Choice, recalling her disconcerting arrival in New York City. My first night, I stayed with an acquaintance. The day before, the stewardess had been murdered 3 blocks away. In the summer of 1971, Sarah was 24 years old. The Texas Methodist minister's daughter, who captured the fancy of the newspaper photographers by showing up for work with her thick strawberry blonde hair combed long and full over her shoulders. She had taken a job some months earlier as a Fort Worth assistant city attorney, the first woman ever hired into that position, and had abandoned it by her own account when her supervising lawyer wrote Sarah a 7-word note apparently meant as an ultimatum. No more women's lib, no more abortion. Sarah had weighed her alternatives, Fort Worth's job or women's lib, and the Supreme Court case, and quit. Now she made her permanent home in Austin and shared a law practice with her husband, who had accompanied her 4 years earlier when she drove to Mexico for an illegal abortion. Nothing gruesome had happened to Sarah during her Mexican abortion. The office was clean, the doctor was pleasant, and she came out of the anesthesia frightened and dizzy, but physically unscathed. For a long time, she was intensely private about her personal stories. Even in abortion law circles, nobody knew Sarah had obtained an abortion herself until she wrote about it 25 years later in her book. When she was asked afterwards about her long reluctance, she would tell people that the abortion had proved an episode of such low drama. She and Ron were not married yet. He did not want children. She wanted to finish law school, that she had always believed she could stick to her law role and keep her personal history to herself. But as a political cause, abortion activism had appealed to her for the first time she learned about it. She was introduced after law school to the feminist branch of the lively Austin counterculture, and by 1969 she was donating legal research time to local abortion referral volunteers. In the University of Texas Law Library, Sarah made her way through the same collection of cases that was beckoning her counterparts around the country. When the local abortion referral organizer, Judy Smith, finally asked her to sue to bring a formal legal challenge to the first abortion statute, Sarah describes having cringed at first. "No, you need someone older and with more experience," I told Judy. "You need someone at a firm with research and secretarial backup." My mind whirled with all the reasons I was not the right person. After all, my total legal experience consisted of a few uncontested divorces for friends, 10 or 12 uncomplicated wills for people with little property, one adoption for relatives, and a few miscellaneous matters. I had never been involved in a contested case. The idea of challenging the Texas abortion law in federal court was overwhelming. She began preparing the case, despite her misgivings, and recruited her former law classmate, Linda Coffey, to help. Coffey was 3 years older than Sarah, which still made her one of the youngest associates in the Dallas bankruptcy firm where Coffey was working. Together, the two lawyers accumulated years added up to less than the age of any one of the black robe justices they were now preparing to face. In Atlanta, Margie Fitz-Haynes was more seasoned, 38 years old and a veteran of both private practice and volunteer ACLU cases. Had done her civil rights work in a local police brutality and racial discrimination cases. It had not gone unnoticed in Washington that all three women, Supreme Court personnel, particularly after Georgia officials announced that an assistant attorney general named Dorothy Beasley would argue for the state, began referring to December 13th as Ladies' Day, and for older attorneys like Connecticut's Catherine Rohrabaugh, it was exhilarating to count up the sheer number of women whose names turned up on legal papers, now circulating with new urgency around the state.
Well, I thought it was very ideal.
I will. Yeah.
Hi, my name is Shemin Schwab, and I'm a pro-choice Catholic mother of two. And at the moment, I am really disappointed in our state legislature, and I call on all of our legislators and our governor to stop this 72-hour waiting period. I'm going to read a brief study on abortion waiting periods cause excessive emotional and financial hardships for women by Tara Culp-Ressler. It's from March 6, 2013. Forcing women to wait a 24-hour period between consulting with an abortion doctor and legally terminating their pregnancy can cause excessive hardships. A new study finds the Texas Policy Evaluation Project, a 3-year research project studying the impact of the restrictive reproductive health laws that Texas passed in 2011, surveyed over 300 women who sought an abortion in Texas last year, the majority of whom reported that the state's mandatory waiting period put an emotional and financial burden on them. Many women struggled to get to a clinic for the required counseling session the day before their abortion. The study's participants traveled an average of 42 miles to visit the nearest clinic, but some were forced to travel as far as 400 miles away from their homes to comply with the law. And nearly half of the women incurred additional costs from the 24-hour waiting period, $146 on average. Because making multiple trips to a clinic required them to pay for extra transportation and childcare on top of the cost of the abortion procedure, ultimately, nearly 1/3 of the respondents said the waiting period negatively affected their emotional well-being. Dr. Daniel Grossman, the Vice President for Research at IBIS Reproductive Health and researcher with the Texas Policy Evaluation Project, said in a statement that the waiting period is an ineffective policy for multiple reasons. It clearly puts a strain on women, and it doesn't actually change their minds about whether to have an abortion. We found that the requirement to visit the clinic at least twice was burdensome for some women and created logistical barriers to scheduling the abortion. Women also reported being equally confident about their decision after seeing the ultrasound and hearing its description, Grossman explained. That falls in line with previous research that demonstrates the barriers to abortion care favored by the anti-choice community, such as waiting periods, counseling sessions, and mandatory ultrasounds, don't do anything to sway women's decision about terminating a pregnancy. In fact, they're simply emotionally manipulative tactics to shame women and make them feel guilty about making their own decision about their body. A Texas lawmaker is using the study's preliminary findings to push for a repeal of the state's waiting period, but there's still a long way to go before U.S. women are completely free from that burden, since 26 states currently require women to undergo a mandatory counseling session and at least a 24-hour waiting period before accessing legal abortion services. South Dakota actually forces women to wait a full 72 hours, the longest period in the country, and may be posed to extend that even further by excluding weekends and holidays from counting toward the requirement. Once again, I call on our governor and all of our legislators to do what they can to stop this bill, be it veto or otherwise. We're going to continue reading from the Articles of Faith, A Frontline History of the Abortion Wars by Cynthia Gorney. By the final weeks of summer, as Sarah Weddington and her husband were preparing to return home to Austin, Roy Lucas had begun insisting that as the more experienced abortion attorney, he ought to present the Supreme Court oral argument in Roe, that he would not even consider Sarah Weddington's suggestion that the two of them divide evenly their allotted time before the court. And when Weddington hesitated about demanding that she argue her own case, it was the don't back down telephone calls from other women attorneys that steeled her resolve. From their work in civil rights, the student left, and the burgeoning women's movement, a network of ardent young women lawyers, many of them working out of ill-funded little offices with macrame plant hangers and Sojourner Truth posters on the walls, had made what seemed to them the natural leap to abortion cases. Catherine Rohraback herself had an abortion law challenge underway, a Connecticut version of Roe v. Wade, and because she had helped argue Griswold, she assumed a venerated elder status among some of the younger attorneys, who looked to her for guidance as they composed and passed around their angry and grand-scale legal complaints. Humility was not a strong suit for any of us in those days, recalls the former Center for Constitutional Rights attorney Nancy Stearns, who was barely out of New York University Law School when she helped prepare an ambitious class action abortion case. One of the 4 lawsuits filed simultaneously in 1969 to challenge the existing New York abortion statute. Their approach was shaped more by political organizing strategies than by fine points of the law, Stearns recalls. She and some of her colleagues deliberately sought out large numbers of women plaintiffs, both to rouse public interest and to impress upon the court the vast reach of illegal abortion as a woman's plight. Remember, the judges were almost 100% male, Stearns recalls. Here you were trying to explain to these basically male, middle-aged, middle-class white men what it was to have an unwanted pregnancy. So just bringing in a single pregnant woman might give you legal standing, but it would not teach very much. In Chicago, the lead attorneys were similarly experienced as they plunged in, really novices of the first order, nobody looking over our shoulder, recalls Sybil Fritsch, who had barely made the transition from the University of Chicago Law School to her new job as counsel to the local ACLU chapter, when she and a young Chicago Legal Aid Bureau attorney named Susan Grossman filed a challenge to the Illinois abortion statute. The Illinois case was constructed from the ground up, like New York's, and Fritschat and Grossman loaded their plaintiffs' list with prominent Chicago obstetricians and pored over every written abortion study that they could find, anxious not to appear the brash young revolutionaries before conservative Illinois judges. By telephone and by mail, the fat manila envelope shipped halfway across the country from one law office to another. Excuse me. The lawyers tracked each other's progress and kept a running score. This argument is working. In some courts, this one is being tossed aside. This one is politically effective, but will never convince the Supreme Court. The Association for the Study of Abortion began leading its decorous newsletter with a lengthy roundup called Cases in Court. And from the ASA's rosters, an older generation of stalwarts now offered up their years of research and statistics, like aging scholars hauled out of the campus library to join the raucous demonstration outside. Christopher Tietz, the internationally respected Vienna-born medical statistician who had spent 20 years with Planned Parenthood and now directed the World Population Council, had volumes filled with his documentation on contraception and induced abortion. Planned Parenthood Federation of America President Alan Guttmacher, who had been writing books about birth control since the 1930s, had elaborate analyses of the medical arguments for dismantling state abortion laws. And in the offices of Harriet Philpott, a New York attorney who had been part of the founding core of the ASA, telephone advisories and multiply shipped sample briefs had created an improvised lawyers' clearinghouse with the remarkable Philpott dispensing legal wisdom and war stories as the Supreme Court arguments approached. Harriet Philpott was a Griswold veteran herself, a longtime American Civil Liberties Union board member, and more to the point, a direct link to Margaret Sanger and the contraception battles of the first half of the century. She had finished Columbia Law School in 1936, the second highest ranked student in her class, and was hired straight into the New York law firm of Morris Ernst, whose client list had since the early 1920s included Margaret Sanger. For more than 20 years now, Philpott had handled the office's Planned Parenthood work, and although Planned Parenthood itself was a nervous and sometimes standoffish ally in the early abortion battles, some regional chapters worked vigorously to keep from sullying themselves with the issue of the abortion law repeal. Harriet Philpott had used both the lay and legal press to agitate for changes in the laws. We continue to maintain strict anti-abortion laws on the books of at least 4/5 of our states, she wrote in the Atlantic Monthly in 1969. Denying freedom of choice to women and physicians and compelling the unwilling to bear the unwanted if we really want to cut our population growth rate on a voluntary basis. We should make abortion available on a voluntary basis, at least in the early stages of pregnancy. When Japan liberalized its abortion laws some years back, it halved its rate of population growth in a decade. Philpott was a striking and fiercely intelligent woman with a reputation both for startling vanity. Professional women around her were sometimes disconcerted by watching Philpott attend to her makeup and elaborately arranged hair in the midst of public meetings, and for a breakneck work pace. It took 2 secretaries to keep up with her dictation, and Eve Paul, a young associate who was later to replace Philpott as general counsel to Planned Parenthood, remembers Philpott hurrying from office to office with so many papers and law books that she pulled them along in a wheeled cart. You could meet her at a party. She was out almost every night, or the theater, or a concert, and there would be Harriet with her little cart, Paul recalls. And now Philpott began from her office in New York to help choreograph some of the preparation for the abortion case's grand debut at the Supreme Court. She visited Atlanta. She consulted with Sarah Weddington. She composed, and with other attorneys, friended the court briefs to add to the principal arguments being directed at the court. She arranged moot courts, the staged question and answer sessions in which attorneys help each other prepare for oral argument, so that abortion lawyers could gather in one room and fling at the 25-year-old Sarah Weddington every rancorous query a Supreme Court justice might be likely to think up. It was a long way from St. Louis, all of it. Frank Sussman was on the mailing list, and the moot court invitations were sent out to him too. But mostly, he stayed away and waited glumly for his Rogers ruling from the Missouri Supreme Court. Hayseeds, that was what the word he would use. The courts were abuzz with abortion cases. Here was the federal court out of Illinois with a wonderful ruling that voided the state statute for vagueness and denial of right to privacy. Here were state courts as far away as Florida and Vermont issuing opinions that would have resounded as victorious as if they had come in Sussman's case. Violative of our state constitution, wrote the Florida Supreme Court, deprives a woman of medical aid even though she may be afflicted in body or mind, or both, wrote the Vermont Supreme Court. A federal court in Kansas took on the Kansas Model Penal Code law, which had already set off a modest but brisk abortion business inside the state, and loosened the new statute even further. No more 3-doctor review committees, the Kansas court declared, and no more requirement that abortions be performed only in certain formally accredited hospitals. This court is convinced of the existence of a fundamental right to individual and marital privacy, read the opinion from directly across Missouri's western border, which includes within its scope the right to procure an abortion. But Rogers v. Danforth was headed for Jeff City, the capital of the Show Me State, the state that emblazoned on its license plate a motto that many Missourians translated wryly for outsiders as, "No, I'm not ready to try that. You go first." Hayseeds reigned the capital city, and hayseeds reigned the Supreme Court, and that was Sussman's considered opinion. Even a rigid model penal code reform law could not seem to find its way out of the Missouri General Assembly. And now Sussman was depositing his abortion case before judges who worked half a block from the Capitol building and probably split lunch checks every week with the politicians who kept voting no. He gave a speech, not an upbeat one, in the spring of 1972. Among the audience members were physicians interested in the clergy service, and Sussman advised them that there was not much risk of prosecution for the referring doctors. Most of the women were being directed to legal clinics in New York, Sussman said, and any prosecution-minded authorities would probably come after the service organizers first. But technically, Sussman told his audience, the Missouri statute did still prohibit advising for abortions unless the mother's life was in danger. I could sit here and not recall the last time that's ever really occurred, where in order to save the life of the mother, based on her physical well-being, you had to perform an abortion, Sussman said in his speech. They get around it and say, well, they classify her as suicidal, and therefore a woman who knows the right doctors and has the right amount of money goes to the right 2 psychiatrists. Each one writes her a letter indicating that she is suicidal. She then takes these 2 psychiatric letters to her favorite hospital, and each hospital has an abortion committee, excluding the Catholic hospitals. And this abortion review board is usually composed of 3 OBGYNs, and she walks in with 1 letter in each hand and waves them, and they all sit there and nod their heads. They assent, and then she goes into the hospital and has an abortion, which is necessary to preserve her life, because otherwise she would take it, and this way avoids the statute. But the amount local hospitals do is just a drop in the bucket compared to the number of people that we see. It's just nowhere near meeting the demand. And it's a very expensive proposition. Judy Whitcomb could see that the clergy service was not meeting the demand either. Even during periods of relative calm, when her underground appeared to be running as smoothly as a commuter airline, Judy knew she was missing women too poor or too timid to seek out directions on how to leave the state for an abortion. By 1972, the service had gone sufficiently public to make underground the wrong term anyway. It was the pregnancy consultation service now, with letterhead stationery and business cards, and papers of incorporation that Sussman had drawn up. They had telephone numbers in 5 cities and a small office in St. Louis. The newspapers had written about them, occasionally in a tone that bordered on frank admiration. One headline in a county suburban paper read, "For problems with pregnancy, call 388-0310. And in the women's pages of the Post-Dispatch, an advice columnist ran the telephone number in the matter-of-fact voice the columnist often used to list information about charities or civic organizations. Under the column's headline, a newspaper artist had drawn a small illustration for emphasis, an airborne jet, the New York skyline looming below, and every passenger seat occupied by a crossed-out stork. And it was plain by 1972 that unless some zealous new attention grabber came to work at one of the local prosecutor's offices, the legal authorities intended to leave the service alone. Newspaper writers used Judy's telephone number whenever they needed comment on abortion news. In their articles, she was Mrs. Judith Whitcomb, director of the Pregnancy Consultation Service, and when the public hearings were called, Judy now made the drive down to Jefferson City so that she could take her turn at the microphone too. She gave the legislature's numbers, sometimes with dollar signs attached, 5,000 women a year, referred out by the service. Husbands or companions sometimes traveled alongside. At least $1 million on airline tickets alone. Another $1 million on abortion fees paid to doctors outside the state of Missouri. Abortion causing outflow of money from state, one St. Louis headline ran crassly, but it was true. All one had to do was sit down with the calculator and the fee list from California and New York. If it were legal in Missouri, if that vicious, winking, we don't really mean this language could just be erased one day from the pages of the statute books. From Washington, where the Supreme Court was due to release its opinions in Roe v. Wade and Doe v. Bolton, there was silence. Then, in June 1972, a brief announcement delivered without elaboration. Both cases had been held over for the next term, with re-arguments scheduled for the fall. Justice Hugo Black and John Marshall Harlan had retired in 1971, leaving only a 7-man court to hear the first oral arguments. Now the 2 vacancies had been filled, with President Richard Nixon's appointees William Rehnquist and Lewis Powell. And although the court never made explicit its reasons for holding the cases over, all the Roe and Doe attorneys were to come back to Washington and present their arguments again in October 1972 to the full Supreme Court. Once again, the briefs were filed, the moot court staged, the arguments rehearsed in anticipation of the justices' questions from the bench. Then 1 week before the Roe and Doe re-arguments, the Missouri Supreme Court handed down its ruling in Rogers v. Danforth. It was worse than Sussman had imagined. The opinion was short and blunt. The argument that the statute was unconstitutionally vague, the Missouri court ruled, was without merit. The rulings of other federal courts finding similar statutes unconstitutional elsewhere were irrelevant. As to the many other arguments, Sussman and Thayer had proffered, the claims of privacy rights and equal protection and due process and so on, the Missouri court dispensed with them all in 2 brief paragraphs. The issue in this case, the Rogers opinion read, are sharply and significantly narrowed by the following facts stipulated to by the parties. The stipulation. Human life is a continuum from conception to death. They were skewering the case on the stipulation, on that 16-page embryos are fetuses are children's treatise that Sussman hadn't known what to do with. The United States Supreme Court has expressed itself on the taking of human life in the case of Furman versus Georgia. The Missouri Supreme Court went on, invoking what seemed to Sussman the spectacular non sequitur of a recently decided landmark capital punishment case. As we read the opinions in Furman, the court generally expressed its disapproval of the practice of putting to death persons who some would agree had forfeited their right to live. We believe we must anticipate at least equal solicitude for the lives of innocents. Well, there was a lot of interesting jurisprudential reasoning emanating from the abortion cases around the states, but Sussman had never seen this argument before, that if states are forced to let criminals live, then they must also be allowed to prohibit abortion. The Rogers ruling included one frosty dissent, twice the length of the majority opinion. There is a great difference between finding that the death penalty, as it has been imposed in this country, is unconstitutionally cruel and unusual punishment, and finding that an abortion in the early stages of pregnancy is thereby an unconstitutional taking of a human life, wrote Justice Robert Sealer, the one Judge Sussman had suspected might lead his way. If the parties were to stipulate that 2 + 2 = 5, we would not consider ourselves bound by it. And I do not consider myself bound by a stipulation which purports to establish as an immutable fact that a month-old embryo is the same, except for age and maturity, as an adult. No other justices joined in the dissent. Hayseeds. The reasoning of this decision has been criticized in many quarters, Sussman wrote to his plaintiffs the following week, phrasing very sparely his assessment of the Furman v. Georgia logic. We believe this legal precedent is not analogous. The practical effects of the Rogers ruling, Sussman wrote, were slight. An appeal would, of course, be forthcoming, but the U.S. Supreme Court already had on its docket 2 cases whose outcome could be expected to address all of the constitutional questions raised by Rogers v. Danforth. The Texas law before the Supreme Court was nearly identical to Missouri, Sussman wrote, and there was a strong feeling that the court was prepared to take on directly the question of state control over abortion. It is my considered opinion, Sussman wrote, that the United States Supreme Court will hold that a woman has a constitutional right to an abortion, at least during the first trimester. But what the court did hold, 3 months later, on the 3rd Monday of 1973, astonished even him. The ruling, 1973. For the rest of his life, Bill Cox would remember that he first heard the news on the radio, KWOS, or KLIK, one of the Jefferson City stations that mixed music with hog price updates and dispatches from the National Wire Services. In the basement office of the Missouri Catholic Conference, a table radio sat on one of the cluttered desks, and it seemed to Cox afterward that for some moments he had stood over this radio, his face turned toward the plain wood paneled wall, and wondered whether he could possibly have heard right. Washington, January 22nd. The Supreme Court barred the states today from interfering with the decision of a woman and her doctor to end pregnancy within the first 3 months. In a 7-2 decision striking down the Texas abortion law, Justice Harry A. Blackmun said medical data indicated abortion in the first 3 months, although not without its risks, is now relatively safe. Therefore, he said, any interest of the state in protecting the woman from an inherently hazardous procedure has largely disappeared. The ruling was issued after 2 years of deliberations by the justices. It was based predominantly on what Blackmun called a right of privacy. He said the right is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. The bulletins changed as the days went on, and the headlines were confusing in their hurried reports. Court bar states from banning abortion in first 3 months. High Court rules abortions are legal up to 7th month. It was a crowded news day because Lyndon Baines Johnson died of a heart attack that afternoon. The papers and the radio news were full of tributes to the former president. And late into the night, as Bill Cox and his Catholic Conference colleagues scrambled for details on the Supreme Court abortion cases, one central piece of information was repeated again and again until they finally came to see that this, at least, must against all instinct and common sense be true. Every state. The Supreme Court of the United States had made the practice of abortion legal in every state, no matter what the statute book said, no matter what the legislators believed, no matter how convincing the photographs of small, dismembered human feet. For the last 3 years, Bill Cox had watched no holds-barred abortion work its way into New York and California. But those were distant places, wild and ethnic, and famously unfettered by Midwestern restraint. Cox had grown up in Missouri, the son of a Jefferson City lobbyist, and even Kansas seemed to him a culture so different from his own. Westward frontier and every man for himself and so on, that he had never imagined the newly legal Kansas abortionists spreading their practice east across the border. It was not conceivable that in Missouri, at that time, the law would change, Cox recalls. It was just not conceivable. Now the Supreme Court had changed it in a single morning from 1,000 miles away. Passage by passage, as Cox and his Catholic Conference co-workers examined the second-day articles, and finally the Supreme Court opinions themselves, the vast sweep of what the court had done began to take shape before them. In the Texas case, Roe v. Wade, the court had struck down the Texas abortion statute and, by extension, the 30 other state laws like it, including Missouri's. In the Georgia case, Doe v. Bolton, the court had struck every provision of the model penal code law that actually hampered the practice of abortion: the residency requirement, the hospital requirement, the 3-doctor approval, the mandatory hospital abortion committees. They were lengthy opinions, more than 100 pages of print. But if one studied them both together, as Blackmun himself had indicated, the reader was meant to do, then neither the first 3 months nor the legal up to 7th month headline had done an adequate job of suggesting just what it was the Supreme Court was now demanding of the American states. As long as doctors approved them, as long as attending physicians could be said to be exercising their best medical judgment, then abortions were to be legal, as Cox read the rulings in every state and all the way into the 9th month of pregnancy. Nobody seemed to understand that at first, but it was written there in plain English in the text. Bill Cox was not a lawyer. Politics was his passion, bred in his own childhood, so that once he had thought he might run for public office himself. He was no abortion expert either. The Missouri Catholic Conference had hired him straight out of Notre Dame as a legislative policy analyst, emphasis on education, and what Cox knew about abortion practice he had learned on the job, taking his turn as an on-request speaker with the Wilkie abortion pictures. It was the pictures that had radicalized him, it would seem to Cox later, but only in the way that famine photographs can rouse a complacent person to write letters or send money. No one needs a picture of a starving infant to understand that famine is bad. Human rights was becoming a term of some currency, the human right to speak freely and to live without political repression. And every time Cox put before an audience one of the dilation and curative slides, listening in the darkened auditorium for the silence, and then the swift sucking in of breath that meant someone had taken an instant to understand exactly what the picture was showing, it seemed to him that everyone in the room must surely see how wrong it was to pigeonhole abortion as a Catholic issue, or even as a women's issue. How could the term human rights have any meaning at all if it did not include the right to keep from being dismembered? Roe et al. V. Wade, District Attorney of Dallas County, was the first Supreme Court ruling Bill Cox ever read from beginning to end, every line of every opinion, concurrence and dissent, including the footnotes.
Will the sister yield to a question?
Yes.
I thank the esteemed sister. My name is Sue Gibson, and I am here today representing the National Organization for Women. The bulletins changed as the day went on, and the headlines were confusing in their hurried reports. Court bars states from banning abortion in first 3 months. High Court rules abortions are legal up to 7th month. It was a crowded news day. Passage by passage, as Cox and his Catholic Conference co-workers examined the second-day articles, and finally the Supreme Court opinions themselves, the vast sweep of what the court had done began to take shape before them. In the Texas case, Roe v. Wade, the court had struck down the Texas abortion statute, and by extension, the 30 other state laws like it, including Missouri's. In the Georgia case, Doe v. Bolton, the court had struck every provision of the model penal code law that actually hampered the practice of abortion: the residency requirement, the hospital requirement, the 3-doctor approval, the mandatory hospital abortion committees. There were lengthy opinions, more than 100 pages of print, but if one studied them both together, as Blackmun himself had indicated the reader was meant to do, Then neither the first 3 months nor the legal up to 7th month headline had done an adequate job of suggesting that just what it was the Supreme Court was now demanding of the American states. As long as doctors approved them, as long as attending physicians could be said to be exercising their best medical judgment, then abortions were to be legal, as Cox read the rulings, in every state and all the way into the 9th month of pregnancy. Nobody seemed to understand that at first, but it was written there in plain English in the text. Bill Cox was not a lawyer. Politics was his passion, bred in his own childhood, so that once he had thought he might run for public office himself. He was no abortion expert either. The Missouri Catholic Conference had hired him straight out of Notre Dame as a legislative policy analyst, emphasis on education, and what Cox knew about abortion practices he had learned on the job, taking his turn as an on-request speaker with the Wilk abortion pictures. It was the pictures that had radicalized him, it would seem to Cox later, but only in the way that famine photographs can rouse a complacent person to write letters or send money. No one needs a picture of a starving infant to understand that famine is bad. Human rights was also becoming a term of some currency. The human right to speak freely and to live without political repression. And every time Cox put before an audience one of the dilation and curettage slides, listening in the darkened auditorium for the silence and the swift sucking in of breath that meant someone had taken an instant to understand exactly what the picture was showing. It seemed to him that everyone in the room must surely see how wrong it was to pigeonhole abortion as a Catholic issue or even as a woman's issue. How could the term human rights have any meaning at all if it did not include the right to keep from being dismembered before birth? Roe et al. V. Wade, District Attorney of Dallas County, was the first Supreme Court ruling Bill Cox ever read from beginning to end, every line of every opinion, concurrence and dissent, including the footnotes. The medical judgment may be exercised in light of all factors, physical, emotional, psychological, familial, and the woman's age, relevant to the well-being of the patient. All these factors may relate to health. This allows the attending physician the room he needs to make his best medical judgment, and it is room that operates for the benefit, not the disadvantage, of the pregnant woman. Or in blunter language, if appropriate medical judgment pronounces the abortion necessary for familial factors or psychological factors, or a woman's emotional well-being, then the state may not interfere to save the fetus. Had the state been left with anything at all? In the months leading up to January 1973, 3 men worked full-time in Jefferson City for the Missouri Catholic Conference. Bill Cox, a former seminarian and city councilman named Anthony Heisberger, and a former Missouri state attorney named Louis DeFeo. DeFeo came from Kansas City, which in the mythology of Missouri geography is supposed to provide the relaxed western counterbalance to the more eastern informal St. Louis, but he was a man of sober demeanor and great reserve, his desk often stacked with yellow legal pads that he filled with tight handwritten notes. To Cox and Heisberger, DeFeo was the slow-talking conservative senior man, methodical and lawyerly, the one who wrote language like shall be construed and pursuant to Section 211 into conference drafted legislation. When Matt Backer had agreed to let his name be used as an intervener in Rogers v. Danforth, thus assuming guardianship of the symbolic infant doe, it was DeFeo and a second attorney who had researched and written the Backer briefs. Now the earliest copies of the Roe and Doe opinions came to Lou DeFeo first, and after he read them and reread them, an uncharacteristic fury filled his voice as he told the non-lawyers in his office what the court majority had done. It was biologically illiterate. There was absolutely no precedent for it. It was wrong. They had 5 weeks left before the March 1st state capitol deadline for introducing new legislation for 1973. Now, Lou DeFeo said, we start drafting now. We hit the floor at a run. Bill Cox flew to Washington, where a dozen state Catholic Conference representatives gathered at the U.S. Catholic Conference headquarters for a grim comparing of notes. In the face of such grand-scale restrictions on the states, what kind of legislation could possibly stand up in court? Was there any way to restore to the states some supervisory power, some authority to ensure at least that the taking of human life not become as commonplace and morally unconstrained as minor elective surgery? Cox brought a few ideas back to Jefferson City, and DeFeo telephoned the state conference offices in New York and other strong Catholic states. Rapidly, a rough list began to form. Perhaps they could require written approval of the baby's father. Parental consent could be made a prerequisite for abortions on underage girls. Live birth language might be conspicuously written in, a mandate that late-stage abortions be performed using a method more likely to deliver a live infant. The legislation itself could include directives on rushing medical aid to an infant that managed to survive a saline or hysterotomy. Probably the reporters would pick up on wording of this nature with its immediate dreadful imagery, and the ensuing articles might help people understand what the court was actually requiring of their own state laws. Abortion, the destruction of the life of an unborn child in its mother's womb, or the termination of the pregnancy of a mother with an intention other than to produce a live birth or to remove a dead unborn child. Even a legislative definition could be phrased to wave before the public a certain way of thinking about what the Supreme Court had done, and DeFeo's legal pads filled with possibilities for a last-minute omnibus everything we can think of abortion bill. He felt a certain queasiness as the draft legislation neared completion, and his discomfort deepened when he heard a few Jefferson City legislators express the same concern. Was the very act of writing this legislation turning them into collaborators? Had DeFeo spent 13 years as a working attorney and a lifetime as a practicing Catholic so that he could bend over a basement desk in Jefferson City and write regulations on the taking of human life? There was not much besides abortion on DeFeo's mind. Those first few weeks after the January 22nd news, and as he talked to men and women in Jefferson City and around the country, some repeated aloud the argument that had been troubling him privately. We must not be accomplices. When Hitler passes a law saying all Jews must wear yellow stars, do we rush to our offices and compose regulations for the yellow star distribution centers? Is there no point at which a person must stop, refuse to budge, and declare, I will not participate in evil? DeFeo didn't know. It was moral triage. A general sends his soldiers into war, knowing some of them will be killed, because he believes that is how he can limit suffering on a larger scale. If no one were willing to write legislative paragraphs about the procedures to be followed before taking the life of an unborn child in its mother's womb, then the limits of the Supreme Court's ruling would never be tested, and abortionists would work without any restraints at all. And so DeFeo went on writing his subsections. Only after the woman certifies in writing their consent. Only after obtaining the written consent of the father. In the event that a child shall manifest a heartbeat, pulse, or other vital signs subsequent to leaving the body of the mother, ... He was going to be the general and send the soldiers in. He had no right not to. That was how it seemed to DeFeo. He was not going to keep himself holy while watching his companions lose the war. If I take the idealistic approach, the babies die, DeFeo recalled many years later, remembering his own time of doubt. If I go into the fray, then maybe it's something like this. No babies die post-viability while we fight for the rest of them. Amid all the written pages in Roe v. Wade and Doe v. Bolton, all the historical background and constitutional discourse, and citations from previous cases, there were three passages in particular that most inflamed ordinary men and women in state right-to-life organizations, and that helped make activists of abortion opponents who had never before thought to sign a petition or join a committee. One had to read through 37 pages of Roe v. Wade to reach the first of these passages, and in those pages themselves was a very great deal to trouble a person of Lou DeFeo's beliefs. DeFeo had a passing acquaintanceship with the Supreme Court Justice who wrote both the Roe and Doe majority opinions. As a novice lawyer, DeFeo had clerked for an Eighth Circuit Court of Appeals judge in 1961, when Harry Blackmun was also serving on the Eighth Circuit and would fly down regularly from his home in Minnesota to St. Louis for week-long convocations of the multi-state court. DeFeo thought Blackmun a likable man, affable and kind, and he knew the soft-voiced Minnesotan had a reputation for working so slowly and painstakingly on his assigned opinions that the final products sometimes generated some eye-rolling around the halls. They were long, scholarly, and given to so much discursive information that lawyers preparing law journal articles, which often required extensive research into case rulings and legal history, cheered up instantly when they saw that Blackmun had already addressed their subject in a judicial opinion. It was President Richard Nixon who had elevated Harry Blackmun to the Supreme Court in April 1970, and until now nothing the relatively new justice had said or written had offered any strong signal as to how he might approach the question of abortion law. Nixon was opposed to loosening abortion laws, or so he had maintained in public, and at the time of Blackmun's Supreme Court nomination, it was supposed, based on Blackmun's own record and Nixon's declaration that he wanted to send the court another strict constructionist, that the new justice from Minnesota would cast moderately conservative votes with a cautious inclination toward civil liberties. Only one item of biographical data might have stirred any speculation about Blackmun's views on matters of medical practice. For 10 years, from 1950 until his Court of Appeals appointment in 1959, Blackmun had served as resident counsel to Minnesota's famous Mayo Clinic. In post-Roe years, several published accounts of the Roe and Doe deliberations would provide background detail on the lengthy Supreme Court discussion that followed the first oral arguments. How Blackmun worked especially hard at first on the Doe v. Bolton ruling, grappling with his own reluctance to dispense with the idea of hospital approval committees. I have seen them operate, Blackmun wrote in an early memo to his colleagues, and they serve a high purpose in maintaining standards and in keeping the overzealous surgeon's knife sheathed. How one justice after another added insertions and revisions as the opinions evolved. How Blackmun flew back to Minnesota the summer before the re-argument and spent 2 weeks alone in the Mayo Clinic library studying medical volumes and researching the history of the Hippocratic Oath. None of this detail was available in January 1973 to a lobbyist in Jefferson City, Missouri, but Lou DeFeo was familiar enough with Supreme Court procedure to know that any important 7-2 ruling reflects more than the thoughts of a single justice and his clerks. DeFeo also remembered that Blackmun had spent a decade on the premises of one of the nation's most prestigious hospitals, and this information only deepened DeFeo's anger at the justice whose name was most prominently attached to the majority opinion. Blackmun should have known better. DeFeo declared aloud as he read with his colleagues the opinions, especially offensive paragraphs, Blackmun should have used his medical background to correct whatever misguided collaboration had taken place among the justices. How could a learned man, steeped for 10 years in the evolving dramas of biological science, make these extraordinary conclusions in the name of the Supreme Court? There were 12 separate sections to Roe v. Wade alone, each headed by a Roman numeral. The very first was preceded, uncharacteristically, for the court that was supposed to act as the unassailable arbitrator of American legal disputes, by a preface that came tantalizingly close to apology for the reaction the justices were likely to provoke. I quote, "We forthwith acknowledge our awareness of the sensitive and emotional nature of the abortion controversy, of the vigorous opposing views, even among physicians, and some of the deep and seemingly absolute convictions that the subject inspires. One's philosophy, one's experiences, one's exposure to the raw edges of human existence, one's religious training, one's attitudes toward life and family and their values, and the moral standards one establishes and seeks to observe are all likely to influence and color one's thinking and conclusions about abortion." Close quote. Then the judicial work of the opinion commenced in earnest. The facts of the case were outlined and various procedural questions dispensed with. Yes, Jane Roe did have standing to bring this suit, even though she herself was no longer pregnant. If that termination makes a case moot, pregnancy litigation seldom will survive much beyond the trial stage. An appellate review will be effectively denied, the opinion read. No, the other Texas plaintiffs, the physician convicted of performing abortions, and the married couple who had been advised not to use birth control pills, did not. There was a lengthy discourse, very Blackmunian, DeFeo thought with some exasperation, on the history of abortion, going all the way back to ancient Greece and the wording of the Hippocratic Oath. The oath includes a pledge never to induce abortion, and although none of the principals in either case had thought to bring it up, Blackmun was clearly troubled by the apparently inflexible words in the famous oath that has stood for so long as the ethical guide of the medical profession. A published 1943 History of the Hippocratic Oath, the opinion read, provided a satisfactory explanation. When the oath was composed, it reflected the beliefs of ancient Greece's Pythagorean philosophers, who condemned abortion as the destruction of a living being, although theirs was at the time a minority view within their own culture. That this view advanced in popularity over the centuries was undisputed. Blackmun had written, but church and criminal laws had contained their own ambiguities even as they condemned the act of abortion. Here the work of the New York NARAL-affiliated law professor Cyril Means appeared to have paid off nicely, for the opinion's references to early Christian theology and the development of the common law included lengthy citations to Means Law Journal articles and concurred in much of their argument. It is undisputed that at common law, abortion performed before quickening, which is the first recognizable movement of the fetus in utero, appearing usually from the 16th to the 18th week of pregnancy, was not an indictable offense. The absence of a common law crime for pre-quickening abortion appears to have developed from the confluence of earlier philosophical, theological, and civil and canon concepts of when life begins. Although Christian theology and the canon law came to fix the point of animation at 40 days for a male and 80 days for a female, a view that persisted until the 19th century, there was otherwise little agreement about the precise time of formation or animation. There was agreement, however, that prior to this point, The fetus was to be regarded as part of the mother, and its destruction, therefore, was not homicide. The law of England was detailed from the 19th century on, as were the first American statutes, which, like the early English law, distinguished in severity between abortion before quickening, not a crime at all in some of the earliest state laws, and abortion after quickening. Even the early laws that did criminalize early abortions established milder penalties for abortions performed before a woman could be said to feel the movement of the fetus. A pre-quickening abortion under the early New York law was a misdemeanor, for example, while abortion of a quick fetus was a second-degree manslaughter. It was not until the late 19th century that the country's laws began to show uniformity in condemning abortion at any time during pregnancy, Blackmun had written. It is thus apparent that at common law, at the time of the adoption of our Constitution, and throughout the major portion of the 19th century, abortion was viewed with less disfavor than under most American statutes currently in effect. Phrasing it another way, a woman enjoyed a substantially broader right to terminate a pregnancy than she does in most states today. Why then had the laws of every state been rewritten before the turn of the century to criminalize abortion throughout pregnancy? Several principal explanations had been advanced. Blackmun had written first that abortion laws were the product of a Victorian social concern to discourage illicit sexual conduct. But the state attorneys were not even trying to raise those arguments in defense of the Texas abortion law. The opinion observed, and no court had taken seriously the proposition that states may try to prevent sexual immorality through their abortion laws. Second, Blackmun had written, citing a 1940s history of medicine, abortion during the 19th century was dangerous. The procedure itself, that is, even when conducted under what, for that era, were medically sound conditions. When most criminal abortion laws were first enacted, the procedure was a hazardous one for the woman. This was particularly true prior to the development of antisepsis. Antiseptic techniques, of course, were based on discoveries by Lister, Pasteur, and others announced in 1867, but were not generally accepted and employed until about the turn of the century. Abortion mortality was high. Thus, it has been argued that a state's real concern in enacting a criminal abortion law was to protect the pregnant woman, that is, to restrain her from submitting to a procedure that placed her life in serious jeopardy. But modern medical techniques had made abortion far safer for women, Blackmun had written, citing a half dozen medical studies, even safer when conducted during early pregnancy than full-term pregnancy and childbirth itself. So the state's rationale for criminalizing the procedure because it was inherently dangerous had largely disappeared, the opinion read. Thus far, for a person up to date on the essays and scholarly writings circulating among the more active state right-to-life organizations, this Roe opinion had already struck out in a dubious direction. It was worrisome to see Blackmun going to such lengths to explain away the abortion reference in the Hippocratic Oath, or citing as historical authority articles by the second abortion advocate Cyril Means. But then the Blackmun opinion listed the next argument that had been advanced to explain and justify the enactment of criminal abortion laws. The third reason is the state's interest. Some phrase it in terms of duty in protecting prenatal life. Some of the argument for this justification rests on the theory that a new human life is present from the moment of conception. The state's interest and general obligation to protect life then extends, it is argued, to prenatal life. Here was the first of the Roe v. Wade passages whose special offensiveness would become a subject of animated discussion in right-to-life circles. The very choice of vocabulary jolted the right to life reader, and warned of what lay ahead. Quote, rests on the theory that a new human life is present from the moment of conception, close quote. This was a theory. The principle that life begins at conception was to be regarded as a kind of educated guess, a plausible hypothesis. Had Blackman and his brethren, in all their voluminous research, declined to pick up an obstetrics textbook, the opinion proceeded cautiously, a step at a time. One did not need to accept this belief in life at the moment of conception, Blackman had written, in order to defend the state interest in potential human life. It was a less rigid claim, but certainly a valid one. If one recognized this interest, this justification by the state for laws that dictate what a person may and may not do, then the federal courts could step in only if there was some other and stronger conflicting interest involved. And there was, the opinion read, privacy. Even though the word was nowhere in the Constitution's text, Blackman had written the rules commonly grouped together, the rulings commonly grouped together as privacy holdings, including most famously Griswold v. Connecticut, established within the protections of the Constitution a guarantee of certain areas of zones of privacy. Courts might find the roots of that guarantee in different parts of the Constitution, the opinion read. The U.S. District Court Roe v. Wade ruling that preceded this one had based the privacy guarantee in the 9th Amendment, which declares that the people may not be denied rights simply because they are not among those specifically named in the Constitution. Another defensible source for the privacy right was the 14th Amendment, which was ratified after the Civil War and wrote protections for the former slaves into the Constitution. The applicable passage, which for more than a century had been invoked and debated in a wide variety of appellate cases, declared that no state could deprive any person of life, liberty, or property without due process of law. The Supreme Court majority in Roe v. Wade now found the privacy right, Blackman had written, in this phrase of the 14th Amendment. And regardless of where its constitutional roots might lie, in the 9th or in the 14th Amendment, the right of privacy was broad enough to encompass a woman's decision whether or not to terminate her pregnancy. The detriment that the state would impose upon the pregnant woman by denying this choice altogether is apparent. Specific and direct harm, medically diagnosable even in early pregnancy, may be involved. Maternity or additional offspring may force upon the woman a distressful life and future. Psychological harm may be imminent. Mental and physical health may be taxed by child care. There is also the distress for all concerned associated with the unwanted child, and there is the problem of bringing a child into a family already unable, psychologically and otherwise, to care for it. In other cases, as in this one, the additional difficulties and continuing stigma of unwed motherhood may be involved. None of these arguments would support a right to abortion, the opinion read, if the fetus were directly protected by the 14th Amendment, as the state of Texas and some friend of the court briefs had argued. If the fetus itself could be defined as a person, the opinion acknowledged, then the amendment would seem to guarantee the fetus' own right to life and liberty. But elsewhere in the Constitution and in other appellate cases, the opinion went on, person was used to mean a person already born. All this, the opinion read, together with our observation that throughout the major portion of the 19th century, prevailing legal abortion practices were far freer than they are today, persuades us that the word person, as used in the 14th Amendment, does not include the unborn. In a footnote, Blackman observed that Texas faced a logical dilemma in urging that fetuses were entitled to 14th Amendment protection. Neither in Texas nor in any other state are all abortions prohibited. Despite broad proscription, an exception already exists. The exception contained in Article 1196 for an abortion procured or attempted by medical advice for the purpose of saving the life of the mother is typical. But if the fetus is a person who is not to be deprived of life without due process of law, and if the mother's condition is the sole determinant, does not the Texas exception appear to be out of line with the amendment's command? Here was the second particularly disturbing passage for a reader of right-to-life inclinations. Nearly anyone who had encountered the 14th Amendment in a history class understood it as a measure of protection, as a set of paragraphs meant to ensure greater security for the life, liberty, and property of individual Americans. That those very words should be cited to permit the taking of fetal life was in itself hard to grasp, but more viscerally upsetting, especially for the non-lawyers who made up most of the Right to Life volunteer forces around the states, was the spectacle of 7 justices announcing that for the purposes of the 14th Amendment, and by extension, logic would seem to suggest the entire American legal system, a fetus was not a person. To a man or a woman who had seen what Jack Wilkie intended in the shining magnificence of the perfect tiny feet, the Supreme Court of the United States had just defined out of existence one branch of the human race. But the worst was still to come. Even apart from questions of 14th Amendment interpretation, the opinion read, the attorneys representing Texas had argued that life began at conception and that protecting human life was one of the duties of a state. And now the court made good on its ominous earlier suggestion about the theory of new life's beginnings. We need not resolve the difficult question of when life began what in right to life ranks were soon to become the most famous 2 sentences in the history of the Supreme Court. When those trained in the respective disciplines of medicine, philosophy, and the theology are unable to arrive at any consensus, the judiciary, at this point in the development of man's knowledge, is not in a position to speculate as to the answer. 2.5 pages of elaboration followed that passage with examples of religious argument and philosophical debate, and the uncertainties raised by new biological developments like morning after pills and embryo implantation. And the opinion went quickly on to say that this did not mean the state must always let pregnant women do anything they wished with the potential life they were carrying. The state does have an important and legitimate interest, the opinion read, in preserving and protecting the health of the pregnant woman, whether she be a resident of the state or a non-resident who seeks medical consultation and treatment there. And it has still another important and legitimate interest in protecting the potentiality of human life. These interests are separate and distinct. Each grows in substantiality as the woman approaches term, and at a point during pregnancy, each becomes compelling. Compelling is a crucial word in constitutional argument. Even when a deeply important personal right is found to be protected by the Constitution, that right can be taken away if the state proves it has a reason that qualifies as compelling. In legal terminology, such a statute must not only satisfy this compelling need of the state, the law must also be narrowly tailored to serve the compelling interest. In other words, the statute must satisfy an especially important state need and must be carefully written to address that need specifically. And with its complex 3-part Roe v. Wade mandate, the court now explained the state had dual compelling interests, which appeared at different points in pregnancy. The barriers were to be set at the trimesters, which were the divisions of obstetrical studies sometimes used to distinguish among different periods of pregnancy. In a normal gestation, each trimester would last about 12 weeks, and what the state could require of a given woman, how much control it could exert through its abortion laws, would from now on depend upon which trimester her pregnancy had advanced to on the day she showed up for an abortion. During the first trimester, the state had no compelling interest that could logically be invoked and could do nothing to interfere. The abortion decision was solely up to the attending physician in consultation with his patient. Then, at approximately the end of the first trimester, when by statistical evidence induced abortion became more dangerous to the woman than continuing her pregnancy, the state could use its compelling interest in maternal health and maternal health only by enacting regulations designed to protect the women themselves. It could require, for example, that all abortions be performed in hospitals. But the protection of life, which people like Louis Fail and had always imagined to be one of the most basic functions of any enlightened government, was not to be invoked in abortion laws until the third trimester of pregnancy. And then, in so timid a fashion that as DeFeo saw it, even those laws could do no real good. With respect to the state's important and legitimate interest in potential life, the compelling point is at viability. The option read, "This is so because when the fetus then presumably has the capability of meaningful life outside the mother's womb, state regulation protective of fetal life after viability thus has both logical and biological justifications. If the state is interested in protecting fetal life after viability, it may go so far as to proscribe abortion during that period, except when it is necessary to preserve the life or health of the mother." Even in the most pessimistic circles of right to life organizations, nothing had prepared people for reasoning quite like this. Requiring every state to allow legal abortion within its borders was bewildering enough, but the way the Supreme Court had done it, that was what struck so powerful a blow. If what Blackmun and his fellow justices had written was meant to be Solomonic, a respectful nod toward all sides, its effect was almost precisely the opposite on those who believed they were battling for the rights of human beings too fragile to defend themselves. From their perspective, emergency room physicians might as well have been ushered into an arena with murderers and told with great cordiality that the court saw the merit in all their respective positions. We need not resolve the difficult question of when life begins. What did the justices imagine their job to be? They were the Supreme Court. They were supposed to resolve difficult questions. If the Supreme Court was going to duck every time those trained in the respective disciplines of medicine, philosophy, and theology disagreed with one another, then the justices might as well give up and go home. They had sidestepped with their 7 votes of support for the majority opinion what right to life people saw as the single most important issue before the court in Roe v. Wade. The humanity of the unborn baby, a phrase whose very vocabulary seemed to underscore its internal logic, had been relegated in a single morning to the status of opinion. The sociologist Kristen Luker, whose highly regarded 1984 book, Abortion and the Politics of Motherhood, was based in part on detailed interviews with California activists from both sides, wrote perceptively about the profound sense of disbelief and betrayal her right to life interview subjects described. accustomed as they were to thinking that theirs was the majority opinion. The pro-life people we interviewed saw in the Supreme Court decision a way of thinking that seemed bizarre and unreal, something they believed to be both fundamental and obvious, that the embryo was a human life as valuable as any, and perhaps more valuable than some because it was innocent, fragile, and unable to act on its own behalf, was now defined as simply one opinion among several. What was more, it was defined as an opinion belonging to the private sphere, more like a religious preference than a deeply held social belief, such as belief in the right to free speech. It was as if the Supreme Court had suddenly ruled that a belief in free speech was only one legitimate opinion among many, which could not therefore be given special protection by any state or federal agency. It offered no solace in the grim Jefferson City office of the Missouri Catholic Conference to find saluted in print the abortion opponents' deep and seemingly absolute convictions and the state's important and legitimate interest in potential life. The law was what mattered, the written word in the statute books, and the law had just been obliterated by the Supreme Court. There were only two passages in Roe v. Wade and Doe v. Bolton that seemed to Lou DeFeo to make any logical or moral sense at all, and those were the dissents. Justices William Rehnquist and Byron White had cast the two no votes, and White in particular used language so barbed that DeFeo repeated it aloud with some satisfaction. Raw judicial power, White had written, attacking both the substance of the majority opinions and the reasoning his fellow justices had used to shape them. Certainly, sister.
Thank you. I'm going to continue reading. Okay.
Yeah, or take them off there. Okay.
Yes?
Yeah.
Okay.
Yeah.
I'm going to continue reading Articles of Faith. The court, for the most part, sustains this position. During the period prior to the time the fetus becomes viable, the Constitution of the United States values the convenience or whim of the mother more than the life or potential life of the fetus. With all due respect, I dissent. I find nothing in the language or history of the Constitution to support the court's judgment. The court simply fashions and announces a new constitutional right for pregnant mothers, and with scarcely any reason or authority for its action, invests the right with sufficient substance to override most existing state abortion statutes. The upshot is that people and the legislatures of 50 states are disentitled to weigh the relative importance, the continued existence and development of the fetus on the one hand, against a spectrum of possible impacts on the mother on the other hand. As an exercise of raw judicial power, the court perhaps has authority to do what it does today. But in my view, its judgment is an extravagant exercise of the power of judicial review the Constitution extends to this court. In the newspapers and the Catholic missives piling up rapidly on the desks of DeFeo and Cox, reaction alone filled columns of newsprint. Bishops denounced the ruling from nearly every Catholic diocese. In St. Louis, Cardinal John Carberry said he was saddened and appalled by the disregard for human life. In Jefferson City, Bishop Michael McLuffy said he was outraged. In Philadelphia, Cardinal John Kroll, president of the National Council of Catholic Bishops, used the same epithet, an unspeakable, that had been invoked by the Second Vatican Council a decade earlier to describe the crimes of abortion. The Supreme Court's decision today is an unspeakable tragedy for this nation. Cardinal Kroll said in a statement reprinted in length in the New York Times. It is hard to think of any decision in the 200 years of our history which has had more disastrous implications for our stability as a civilized society. Abortion ruling draws cheers and dismay here, the Global Democrat headlined in St. Louis. The cheers took up some of the newsprint too. There were celebratory remarks from the American Civil Liberties Union and the Planned Parenthood Federation and the Center for Constitutional Rights, where Roe v. Wade was publicly hailed as a great victory for the women's liberation movement. Frank Sussman telephoned for reaction by the reporters in Missouri, was excited about the news. I think it's fantastic, he said. It will clearly invalidate our present statute as I understand it. For all practical purposes, the Texas and Missouri laws are identical. In the general audience papers, the Roe v. Wade stories were written with a note of finality. Questions remained, individual state statutes must still be examined one by one, but the Supreme Court of the United States had settled the argument. Resolution appeared in many of these accounts, both as word and implicit idea. A few unresolved issues remained after yesterday's long-awaited ruling, declared the January 23 Washington Post, offering by the way of example one of the smaller matters, veto rights of the father, that the court had skipped over as it put to rest the big ones. In New York, where legislative abortion battles have been busying State House reporters for more than 4 years, the second paragraph of the New York Times principal next day Roe story began like a door swinging shut. An historic resolution of a fiercely controversial issue. But in the St. Louis Review, the Archdiocese Weekly that was delivered by mail to 90,000 Catholic households, the coverage was where the battle begun. Suddenly, everything that preceded the news of January 22nd, and there have been many hundreds of articles in this and every other archdiocese paper in the country, ranging from state-by-state legislative reports to long moral and political analyses of abortion law, were shoved aside as warm-up. Abortion, the battle lines are drawn. Read the headline stripped across the Review's February 9th front page. And nothing in that article so much as suggested the Supreme Court had presented the nation with a resolution. Washington. The U.S. Supreme Court decision striking down state abortion legislation has nationalized the anti-abortion movement. Prior to the decision issued late last month, anti-abortion efforts were usually aimed at state legislatures. But with the restrictive statutes supported in state capitals apparently outlawed by the court decision, the new target has become the Congress. The aim to overrule the Supreme Court through an enactment of constitutional amendment which would specifically guarantee the right to life of the fetus. In its decision, the court said that the fetus was not due constitutional protection of life because it is not a person in the constitutional sense. But the Supreme Court had handed down this and scores of other post-Roe articles urged in their tone of their interview quotes was a massive recruiting call for right-to-life organizations across the United States. In Congress, the staffs of 2 Republican offices had rushed to work on legislative language that might eventually undo Roe v. Wade and Doe v. Bolton. Maryland Representative Lawrence J. Hogan, whose brother was the obstetrician who had provided the Wilkes with some of their first useful pictures, announced within days of the rulings that he was drafting a constitutional amendment and intended to rally his colleagues to join him. If I had been alive in Nazi Germany, I'd like to think I would have had the courage to stand up and oppose the slaughter of Jews, Hogan said. New York Senator James Buckley told reporters he was consulting men of science and law to begin a parallel campaign in the Senate. Public statements and defiant resolutions, the only context in which the Review would use that word, were delivered to news releases by the National Right to Life Committee, by the National Youth Pro-Life Coalition, by the National Federation of Catholic Physicians Guilds. The default of judgment of the court lies in its own admission of indecision on the very crux of the problem, namely, when does life begin, read the angry statement from the Physicians Guild. There's surely irrefutable evidence that life begins long before 6 months of gestation. That so many of these dispatches were arriving affixed with the Catholic label had not gone unnoticed in either the lay or the religious press. The St. Louis Review ran an anxious roundup of protests from inside other churches. Here was a Lutheran minister from New York, Right to Life, a Baptist minister from New Jersey, Right to Life, a blast from the Mormons describing abortion as one of the most revolting and sinful practices of the day. But neither Baptist nor Lutheran church officials had themselves raised public objections to Roe. Of the commonly known non-Catholic religious denominations, only the Mormons and the Orthodox Church in America joined the Catholic Church in an open fight of the Supreme Court rulings. Even the Orthodox Rabbi Council of America, the only branch of American Judaism that condemned early abortion as the taking of human life, declared through a spokesman that the court's authority must be respected even when its decisions appeared flawed. Non-Catholic Protestant court ruling, read the review doggedly, but the problem was impossible to evade. In the press, on the television, and in the public mind, the first great protest to Roe v. Wade was being portrayed as a face-off between the Supreme Court and the Catholic Church. The Congressman Lawrence Hogan, working so swiftly in Washington on his constitutional amendment proposal, was identified as Catholic in a wire service story only 7 lines long. Lawrence J. Hogan, Republican of Maryland, a Roman Catholic. It was a lead chain around their ankles. Bella Abzug could address the National Association for Repeal of Abortion Laws, and nobody ever hurried back to the newsroom to write, Brett Bella Abzug, Democrat of New York, a Jew. The connection was going to have to be served somehow, or at the very least stretched enough to make people see that men and women enlisting in right-to-life groups were not simply snapping to attention under the orders from their bishop. And one of the first targets was the modest and somewhat ineffectual National Right to Life Committee. In Arizona, the internist Carolyn Gerster, who was an articulate and strikingly good-looking woman, was emerging as one of the bright Protestant lights of the regional Right to Life activity, was still in a paralysis of post-Roe gloom when she was telephoned from Minnesota by Marjorie Mecklenburg and the Methodist who had helped start up the Minnesota organization. The little National Right to Life office in Washington, D.C. was not going to suffice any longer, Gerster recalls. Mecklenburg saying briskly, it was too Catholic. It placed multi-state meetings on Catholic campuses. Its director was a priest. She said, this is obvious. Now that the court decision has occurred, we need a national organization. We should have had one long ago. We were very slowly awakening. Non-sectarian was the first key principle, raised like a national flag as a small collection of men and women from Right to Life organizations around the states began gathering bi-weekly at the centrally located O'Hare Airport in Chicago. 1 or 2 days at a time in long, contentious meetings that sometimes left them exhausted, the dozen of them, Gerster, Mecklenburg, and a handful of attorneys and regional leaders from states as far afield as Washington, Texas, and Vermont, argued over exactly what it was that an organization itself, National Right to Life, ought to pursue. That abortion should be returned to the criminal codes was agreed. But how would that happen? What about the social climate that had helped make abortion acceptable? What about the alarming possibilities implicit in a willingness to abort? Euthanasia, for example, or the eugenic elimination of the unfit. Should intrauterine devices and birth control pills, which were believed to work partly because they prevented implantation of already fertilized eggs, be characterized as as an abortion pill, should the new organization take a stand on contraception in general, urging it as a preventative to unexpected pregnancy, or condemning it as a part of the mentality that has led Americans to believe that sex carried with it no responsibility for the creation of life? At the height of these meetings, a grand disorder of notebooks and hardbound volumes would litter the long table. Gerster brought her text, the lawyers brought sheets of legal papers, the Lennart Bissell article would be open to the most affecting of the in utero pictures. Some people wanted to get the hungry and homeless in there. Margie, for example, had a much broader scope, human life in every aspect, Gerster recalls. Some people were opposed to capital punishment, and they wanted to put that into Article 1. But people said no. That was a different issue. That we were talking about taking of innocent human life without due process of the law. Sorry.
I wonder if we have bigger type. Would that be easier?
Oh.
Or a flashlight?
I think the flashlight, yeah. Sorry. I wear my glasses.
That's like a good backup.
Is it the
bigger
same
type?
book?
No, it's a different book.
Oh, it's a different book.
You want to change a paper?
Sure, yeah.
All right, women filibuster. Let's go. Changing it up.
Sorry, I was like a lot. All right. Roe v. Wade. The untold story of the landmark Supreme Court decision that made abortion legal. All right. Linda Coffey and Norma McCovery were the first to arrive at Columbo's Pizza, an unpretentious family restaurant on Mockingbird Lane in Dallas, Texas. The restaurant was chosen for its central location and hearty, cheap food. None of the three women coming to this dinner meeting had much money. Coffey, aged 26 and a lawyer, was still dressed in the suit she had worn to work. The December chill that passed for winter in Dallas had settled over the city, but as usual, it was not enough to make a winter coat a necessity. Medium height and small bone, Coffey was one of those women with a solid torso and bird-like limbs. Her name was aptly descriptive. Coffey's skin was the color of richly creamed coffee, and she had dark brown eyes. She wore beiges and browns a lot, which intensified her coloring. In the late 60s, an era of heavy makeup and beehive hairdos, Coffey stood out because she wore no makeup and styled her hair simply, either down over her shoulders or in a plain twist. What people noticed first about her was her dark brown, curly, and very fine hair. Its most distinctive feature was that it looked tousled no matter how many times a day she combed it, which was not very often in any event. Coffey was a woman with too many other things on her mind to be overly concerned with appearances. Despite her usually disheveled appearance, though, she managed to dress the role of a young corporate lawyer that she was. Coffey's demeanor would be best described as diffident. She tended to wait for others to take the lead, to introduce themselves and start a conversation. That trait was misleading, and that it sometimes caused someone meeting her for the first time to think she was not especially smart, an appraisal that vanished as soon as she began to talk about the law or any other subject she knew well. Coffey blossomed when she discussed her work. She spoke with the authority of one who not only knew the rules, but also thoroughly understood how to use them. Where a lesser lawyer might mull over the colored suit to wear to impress a judge or jury, Coffey would
Would you like to have someone inquire of you?
Yes.
May I inquire?
Sorry, I think I need to drink a little bit more coffee.
Yeah.
All right, I'm right here.
All right, fantastic.
Coffee being confident.
Okay, let's talk about this hour. We need some
I
coffee.
have too many seats.
Okay, so
I am Mebby. I'm a member of Women's Voices Raised for Social Justice, and I am reading from Roe v. Wade, the untold story of the landmark Supreme Court decision that made abortion legal by Marian Plow. Coffee blossomed when she discussed her work. She spoke with the authority of one who not only knew the rules but also thoroughly understood how to use them. Where a lesser lawyer might mull over what color suit to wear to impress a judge or jury, Coffee would confidently count on the logic of the law to influence. She was unimposing in her knowledge, and her conversations were blessedly free of legal jargon. Coffee never feigned what she did not know, and what she knew cold. Across the table from her sat Norma McCorvey, a waif in appearance and manner, a short, wiry woman with dark brown hair and small features, a stingy mouth, pug nose, and deep-set, mischievous green eyes. She also had an impish air. Her friends called her Pixie, a name that both suited and pleased her. Dressed in blue jeans and a t-shirt, she looked working class, and she was. At 21, she had been married, divorced, and was the mother of a 5-year-old daughter. Her hard life already showed in her face. For someone as street-worn as Norma obviously was, she had some unusual qualities. Vulnerability spilled out of her at times, and she had a naive enthusiasm that occasionally made her a too willing party for the wrong opportunity, and sometimes, as would happen tonight, for the right one. Coffee and McCorvey were struggling with the conversation while they awaited the arrival of a third woman who was going to join them. The silences between the polite chit-chat grew longer. Linda never was any good at small talk, and Norma, having grown up in a family where simple survival was a skill, had never learned any social graces. They would not have helped much with the life she led anyway. Norma had met Linda twice before, once in her lawyer's office and once in Coffee's office. At each of those meetings, at Linda's urging, Norma talked more about herself and her background and her problem, which was hanging heavily over her right now. Norma had not minded telling her story to Coffee, even though Coffee was a stranger. These days, Norma was talking to anyone who might be able to help her out of her predicament. At the moment, however, between these two taciturn women, there seemed to be little left to say. Coffee was biding her time, waiting for her colleague to arrive so that Norma could tell her story once again. Norma was curious, anxious, and eager to hear what these women could do for her. Sarah Weddington pulled her car into a parking spot. A tall, heavy-set woman, she moved with unusual grace. Her most striking feature was her strawberry blonde hair, something she was enormously proud of and often used as a point of reference in conversation. Long, wavy, and thick, truly the kind of hair that used to be described as a woman's crowning glory. Sarah's hair framed a diamond-shaped face that was further enhanced by a flawless pink-toned complexion, a prim mouth, and clear blue eyes. Unlike Coffee, she wore makeup, just the right touch of it. She also wore ruffled pastel clothes, the kind of ultra-feminine dress many big women shy away from, but which looked right on her. Her choice of clothing was neither an affectation nor wishful thinking on her part, but came from a strong sense of what worked for her. She liked to project an image that was both womanly and businesslike. Tonight, dressed in casual pants and a blouse that she had changed into after work, she looked like a teenager, much younger than her 23 years. Sarah lived 40 miles away in Fort Worth. She had recently taken a job as an assistant district attorney and was the first woman hired for that position, a fact for which she was inordinately proud. She walked into the restaurant, scanned the room, and she spotted Coffee, and headed toward the table where the two women sat. She had a real take-charge manner that others either appreciated or resented, depending on what they wanted from her. On this occasion, Linda felt only relieved that Sarah had arrived, welcoming her presence on this night when the two of them must make an important decision. In contrast with Coffee, Sarah Weddington is a native of poise. She has a kind of social polish and soft-spoken, though somewhat programmed manner of talking that one associated with beauty contestants. An intent listener, Sarah was at ease with all kinds of people, an ability she attributed to having been reared a minister's daughter. Coffee introduced Sarah Weddington and Norma McCorvey to one another. For a few minutes, the three women busied themselves discussing what kind of pizza to order. They ordered a beer to drink. Even before the pizza arrived, Weddington began talking to Norma, deftly moving from small talk about the weather, which was uneventful, and the restaurant, which was undistinguished, to the reason they were there. She questioned Norma McCorvey gently and politely, as was her style, and Norma began to tell her story one more time. Norma said she had been living with a woman friend and working as a waitress in Dallas when she first suspected that she might be pregnant. One clue was an attack of nausea, even though she later recalled no one was frying eggs. The nausea persisted, and then a few days later, a friend with whom she was staying commented that she somehow looked different. Swollen was the word her friend had used. Norma attributed this to having downed a couple of beers the previous night. She had eyelids that got puffy over any little change in her system. The nausea still bothered her, and she imagined it had gotten even worse. Norma was worried that her period was delayed, but she could still rationalize away her symptoms. In her family, such delays were attributed to nerves, and she thought this was merely one more sign of her inability to cope with her topsy-turvy life. She had been knocking around from place to place since returning to Dallas a few weeks earlier. First, she had lived for a week or two with one woman friend, but by mutual agreement that was only a temporary agreement. Since then, she had crashed wherever a friend had a spare bed or corner for the night, or, if she got lucky, for a few nights. She had tried living with her father, but that had not worked out. He was mean to her when he got drunk, which was fairly often. Besides, he had just gotten his second divorce and was in no mood to have his unmarried adult daughter living with him. Even though Norma did the housework and tried to make the arrangement work, she found the situation intolerable and soon left to live with another friend. Her nausea worsened, so much so that she was unable to work. Gradually, over several weeks, Norma had to acknowledge what she had been denying. She felt pregnant. She was beginning to look pregnant. She felt the way she had when she was pregnant with her daughter. She finally went to a physician who tested her and reported back a couple of days later that she was indeed pregnant. Involved as she was in her own story, Norma had not failed to notice the effect her story was having on her audience. She had told the story several times over the past 2 weeks, each time adding certain flourishes and embellishing the drama she felt it to be. Nor was she too involved to be quietly forming impressions of the two other women. In previous meetings, Norma had found Linda Coffey to be nice and quiet, a voice of calm in her otherwise tumultuous life. Norma decided she liked Linda even though sometimes she found her slightly distant. She was discovering that she liked Sarah even more. However, from the first moment she met her, Norma sensed that Sarah had something she badly needed in her life, an ability to nurture and comfort, to offer a kind of reassurance that there might be solutions to even the most pressing problems. Norma decided right then and there and forever that she liked and trusted Sarah Weddington. Even when she was down, Norma had a natural vivaciousness that was not unlike Sarah's. As Norma told her story, she began to relish being the center of attention. Never had she so sympathetic an audience. It encouraged her to talk even more about what had happened to her. A few months earlier, during August of 1969, Norma had been traveling throughout the South at the carnival. Her job selling tickets to an animal sideshow was not exciting. But she loved the life. It was the people who attracted her to the carnival. These people were theater. They were even better than theater. These people were theater. Wait, I even said that. These exotic vagabonds who got paid for roaming the country and performing their various acts and tricks for delighted audiences. Norma liked this life more than any she had ever done. For one, she did not feel like an outsider, as she so often had with her family. The carnival felt like the kind of home she had been searching for and never found. Unlike her parents, her co-workers simply accepted her for what she was and asked few questions. She had even made a couple of special friends, 2 women with whom she shared a motel room. Norma told Linda and Sarah how she was selling tickets one sultry summer night, the last night of the carnival gig in a small town outside Augusta, Georgia, when some minor trouble broke out. She and several of her coworkers were harassed by a group of rough-looking, tough-talking young men. Since it was the kind of disruption that often rippled through a traveling show, it was no cause for alarm. Because this was the carnival's last night in town, the atmosphere was more festive than usual. And the women treated the men with good humor, even bantering with them a little bit. After the show closed that night, several hours' work remained to be done. Taking down the big tents, packing them away so the show could leave the next morning. As a result, Norma and her roommates decided to walk back to their motel rather than wait for their usual ride. It was during that walk back to the hotel with her friends, Norma recalled, that real trouble broke out. On the way back to her room, she told Weddington and Coffee she was raped. Norma could remember few details of what had happened to her. She thought that she had lain by the side of the road for several hours. The rest of the evening passed in a haze. When Weddington gently probed for more, Norma's story became confused and vague. She thought the rapist may have been one of the men who had disrupted the circus earlier in the evening. What had happened to the women who were with her? Sarah asked. Norma said she did not know. She only knew that when she managed to rouse herself, she was alone. She stumbled back to her motel room, only to find it empty. Her roommates had vanished, taking her belongings with them. She did not report the rape to anyone, nor did she talk to or even see anyone in the hours immediately following the rape. She crawled into bed. When she awakened in the motel room the next day, Norma was still alone. The circus had left town without her, and in the course of doing so, had left her with no money, no way to even pay for the motel for another night. The defeated Norma decided she would return to Dallas, where her family and friends lived. She knew no one in Augusta, Georgia, whom she could ask for help. Norma telephoned an old friend in Dallas to ask her to send enough money for the bus trip home. To her chagrin, the friend wired only the exact amount of the bus fare. Norma sold the taxi driver the radio from her motel to pay for her fare to the bus station. The trip back seemed endless. Norma said, particularly since she had no money to buy food and thought she had changed buses several times. Upon her return to Dallas, Norma found her way to her friend's mobile home, crawled into bed again, and slept for 2 days. When she awoke, feeling only slightly better, her friend helped her get a job as a waitress in a bar. That was what she was doing when she began to realize she was pregnant. Norma told the two women about her search for an abortionist. She knew that she did not want to have this child. She did not know the father. She had no way to support a child, and no home and little income. She was not even managing to rear her daughter, who was living with her mother and her stepfather in Arkansas. Her life was a mess. She had no idea when or how she would pull it together. She asked the physician who had told her she was pregnant about an abortion. In 1969, abortion was illegal in Texas. Asking a licensed physician for help getting one generated any number of responses. A few recoiled in horror at any patient who even suggested they perform an illegal surgery. Some lectured their patients about their lack of maternal feeling and their selfishness for not wanting a child, any child, regardless of the circumstances under which it was conceived. Most reassured their patients that once the baby was born, all doubts would vanish, and the maternal instinct would take over, a line of reasoning they borrowed from the leading obstetrical texts of the day. A few brave physicians tried to help their patients, often endangering their careers to do so. One Texas woman recalled the type of cautious help she received when she asked her family doctor about an abortion. He opened the phone book and had her run her finger down several columns of physicians' names, telling her that she was hot, then cold, then hot again, there, no, not there, but there, until finally her finger rested on the precious number of someone who would perform an illegal abortion on her. If a woman were really lucky, her doctor wrote out a name on a piece of paper and handed it to her. A name that came through a doctor was considered especially valuable because the assumption could be made that the abortionist, if not a licensed physician, would at least be competent, or a physician would not be recommending him. If a woman were unlucky, her physician declined to help in any way, and she had to embark on her own search for an illegal abortionist. Norma was not one of the lucky ones. Her physician curtly informed her that abortion was illegal in Texas and suggested that she travel to where laws were more liberal. In 1967, abortion was legal in Colorado and California, 2 nearby states, as well as Georgia, but even the new so-called liberal laws have restrictions, such as residency and time requirements that would have made attaining legal abortion difficult for Norma. Texas women frequently went to Mexico to obtain illegal abortions in the numerous clinics operated for that very purpose. But Norma had heard about those, especially the cheap ones, and did not want any part of them. Besides, she barely had car fare home from her doctor's office, let alone the money to travel anywhere to get an abortion. It seemed her only alternative was an illegal abortion in Texas. She hoped she could find someone skilled enough to do the surgery. Norma spent the next few weeks in a futile search for an abortionist. She talked to a few women she knew, hoping one of them would give her the name of someone who could help. She learned that a competent abortion, even an illegal one, costs a lot of money. The kind that could be bought for $50 or $100 was not, in Norma's opinion, worth risking. Gradually, over several weeks, she began to consider the only other option she could think of, which was adoption. She returned to her physician for help. He gave her the name of a young lawyer, Henry McCloskey, who sometimes arranged private adoptions. Norma called McCloskey, and he agreed to meet with her. McCloskey turned out to be a kind of man who took time to listen to Norma and get to know her. She told him that she really wanted an abortion, but since she could not afford one, she really had no choice but to have her child and put it up for adoption. Without telling her why, McCloskey asked Norma to meet with another lawyer. He promised Norma that she could return to him if the other lawyer was not helpful. That was how Norma had met Linda Coffey, and why she was sitting in a restaurant recounting her story for Coffey and Weddington. Now it was time for Coffey and Weddington to tell Corby what she could do for them. They told her that they were looking for a woman to be a plaintiff in an abortion suit. They asked Norma if she were aware that many people wanted to change the abortion laws. Norma was not alone in her attempts to obtain an illegal abortion, nor was she alone in her failure to get one. Many women who needed abortions found themselves unable to obtain one and were forced into a legal one. Because abortion was illegal, no one knew for sure how many women terminated their pregnancies. But one study found that the women surveyed ended between 1/5 and 1/4 of all their pregnancies. Only 8,000 to 10,000 legal abortions were done each year in the United States, while experts guess that between 1 million and 1.5 million abortions were done annually. Women who got illegal abortions took much greater risk than those who were able to obtain legal ones. Some women got competent illegal abortionists, Weddington said, but many suffered at the hands of uncaring, unscrupulous, illegal practitioners. While she was looking for someone to perform an abortion, Corby told the two women she had heard many horror stories about what happened if a woman went to the wrong kind of abortionist. That was why she had not been able to go through with the surgery. No licensed doctor would agree to perform the operation, and although one abortionist had offered to do it for $500, he did not have a medical license, and she was afraid to let him touch her. Weddington asked Norma how she had felt when she could not get an abortion. Norma replied that she was angry at being forced to have a child whom she did not want and could not care for. Sarah said that she and Coffey were angry too, and that they wanted to help women in her plight. That was why they needed her help. Weddington and Coffey's motivation in taking on the Texas abortion was, I discovered somewhat to my surprise, primarily ideological. On one of my visits to Texas, I asked the two women why they had decided to work on abortion reform as opposed to any number of other women's issues. Neither woman had undergone an abortion nor had any first-hand experience with one. Like so many other women their age, they had known or heard of women who had undergone illegal abortions, but abortion had not touched either woman in a close, personal way. But like many women, although their interest was impersonal and somewhat abstract, They were angry, as they told Norma. They wanted to help women, and since they had legal skills, something few women could claim at that time, they thought they could use them to do something about the present restrictive laws. Each woman told me separately, and in remarkably similar words, how attuned she was to the rapid changes occurring in women's lives. The idea of abortion liberalization was in the air from the mid-1960s on, and the two women thought they could do something, at least about the Texas law. Norma knew nothing about the legal system. She had no idea what a plaintiff was, and consequently was not sure what she was being asked to do. Coffey and Weddington told her they were planning to challenge the abortion law of the state of Texas. They could not do this, they explained, simply by going into a court and asking a judge to overturn the law. Instead, they had to bring a suit, in this instance, obviously, a suit involving a pregnant woman, into court. The pregnant woman, not Coffey or Weddington, would actually sue the state of Texas. Because she was the person filing the formal complaint, she was considered the plaintiff. After the suit was filed, there would be a trial or a hearing, perhaps several hearings. Norma might have to be present, she might even have to testify. Sarah and Linda assured her, however, that they would do most of the talking in the courtroom. A judge would then weigh the facts of the suit and use them to decide whether or not to permit the plaintiffs to have an abortion. If a Texas judge ruled that one woman could undergo an abortion, then all the women in Texas in similar circumstances would be entitled to one. Coffey and Weddington wanted to build a broad enough case so that any Texas woman who wanted an abortion would be able to get one as a result of the ruling they hoped to obtain. They hoped that their case would result in a clear-cut rejection of the Texas abortion law. It would not be easy to build such a case, and the risks were high, they knew. Once they went into court, the judge could decide in their favor, ruling that the Texas abortion law was illegal. He could decide to strike only certain parts, but not all of the law, or, worst of all, from their point of view, a judge could decide that no part of the law was illegal and, in effect, let the law stand as it was. In that event, women would not be allowed to have abortions, and it would be difficult for anyone else to challenge the Texas abortion law after a recent ruling supporting its legality. It was this last instance, a decision that the law was acceptable as it was written, that Coffey and Weddington wanted to avoid at all costs. That would be a serious setback for the abortion reform movement beginning to take shape all over the country. Many people favored liberalizing the strict abortion laws, but a number of institutions and persons had no intention of letting that happen. Coffey and Weddington did not prepare their case well, and if as a result a judge ruled that the Texas abortion law was legal, it would be a victory for the anti-abortion forces. Sarah told Norma that she thought this would be a very important case, not only for Texas women, but for women everywhere. It might even go to the Supreme Court. Even though Norma was still unsure what Sarah was talking about or what court she had in mind, she was impressed. The two lawyers told Norma they thought she might make a good plaintiff for their suit, although they would not make a decision right away and suggested she take some time to think over what they would need her to do. They wanted to know whether she was interested. Norma was immediately enthusiastic. The two women had affected her, not least because of the way they treated her, as if she were an important person to them. Norma wanted to help Coffey and Weddington if she could, to be a part of this case they were talking about. She agreed on the spot to be their plaintiff. Pleased as they were with the offer, Coffey and Weddington felt they could not in good conscience let Norma become their plaintiff until she had been given a chance to think things over. They also wanted her to talk some more to make sure she knew exactly what she was getting into. As a woman who felt deeply for Norma's plight, Weddington and Coffey wanted nothing less than a fully informed client. We're headed to the end of this chapter. Coffey and Weddington also had to be sure that Norma was the right plaintiff for their job, and that would take some thinking and discussion on their part. The evening ended with the women agreeing that they would each go home and think about what had been discussed. Coffey and Weddington said they would need to meet a few more times with Norma before any final decision could be reached. They promised they would be in touch with her. I'm about to yield the floor to my fellow woman filibusterer. But before I go, I do want to say that unfortunately the Missouri Senate took action on the bill that we are trying to filibuster tonight, the one that would mandate a triple in the delay for a woman seeking abortion in Missouri. It would have dire consequences for women like we're reading about today. We don't want to go back to the days that Norma McCorvey lived in and struggled in with her reproductive choices. It looks as though the bill may advance through the House and end up on the governor's desk, and we urge all legislators, the members of the House, the governor, to stop this bill and protect women. So with that, I yield to my colleague, and thank you so much. Here's your... Thank you. You can watch your stuff right there.
My name is Sue Gibson. I'll continue to read from Roe v. Wade, the untold story of the landmark Supreme Court decision that made abortion legal, by Marian Foe. Chapter 2, Finding Jane Roe. Coffey and Weddington were excited, more so than they had let on in McCorvey's presence, about her potential as a plaintiff. Still, they could not afford to let their desire to get an abortion case underway interfere with their choice of a plaintiff, especially since both women knew that this would be no run-of-the-mill lawsuit. More than anything else, this perception would guide them in their selection of a plaintiff and would ultimately lead them to the realization that their personal desire to be the lawyers who successfully challenged the Texas abortion law, or their fire to find a plaintiff and get a case, any case, underway was less important than the overall goal of overturning the Texas abortion law. A case like this was not intended to benefit one person, but the hundreds of thousands and even millions of Americans whose lives would be affected by a change in the abortion laws.
You can keep going.
To the extent that it was possible to do so, they wanted to choose a plaintiff who would be helpful to them in achieving the larger goal. It was not necessarily an easy task. For one thing, they would need to exercise more control over the plaintiff than they would in another kind of suit. They would use her, if necessary, in and out of the courtroom to build their case. If they wanted to build public sympathy for the case, for example, they might leak all or part of her story to the press. Conversely, they might want to avoid publicity. Some judges forbade participants in a lawsuit to talk to the press, and in a situation like this, when a gag order was imposed, they would have to be able to prevent their client from talking. For another thing, if it would help, they would want their plaintiff present in the courtroom during the proceedings, an event that would almost certainly destroy any anonymity she had. Her presence might even be required by the court. Alternately, they might even try to play down her role in hopes that she would be seen as a sort of every woman, a symbol of the need to reform the abortion laws. Either way, their plaintiff would have to be under their control. Would McCorvey, they asked themselves, submit to their guidance in matters like these? Yet such considerations were just theoretical possibilities that might or might not occur in the course of the lawsuit. The most pressing practical issue, Coffey would recall in our conversations, was whether they could actually help Norma get the abortion she wanted. Just possibly, they could arrange for her to obtain a court-sanctioned one, but chances were far greater that they would not be able to do so. The wheels of justice did not turn rapidly. By the time the legal system was through chewing on the wisdom of whether to allow her to have an abortion, Norma would most likely have had her baby. Norma had looked pregnant to Linda Coffey since their first meeting. It seemed to Coffey that she was pushing, if not into her second trimester. This meant that if Norma were to undergo an abortion, she should do so right away, probably within the next 2 or 3 weeks. The only way the two lawyers could see to act quickly enough was to file a request for a restraining order. A restraining order, always temporary in nature, and thus often referred to as a temporary restraining order, or TRO, could be granted without a hearing, although one would be held later to determine what relief was appropriate. Such an order would prevent officials from enforcing the abortion law, and in theory at least, would then leave the physicians in Texas free to perform abortions. TROs, however, were basically designed to protect the status quo, and in this case, the status quo dictated that abortion was illegal. It was unlikely that any judge would order an abortion to be performed without first examining the constitutionality of the Texas abortion law. Furthermore, although this was something they had yet to research, Weddington and Coffey thought that they could take their case into a federal court, that this was the proper forum for challenging a state law. It offered the possibility of a more encompassing decision, one that could set a precedent for decisions outside Texas. But it also made their case more difficult. The federal courts, ever wary of states' rights issues, were being ultra cautious, largely because of some recent rulings involving criminal cases in which they were perceived, at least by some, as having overstepped their power to rule on state laws. In fact, there was every reason to believe that a federal judge would be even more reluctant than a local or state judge to issue a restraining order that would overturn a state criminal law. Apart from all these considerations, even if they did find a judge willing to issue a TRO, they would still have to find a physician willing to do the abortion. That they suspected would be an impossible task as long as the law was still in limbo and the physician might risk later prosecution. The first and most difficult decision the two lawyers made then was not to seek a TRO for Norma, even though that was her only chance for getting court permission in time to have a legal abortion. Since she wanted an abortion badly, this might mean she was not the best plaintiff for them after all. They needed to impress upon her exactly what this meant, namely, that she would most likely have to go ahead and have the baby if she became their plaintiff. As the two lawyers met with Norma several times over the next few weeks and learned more about her, another potential problem emerged. Coffey and Weddington began to understand better something they had suspected from their very first meeting with Norma, namely that their potential plaintiff had a past and a present life that would not withstand much scrutiny. Norma grew up in an unstable family. Her father was a military career man, and the family moved every 2 or 3 years. The frequent moves made school difficult for Norma, and she had never done well. Even after her father left the Army when she was still in school and settled in Dallas, where he worked as an electrician, life did not become any easier for Norma or her only sibling, a younger brother. Between the two of them, Norma told the interviewer, her brother was a punko and she was a freako. Her home life was trying. Her parents' marriage was on the skids, aggravated by her father's drinking problem. From an early age, Norma was a child who had nowhere to go. She avoided home because she could not stand listening to the drunken arguments of her parents, and she avoided school because she had been labeled a troublemaker and was often in trouble with the juvenile authorities. Norma recalled the shock of coming home from school one day to learn out of the blue, as far as she was concerned, that her parents were divorcing. Her father had moved out. Once gone, he made no attempt to stay in touch with either Norma or her younger brother. She was now left with only her mother, with whom she had never gotten along. Later, Norma would always recall her mother as a cold, domineering woman who never gave her credit for doing anything right. With so hostile an environment at home, nothing went right at school either, and she soon dropped out of high school in the 10th grade and went to work at the only job she could find, a car hop in a drive-in restaurant. At the drive-in, she met and began dating a 20-year-old drifter who had dreams of glory. An aspiring rock singer, he promised Norma that he could build a better life for both of them in Los Angeles. Since she was still 16, Norma needed her parents' consent to get married. Happy to have her out of the house, her mother agreed, and Norma married her would-be rock star and moved to Los Angeles with him. Their new life did not go well from the beginning. Her husband could not find work, and Norma soon found herself pregnant. When she told her husband the news, he beat her. She waited until he fell asleep that night, gathered her clothes and the few dollars she had saved, and bought herself a bus ticket back to Dallas. The period right before and after her baby was born was one of the lowest times of her life. At first, Norma's mother suggested that Norma put her child up for adoption, but gradually she softened and let Norma live with her. Norma tried to go back to high school after the baby was born, but she felt too out of place, in her own words. Like a pool cue in a china cabinet, like a big idiot. She walked away from that. After her baby, a little girl, was born, she worked at a string of jobs, mostly waiting tables in bars at night. Norma's relations with her mother, never good, worsened after the baby was born. Norma's mother constantly undermined Norma's ability to care for her new little daughter. Norma recalls having been awakened by her mother from a sound sleep, and while still groggy, being forced to sign some papers that she believed gave her mother custody of her infant daughter. Shortly after that, her mother and stepfather moved to Arkansas, taking the child with them. Norma missed her daughter terribly, but had no money to visit her and did not know what she could do to regain custody. Moreover, she could not support a child on what she earned, nor could she care for a child properly with her unsettled life. Left alone in Dallas, Norma maintained occasional contact with her father, although she was always the one to call him. Norma remembered those years as ones in which she struggled simply to make it through each day. She suffered from severe bouts of depression and would later recall, "It seemed like there wasn't anything to live for. Everything I did or said was wrong. I just wanted to vanish." Vanish she did, in a sense, during the summer of 1969. She had gotten together enough money to visit her mother and daughter in Arkansas. The visit was not going well. The two women fought constantly over the child, while the little girl watched and listened. Norma sensed she was losing her daughter to her mother, who had taught the child to call Norma Mama Big Sister. After a week of quarreling, when Norma thought she could not stand much more of her mother's house, but had no idea where she would go, a new acquaintance offered to drive her to a nearby town for the day. She readily accepted. The blocks around the town's courthouse were occupied by a small carnival. Norma hung around, struck up a conversation with some of the people who worked there, and learned that there was a job available as a ticket seller. She took it and moved out with the traveling show that night. She had worked with the carnival only a few weeks when she got into the trouble that resulted in her second pregnancy. After hearing so much about McCorvey's background, Sarah Weddington and Coffey became concerned that she might not be such a good plaintiff after all. Her life thus far, a high school dropout, married at 16, a daughter she did not have custody of, walking out on a visit with her daughter to join a carnival, her present hand-to-mouth existence was a major problem. Another problem was the rape. In our talks, both Weddington and Coffey recalled that it was a delicate issue. Sensitive as the two women were to any women's claim that she had been raped, a claim that was too often ignored or worse, challenged, they were also lawyers trained to size up a potential witness's credibility. And whatever had happened to Norma McCorvey, they did not feel that she would be a credible plaintiff in a rape case, let alone in an abortion case involving a rape. Coffey in particular was struck by McCorvey's lack of emotion when she described the rape at their first meeting. Some rape victims are stoic, even with the people who try to counsel or otherwise help them. But McCorvey's remarkably unemotional recounting of how she had been raped made her lawyer uneasy. McCorvey was vague about the circumstances of the rape, and her story became more unclear and the details more bizarre with each retelling. She told Coffey and Weddington she had not gone to the police or filed any kind of official report. Initially, she said she had been raped by one man. She later changed her story and claimed she had been gang raped, sometimes by several men and her female companions, sometimes by a white, black, and Hispanic man, a highly unlikely combination to have been walking together down a Georgia country road late at night in 1969. Weddington and Coffey wondered whether McCorvey had, in fact, been raped, but regardless of the circumstances, they were concerned that the rape not become an issue in their case. Rape victims did not fare well in court. Their lives were often subjected to excessive scrutiny. In fact, much more attention was typically focused on the character of the women who were raped than on the men who raped them. And women who pressed rape charges frequently had to prove that they had not in some way invited the rape. Beyond that, there was the problem of blame and punishment. However much rape, and for that matter abortion laws, appeared to be neutral, they were not. They were based, at least in part, on society's standards and expectations regarding sexual mores. Therefore, a woman who was perceived as having invited a rape was seen as having gotten what she deserved. And similarly, a woman who needed an abortion had better be prepared to prove that she deserved one. Such thinking made many movement lawyers cautious about whom they would take on as a plaintiff. Most abortion reform lawyers speculated that any woman who became a plaintiff in an abortion suit would be subject to the same kind of scrutiny as a rape victim, a reason they held to find a plaintiff whose life and character were as impeccable as possible. McCorvey's clearly were not. Although Coffey and Weddington spent hours thrashing out the pros and cons of using her as their plaintiff, the issues were simple. On the one hand, the more they learned about her background, especially her claim that she had been raped, the more worried they became. On the other hand, in a year of looking, they had not found anyone who was better. For a start, not many women existed who were pregnant and wanted an abortion and were willing to become involved in a lawsuit to change the abortion law. Coffey and Weddington had learned from experience that finding a plaintiff was an almost impossible task, not least because, as one New York abortion reformer noted sardonically, short of a virgin, there is no such thing as the perfect abortion plaintiff. Eager to get on with the business of challenging the Texas law, the two young lawyers were inclined to take their chances with someone who was less than perfect. Their problem with McCorvey's claim that she had been raped receded once they realized there were other reasons not to assign the rape any role in the case. Like any lawyer working on abortion reform, they hoped to obtain as broad a ruling on an abortion as possible. They did not want a court to rule that women were entitled to an abortion when a pregnancy resulted from rape or incest, and this, they realized, was a distinct possibility, since current Texas law permitted abortion only to save a woman's life, not in cases of rape or incest. No one had ever challenged the law on these grounds, and Coffey and Weddington had no intention of being the first to do so. So narrow a ruling would be a waste of time. As a result, they decided that if McCorvey did become their plaintiff, they would do everything possible to keep the rape from becoming an issue in the case. They reasoned this would not be hard to do, since there were no police reports or witnesses or any other records to attest to the rape. Ironically, had Norma decided to pursue an abortion in Georgia, the state in which she was living when she claimed she was raped, she would have been legally entitled to one. Georgia's reform-style law, passed in 1968, permitted abortions in cases of statutory and forcible rape, but not for incest. Norma would have had great difficulty, however, obtaining an abortion in Georgia. Although intended to liberalize abortion, most of the reform laws were now even more complicated than they had been in the past. Under the new reform law in Georgia, for example, Norma would have had to reside in the state for a specified period of time, and she would have needed the approval of 2 physician consultants and the hospital's therapeutic board, also composed of 3 physicians. Lawyers were already mounting a challenge to this complex reform law. Once Coffey and Weddington decided they wanted to keep any mention of the rape out of the case, they had to figure out how best to do this. This, Weddington said, they accomplished by by making sure that no references to the rape appeared anywhere in the court papers. They had no qualms about doing this, no sense that they were manipulating their client's story or interests. The idea of not mentioning the rape also appealed to them on another level. Just as they did not want the case decided on narrow grounds, neither did they want the record to contain anything that might later be subject to a legal challenge. Their aim of compiling a flawless court record, one that would be acceptable to any higher court and would also stand the test of time, was well served by omitting the rape. They did realize that some potential existed for an embarrassing and possibly damaging episode if McCorvey decided to talk to the press at some later date, or worse, if the press decided to ferret out her past. If she revealed her story, attempts would undoubtedly be made to verify the rape. While Coffey and Weddington strongly suspected that any such investigation would not pan out, they recognized that the disclosure alone could result in a damaging contradiction between the official court record and McCorvey's version of what had happened. As they discussed this potential scenario for disaster, they found yet another cause for relief in their decision not to mention the rape. Without a reference to it in the court papers, the rape would never become a legal issue. Mostly, they hoped to be able to keep the press and their client far apart. Apart from any legal considerations, they recognized that if the case did catch the media's attention, they might also have to contend with the opponents of liberalization, who would make political hay of the fact that Norma McCorvey was not the most stable personality. Fortunately, there was no crime in that, and particularly if a decision had already been rendered, her personality and lifestyle would not be grounds for any legal action to overturn the case. The second time the 3 women met, the lawyers explained to McCorvey that in all likelihood, she would have to go ahead and have her baby if she became their plaintiff. They told her there was almost no chance that a court would decide her case in time for her to get an abortion, and that possibly the law would not be overturned at all. Coffee and Weddington offered to help Norma get an abortion if she wanted one. They felt honor-bound to do so. There was a slight chance that they could still use her as a plaintiff even if she got one. Coffee thought they could perhaps build a case around the argument that their client had been forced into a dangerous, possibly septic and illegal act, and that it was a violation of her, and by implication other women's, civil rights to put her in this position. Both women knew, however, that they were far more likely not to use Norma as their plaintiff if she got an abortion. They would probably go looking again for a pregnant woman who would be willing to be their plaintiff. Norma turned down their offer and agreed to go ahead and have the child. Although Weddington would recall that her motives for doing so had been largely altruistic, her decision was also undoubtedly motivated, at least in part, by the simple fact that 4 months into her pregnancy, she was not likely to get an abortion anyway. After 3 months, abortion was done by a mini cesarean section and was considered major surgery. Rarely could a legal hospital abortion be arranged at that stage, and illegal abortionists never risk this kind of surgery. In another 15 years, the technology would be developed to make late abortions safe, but in 1969, it did not yet exist. The next thing Coffey and Weddington brought up with Norma was how long the case might take, months or even years if it were appealed. Although the legal maneuverings would be complicated and difficult for any layperson to understand, they promised they would do their best to keep her informed throughout the case. Finally, the three women discussed the publicity that would quite likely ensue from the case. Abortion was rapidly becoming a hot topic with the media, and hardly a week went by without another newspaper series, editorial, or nationwide poll pointing out the mounting pressure for reform. Although the subject had been taboo only 2 or 3 years ago, women's magazines now wrote regularly about abortion, usually touting reform. Weddington and Coffey suspected that a torrent of publicity would begin once the press got wind of their suit. With it, they feared, might also come some harassment of their client, or at a minimum, the loss of her privacy. The latter would be more overwhelmingly intrusive than she might imagine, they warned. They could try to protect her from it, but might not be able to do so. If the court insisted that she appear or testify, they would not be able to keep the press from identifying her and delving into her background. The press would be eager to interview her. She would, they warned, become the human interest in an otherwise relatively dry legal case. Norma's fears about publicity had more to do with her family than anything else. Her father was a Jehovah's Witness, and her mother was nominally a Roman Catholic. While neither parent was particularly religious, she worried that they might have strong anti-abortion opinions. They had never expressed any feelings one way or the other about abortion, but then she had not told them she was trying to get one. On the one hand, Norma was acutely aware that very little she had done in life had met with her parents' approval, especially her mother's. Her mother had shown no sympathy or inclination to help when she learned that Norma was pregnant and homeless the first time, and she was hardly likely to take a more generous view of her daughter's situation now, especially if it were reported in the local newspapers. On the other hand, although Norma was a rebel, like most youthful renegades, what she really wanted from those she railed against was acceptance. Just possibly the case might give her some of that. Certainly the fact that she knew 2 women like Linda Coffey and Sarah Weddington would impress her mother, and that she was a plaintiff in so important a case might also carry some weight. Ultimately, Norma decided to go ahead with the lawsuit, but indicated she wanted as little publicity as possible. She specifically did not want her parents or her daughter to know of her role in the case, nor would she tell her friends. When Coffey and Weddington suggested the use of a pseudonym, she readily agreed. It would at least offer her some protection. They quickly settled on Jane Roe. Coffey and Weddington would prove to be quite successful at protecting their clients' privacy. Over the years, reporters would occasionally try to discover Jane Roe's identity, usually on important anniversaries of the case. Her lawyers grew so used to her refusals to grant interviews that they no longer called her with requests. For 10 years, until Norma herself broke the silence, no one, not even other lawyers who would work on the case, knew who Jane Roe was. When McCorvey broke her silence in the early 1980s, she talked only to a handful of reporters and writers before engaging the services of an entertainment lawyer in Dallas. After that, she would only agree to be interviewed if she were paid. As a result, she was never interviewed for this book. Coffey and Weddington had only one last concern to bring up with McCorvey before settling on her as her plaintiff, and that was whether she would be able to go the whole way with them. After having come so far, they could not bear the thought of putting in months of work on the case only to have their plaintiff get cold feet and ask them to drop the suit. They talked to Norma about this too, until both women were convinced she could stay with them. From their first meeting with Norma, Coffey and Weddington had been impressed with her enthusiasm and spunk, as well as her desire to help other women who were in the same situation. Through all their discussions, Norma never wavered from her willingness to proceed. In our conversations, Weddington would recall that Norma seemed to have some sense of the historic proportions of the case. The three women agreed that it was settled. Norma McCorvey would become their plaintiff. A challenge to the Texas abortion law, which had stood inviolate for over 100 years, was underway. Chapter 3, Two Women in Search of a Case. The forces that drew Sister.
Will you yield?
I will yield. Yes.
Chapter 3, Two Women in Search of a Case. The forces that drew Sarah Weddington and Linda Coffey together to challenge the Texas abortion laws were not entirely the result of fate. These two young lawyers came of age during the 60s, eager to try out their new law degrees and test their ideologies, could just as easily have thrown their energies into the civil rights movement. That was the area for someone with a finely honed social conscience. And it did not hurt that, with a little good luck and timing, careers could easily be made. The newly emerging women's rights movement, by contrast, was not a proven career maker, nor did it have, the caveat of working in civil rights. Women's rights, however, were accessible to women, which is more than one could say for most other areas of the law. At least in part, Weddington's and Coffey's involvement in women's issues and ultimately with abortion came about because of the doors that were still closed to them in other areas. Their interest in women's rights paralleled that of hundreds of thousands of other young, mostly college-educated women during the 1960s. Feminism was emerging as an important social issue for the second time in 100 years. The first organized attempt at achieving women's equality took shape after the Civil War, when a group of mostly elite, middle, and upper-class women who had worked in the abolitionist movement and had seen parallels between the plights of women and blacks began to press for greater equality for women. The women's suffrage movement eventually focused on, and in 1920 succeeded in winning, the right to vote. However, the suffragettes had tied their cause to the role as mothers. They argued that women would be better mothers worthy of greater respect if they could vote. It was essentially a conservative doctrine. After their victory, feminism entered a dormant era, undoubtedly because women believed that winning the vote, they had gained more than they actually had. For obvious reasons, women's reproductive rights had not become an issue during the first wave of feminism, nor would it become one until the early part of the 20th century, at which point Americans became involved in an extended public debate over birth control. The debate arose in the first decade of the new century among socialists and anarchists and was promoted by political radicals such as Emma Goldman and Moses Harman. Socialists were not, however, particularly concerned with women's rights, preferring to focus on whether the working class would fare better or worse by limiting its size. Despite its radical origins, this debate touched a nerve throughout society, and the birth control movement, not yet named that, was spawned. When Margaret Sanger rose from the radical ranks to ride the crest of the new movement and to convert birth control, an expression she coined, into a less radical, single-issue cause, she found herself at odds with the suffragists, who were politically conservative and feared that contraception, by any name, would destroy family life. Although much was accomplished in the birth control movement, for the second time, a cause involving women's lives had failed to engender any real discussion of women's rights to control their reproduction. Not until 1963, when the first magazine excerpts of Betty Friedan's The Feminine Mystique rocked the female consciousness, did women begin to examine the relationship between reproduction and equality. The impact of Friedan's book on women's lives was astonishing. In response to requests from women for help, Betty Friedan founded the National Organization for Women, NOW, and in a stroke of genius for the building organization and the movement, NOW began to encourage women to form something called consciousness-raising groups, intimate support groups in which women could meet and discuss their mutual concerns. The groups were not only attractive to the converted, they were also an excellent way of recruiting women to their own movement. Throughout the late 1960s, following an agenda established by NOW, women began meeting in small informal groups all over the country to discuss such topics as marriage, careers, motherhood, and sexuality. Women who participated in those groups recall that discussions about sexuality inevitably worked their way around to abortion, something rarely discussed publicly before. Until the late 60s, a woman who underwent an abortion often told no one, not her best friend, not her sister, and sometimes not even her husband, about her choice. Once an abortion was over, most women tried to put it behind them, tried to never think about it again. Abortion was a painful, lonely, and with its imposed secrecy, sometimes guilt-producing event in a woman's life. Now, perhaps for the first time, women began to share the pain they felt over the decision to abort, as well as the problems of being unable to control one's fertility as well as one might like. They shared their common experiences with abortion, the desperate attempts to raise money, the trip, often alone, to nearby city, the experience at the hands of an illegal abortionist. They talked about the abortions that went smoothly, their surprise at discovering that abortion was really minor surgery, their shock and relief at learning that their family doctor would help them, perhaps even perform the surgery himself. Their surprise in finding out that an illegal abortionist ran what amounted to a storefront clinic and employed the most up-to-date surgical techniques. And they spoke, in hushed tones, about the bad parts. The fears that they might be maimed or injured and left to die in a strange place, the unsanitary conditions, and the risk of infection. The concession and insults, or condescension and insults, even the occasional rape. For the most part, it was enough just to be able to talk about abortion after all those years of societal imposed silence. Actions could come later, and it would, of course, because those meetings, with their shared intensity, planted the seed of reform. Like so many other women of their generation, Coffee and Weddington were swept up in the women's movement. In law school, each woman joined a consciousness-raising group. Although they had no way of knowing it then, they would soon have more reason than most women their age to become involved in the women's movement. Weddington and Coffee were two of the 5 women in the freshman law class of 1965 at the University of Texas. They were the only 2 who were planning to practice law. The rest were married and had decided to postpone law careers to start families. It was just as well, as Coffee and Weddington would discover, since obtaining a law degree in 1969 was no guarantee that a woman would be able to practice law. The ideas of attending law school did not dawn on either woman until both were almost through undergraduate school. Few women planned to have any kind of a career at that time, and there were many stumbling blocks even for those ambitious enough to want one. Coffee was finishing undergraduate school at Rice when she began to weigh what she would do next. She knew only that she wanted to have a serious career. No one she knew encouraged or discouraged her when she began to look into law school. The law seemed like a good enough choice for her because she thought she had an orderly, logical mind. Her parents supported her choice only to the extent of telling her they preferred law to teaching. Coffee's father was a research chemist, and her mother had worked off and on as a judge's secretary, so the idea of a professional daughter probably appealed to them. Coffee was born in Houston, but moved to Texas when she was a small child. Having rarely been outside Texas, she felt most comfortable there and decided to apply to the University of Texas. When she was accepted, she felt pleased but not surprised. Her undergraduate record was excellent. Despite the fact that she was readily accepted, her parents proved to be less than eager to pay for advanced education. They offered a little financial support during her first year of law school. That and a loan from an aunt guaranteed that she would be able to devote her energies to her courses. Student loans paid the way with her second year. By the 3rd year, Coffee was doing well enough to support herself while she attended school full-time. Weddington, the daughter of a Methodist minister and a teacher, basked in the attention she received as a child from her father's congregations. She soon learned what pleased the adults: a smiling face, a willingness to help when needed, and a drive to do the best wherever she tried. Despite frequent moves throughout her childhood, she lived in Dallas while her father finished seminary, where he taught religion, in Wiley, where he tended his first congregation, and in Mundane, Canyon, and Vernon. Her school record was excellent, and she would always be proud of it. After skipping 6th grade and a year of high school, she went off to McMurray College, a small Methodist church school, from which she graduated at age 19 in 1965. In interviews, Weddington speaks more often of her mother than her father, always referring to her as an educator, never a housewife. She was proud of the fact that her mother completed a master's degree in education while she was in high school, and liked to recall that her mother and a friend of her mother's encouraged her to go to law school. Her father appears to be a more distant figure, but it was from him that she derived much of her image of herself. Long after she had seen something of the world and accomplished many things on her own, the fact that she was a minister's daughter still provided a frame of reference for much of what she saw and did. As a child, Weddington rarely traveled outside Texas, and then only to church meetings. People who knew her in her 20s recall her freshness and innocence. Her husband, Ron, whom she met in law school and married shortly after she graduated, was considered the outgoing social Weddington, while Sarah's natural reserve made her the quieter, less party-going type. Weddington's family could not afford to send her to law school, but hard work was nothing new to Sarah, who had held various jobs since junior high school. To support herself in law school, she worked as a records librarian for a hospital, an assistant house mother, and a freelance typist. She began to toy with the idea of graduate school as she was finishing undergraduate school. She wanted to get some kind of advanced degree and thought for a while that she might continue English, her undergraduate major. But while doing her student teaching, she realized that teaching held little reward for her. She did not feel that it offered as much of an opportunity to have an impact on people's lives as she wanted. More important, she disliked the fact that her success was so directly dependent upon others. She briefly considered medicine, but had not taken enough science courses to get into a good medical school. She began to think about law school. Her interest in politics undoubtedly provided an added incentive to study law. When she graduated from undergraduate school at McMurray College, her family was living in Vernon, Texas. Weddington's mother took her and her brother to see their representative in the state legislature, who, as a family friend, was delighted to help them both acquire jobs at the state capitol. Her brother became a page, and she worked as a clerk typist and legal proofer in the Department of the Texas Legislature. Even though the Texas legislature only met every other year for 4 months, life was intensely political in Texas, and especially in Austin, its capital city. Sarah took to the hustle and bustle that echoed through the halls of the elegant brownstone Victorian State House. And it was while working there that she began to seriously consider the idea of a law degree. At that time, most law schools still admitted people with a variety of undergraduate degrees, including liberal arts, and the University of Texas automatically admitted anyone above a certain grade point average. Weddington had always been an excellent student. She decided to apply to the University of Texas Law School. During Weddington's admission interview, the dean of the law school tried to discourage her by emphasizing how difficult his son was finding the law school. Typically, Weddington was merely spurred on by the dean's words. Being redheaded, I rose to the challenge, and I decided I was sure I was going to law school. Weddington would later recall of her decision, I think in some ways I just never questioned that I couldn't do it. I always made excellent grades. I can't remember worrying about whether I could make it through law school. I just figured if I wanted to, I could do it. Do it she did. Weddington graduated from the University of Texas Law School in 1967. At the tender age of 21, she had spent a record 27 months in law school and had supported herself the entire time. She would later note, ruefully, that she was so frugal she managed to save money while paying her own way. Neither Coffey nor Weddington found law school difficult, and that only made them even more unprepared for what awaited them upon graduation. They soon discovered that while they might be, in theory, valued commodities as lawyers, they were nowhere near as valuable as their male colleagues. Both women, ambitious for the same things as their male colleagues, told me how they had expected the major law firms to wine and dine them just as they did the men, after which several offers would be forthcoming. In the late 60s, employers in some parts of the country were actively seeking women to work for them, if only as tokens of equal opportunity. The good old boys who dominated life in Texas, however, had not caught up with the rest of the country. Women were still an unwanted, mistrusted, and largely undesirable commodity in Texas boardrooms and law firms, except, of course, as secretaries. Coffey, who had been invited to join the law review in her senior year, although the honor came too late, and she was unable to accept it because of other time commitments, thought that working for a judge would put her in an even better stead for the corporate position she eventually hoped to land. She applied for and landed a highly coveted clerk's job on the prestigious Fifth Circuit, among the most active of the federal benches. With a bent for real estate and corporate law, she had assumed she would have no trouble joining a major Dallas firm after a year of clerking. To her surprise, her only offer came from a small firm in Dallas that specialized in bankruptcy law. Although bankruptcy's star had since ascended in the late 1960s, it was not an area of the law that bright, eager young law school graduates were burning to get into. If anything, it was looked upon as something only slightly removed from ambulance chasing. Coffey was offered the position with Palmer & Palmer, a small corporate firm, not so much because of her stellar record, but because the firm needed to hire a young lawyer, and she was one of the few willing to do bankruptcy law. Weddington was more confident than Coffey that she would be able to open the door to some important corporate firm. She rarely failed once she put her mind to something, and she took pride in her ability not only to be a team player, but also to play the game the way the coaches wanted it played. She was, and has for the most part remained, a corporate woman, attuned for achieving her goals by working within the system. To build up her resume, she had begun to work part-time with a law professor named John Sutton on a special project for the American Bar Association even before she graduated.
May I inquire what films there is?
Yes,
You yield?
I do.
Fantastic.
Right there.
Okay.
Just steal those things.
Yeah.
Thank you.
Weddington was thrilled to be the first woman in her class who was invited to fly to Dallas for an interview with a major law firm. Her hopes were shattered, however, when she realized that the firm had no intention of hiring her or any other woman. The partners, perhaps feeling some pressure to hire a woman, but clearly unwilling to do so, let the interview disintegrate into a discussion of why they could not hire her. One partner told her in all seriousness, as far as she could tell, that lawyers use foul language in conferences, language that might offend her. Worse, another lawyer commented the only way to train a clerk was to cuss him out occasionally. And they just would not feel comfortable doing that to someone as pretty and sweet as she apparently was. Besides, they noted, she had a husband. Wouldn't she need to be home to cook dinner for him? Lawyers, especially young lawyers, worked long hours. We know a little bit about long hours, don't we, women? How could she possibly work the hours a job with their firm would require and handle her obligations at home? The final problem with hiring her, as far as the partners were concerned, was that their wives had reservations about having them working with a professional woman. Secretaries were enough of a threat without adding attractive new law school graduates, women who would be colleagues. They were sure she would sympathize with their wives' thinking and perhaps even share it one day if she did not now. Before Weddington left the firm, she knew that an offer would not be forthcoming. Without the law firm job she had hoped to obtain, Sarah continued working for John Sutton on the ABA ethics project after she graduated. The job actually worked out well since her husband, whom she had met on a blind date her last year of law school and had married shortly after graduation, was still finishing law school. He was Sarah's age, but serving in the military had put him a year behind her. The job also gave her an opportunity to travel all over the country meeting other lawyers, some of whom would be invaluable contacts in her future work. It was during this period that she had developed a lifelong appetite for travel. The result of her 2.5 years of committee work was the Code of Professional Responsibility, a book that is still widely used by lawyers and state bar associations. Spurred by the big law firms, Weddington found herself even more interested than she might otherwise have been in the women's movement. She had joined Austin's first consciousness-raising group during law school and now became active in the National Organization for Women Now and Planned Parenthood. She also joined a group of Texas women who were trying to find women to run for public office. Had she joined a law firm, Weddington's feminist side might never have developed so fully. Like most junior members of such firms, she would have had little spare time for any kind of extracurricular activity. She would not have been encouraged to pursue anything related to the women's movement, which was viewed as a radical activity in Texas. If Sarah, a traditionalist to the core, had a radical feminist period, this was it. An acquaintance recalls her appearing at the many meetings that filled her life at that time wearing a black cape, fairly avant-garde garb in a state like Texas, where women were given to wearing pastel colors and dainty prints. Weddington's first involvement with abortion occurred when she was still living in Austin, and working for the Bar Association. A group of women who were loosely affiliated with the University of Texas, students and staff, approached her at a garage sale and asked if she would help them organize a problem pregnancy counseling service. She would later recall having jumped at the chance, not so much because it involved abortion, but because it gave her a chance to practice law. Pregnancy counseling services were springing up all over the country in emulation of the first bravely named New York group called the Clergy Consultation Service on Abortion. Formed in 1967 by the Reverend Howard Moody of the Judson Memorial Church, a longtime social activist, and 21 other Protestant and Jewish clergymen, CCS was a response to the growing concern over the millions of women who were forced into illegal abortions every year, many at great risk to themselves. The counseling services, which required no money or accepted only nominal fees, advised pregnant women about the choices open to them if they did not want to have a baby, and referred them to sources of help, either adoption agencies or abortion services. Most of the women who sought counseling, about 90% of the clergy consultation services cases, for example, chose abortion. The services were a brilliant and, in retrospect, rather flagrant form of civil rebellion. They advertised openly, making little attempt to hide what they were doing. Most practiced some circumspection, however, refusing, for example, to refer women to doctors over the telephone and insisting that the service did not provide abortion, only abortion counseling. In one or two states, a person who counseled abortion was considered an accomplice to the crime, but even where this was not the case, referral services obviously fell into an indeterminate gray area regarding their legality. Obviously, one of their goals was to subvert the abortion laws. The pioneering clergy-run services were especially successful, largely because law enforcement agencies were reluctant to take on clergy. Not so in the House of Missouri, or in the Missouri Senate last week. The clergymen, in turn, lent credibility to the abortion reform movement and made people see that abortion was an issue that could no longer be ignored. The New York services sent women to Puerto Rico, and when abortion became legal in England in 1968, to London. Sometimes women were sent to Eastern European countries and Scandinavia, where abortion was either legal or illegal, but accessible. Texas and California women were sent to the Mexican clinics that had been inspected and pre-approved by the people who ran the services. Even though abortion was illegal in Mexico, a Catholic country, the laws were ignored and abortion was easily obtained. In addition, illegal abortionists thrived in most towns in any size across the United States, and referral services used them if they were skilled and reputable. The organization also referred women to private physicians who were brave enough to do in-office abortions. The services were a response to the fact that illegal abortion was almost impossible to arrange. Only 8,000 to 10,000 were done each year. The services were a response to the fact that illegal abortion was almost impossible to arrange. Only 8,000 to 10,000 were done each year throughout the country, compared with 1 million to 1.5 million illegal abortion that experts such as Planned Parenthood and the National Committee on Maternal Health estimated were obtained each year. Illegal abortion could only be gotten through a physician who could, and frequently did, exercise his own personal judgment about which of his patients were entitled to one. And these were done in hospitals, which were reluctant to permit them. Even large metropolitan hospitals averaged only 25 to 35 a year. Hospital abortions were reserved primarily for the women with clout. Doctors' wives, the women whose husband had donated a wing to the hospital, wives and teenage daughters of families lucky enough to count a physician as a personal friend. To put it bluntly, to the extent that abortion was legally available, a rich, well-connected woman always had a better chance of getting one than did a poor woman with no connections. One doctor at a major Texas hospital summed up the prevailing philosophy among his colleagues. There are only so many times you're going to go to bat against the hospital administration that you'd like to save it for your regular patients. Poor women were another story entirely. As evidence of the discrimination against them, lawyer Harry Philpott, who was active in birth control and later abortion reform movement, testified before the New York State Assembly in 1967, when New York activists were trying to pass a reform law, that the ratio of abortions to live births for private patients in New York State was 1 to 250, whereas for ward service, it was 1 to 10,000. Most poor women lacked a network of friends and acquaintances who could direct them to the skilled local abortionist. And those who could find one frequently did not have funds to pay for his services, which ranged from $250 to $1,000. More often than not, poor women got the bad abortions. They became the bloody statistics, the heartrending stories plastered across the front pages of newspapers. By 1968, abortion was a relatively safe medical procedure, but it could and did turn foul when done on a dirty kitchen table with septic instruments by an unskilled abortionist. The counseling services that sprang up across the country in the late 1960s and early 1970s were as much as anything an attempt to provide abortion services to all women and not just the fortunate few who had the right connections. The Austin group that asked Weddington to work with them intended to run a straightforward referral and counseling service, and to this aim they had hoped that legal counsel would help them avoid any clashes with the law. Although willing to skirt the law, they were not seeking to challenge it openly. As Weddington worked with the group and learned more about abortion, she developed a desire to do even more than she was. One day she decided to get in touch with Linda Coffey, partly because she was the only other woman from her law school class who was practicing, but also because they were in law school together. They had occasionally talked to one another about women's lives and issues. She thought Coffey might be interested in helping her to do something about abortion. After her disappointment over not receiving an offer from a major law firm when she finished her clerkship, Coffey, like Weddington, had involved herself more deeply in feminist concerns. She had joined NOW and was also active in the Dallas-based feminist group called the Women's Equity Action League, WEAL, which worked for better employment opportunities for women. Unlike Weddington, Coffey was quick to call herself a feminist. She would later tell me that she was the only feminist lawyer in Dallas, and that she alone went out of her way to use the label at a time when most active professional women would not touch feminism with a 10-foot pole out of fear doing so would jeopardize their career. Although the two women had not been friends in college, they were now drawn together by their common interest in women's lives. They spent hours on the telephone and occasionally met in person. During this period, they compared their lives, sharing stories about the doors that had been closed to them professionally, and always thinking about what they could do to change things. Their discussion invariably returned to abortion and what could be done about it. Like many women, they were finally beginning to see, as Dubois had predicted, that women needed to be able to control their fertility to be free. And that abortion was one key to doing so. The idea that women could not control when and under what circumstances they would choose to reproduce struck them as unfair. The one thing that truly hindered women as they planned their careers. They began to talk about what specifically might be done to change the Texas abortion law. One possible means of change, a painstakingly slow one, was the state legislature. But that would require the cooperation of Texas state legislators, most of whom wanted nothing to do with livers causes, or even, for that matter, causes of women who were not livers. Besides, Weddington and Coffey had no political clout with the Texas state legislature, and in fact, they knew few women who did. It's a long time ago. It's starting to feel like it's about now. The court challenge was the other possibility, the one that seemed more viable. The courts, especially at the federal benches and the Supreme Court under Chief Justice Earl Warren, were the scene of most battles over civil rights legislation in the reform-oriented 1960s. In large part because they have proved to be the branch of government most receptive to social change. Oh, how times change. Of course, the court challenge could drag on too, as witnessed by the years of courtroom squabbling that have followed the Supreme Court decision ordering the desegregation of public schools. The city of Dallas had been embroiled in a suit to work out an acceptable desegregation plan for almost a decade. Coffee had experience with the judicial system, and that would be helpful. Another advantage to a court challenge was the element of surprise it would provide. Law enforcement officials would not be expecting a court challenge, so the state might not offer much opposition. All things considered, both women thought the courts were probably the way to go, in Texas at least. They decided they would each begin looking for a potential test case to take into court. In all their hours planning and speculating, the one thing that the two young, inexperienced lawyers never discussed or even considered was their boldness in planning to challenge a state law. This was because the idea of taking on state government, or even federal government for that matter, was not as unusual or difficult a task in the late 1960s as it has since become. In those heady days of civil rights activity, countless lawyers, many of them fresh out of law school and imbued with a sense of idealism, were hoping and praying to make their mark somewhere. At issue was not so much whether they would challenge the law, but which law they would challenge. Coffee and Weddington later admitted they were simply too young and inexperienced to understand fully what they were taking on. In one of her rare expansive moves, Coffee told me, "When you're young, you have high aspirations, and you do just what needs to be done." Just like what we're doing here over these 72 hours. The first order of business was to find a suitable plaintiff. Thinking that their best resources were the numerous feminist organizations they had joined, each woman stepped up her activities. Weddington in Austin, where she was still living at the time, and Coffee in Dallas. Both women made themselves available as speakers on the subject of abortion. They gave speeches intended to educate women on the need for abortion reform, but always, as they made the rounds of various women's groups, the more traditional volunteer groups, as well as the feminist ones, each was looking for a certain kind of woman, someone with the potential to become an abortion case plaintiff. It was also not unusual for a lawyer who was looking for a plaintiff in a test case to put out feelers among his or her colleagues to be on the lookout for someone suitable, and Coffee had done just that in Dallas. For a while, Weddington was hopeful that a plaintiff could be found among the women in the problem pregnancy counseling group. If not among the organizers, then among the women they counseled. She met several times with the abortion counseling group to discuss the possibility of developing a test case. She talked about what was needed to overturn the laws, how such a case would proceed, and of the demands that might be made of anyone who volunteered to become a plaintiff. Gradually, though, her hopes faded, at least for finding a plaintiff among the referral group. One problem was that most of the women who sought counseling knew they wanted an abortion. The sooner a woman underwent an abortion, the healthier it was for her, and few were willing or could justifiably be asked to risk the delay, even if a brief legal proceedings might entail. The other possibility was to use a member of the referral group who happened to be pregnant, even a woman who did not want an abortion, but was willing to claim that she did in order to press an abortion suit against the state. It certainly was not Weddington's first choice to use a kind of trumped-up defendant, but if no one else turned up, she realized that it might be her only option. That might be more humane in the long run anyway, since she knew that any suit she filed would most likely not be decided in time for the plaintiff to undergo an abortion. Still another thought was to file a class action suit against using the Austin referral group. The members were eager to help in any way they could, and so much so that when Weddington once asked if anyone in the group happened to be pregnant, Several voices chorused, "No, but that can be arranged." The problem with using the group was that at least one plaintiff had to be a representative of the class. In this case, that meant a pregnant woman desiring an abortion. Coffee, too, had begun to do more public speaking in Dallas in an attempt to find a plaintiff. One night, at a meeting of a feminist-oriented group, Coffee was approached by a couple who began to talk to her about her work in abortion reform. Eventually, the couple got around to suggesting that they might be willing to become plaintiffs in an abortion suit. The woman told Coffee that since 1968, she had suffered from a neurochemical condition that caused backaches and depression severe enough that her physician had suggested she not become pregnant for the time being. She had to stop using the pill, then the most reliable form of birth control, because it blurred her vision. 4 months after the onset of her physical problems, she had become pregnant. Apart from her illness, she and her husband did not feel as though they were ready for a child, so they decided on an abortion. Through an abortion counseling service, the woman had made arrangements to obtain an abortion at a clinic outside the United States. Despite using contraception, the couple were worried that the woman might become pregnant again. They could not afford another abortion if it meant traveling outside the country. In an interview they would later give to Barbara Richardson, a reporter from the Dallas Times-Herald, they shed more light on their willingness to become plaintiffs. Both felt a moral imperative to help legalize abortion. The husband added, "Our personal, moral, and ethical codes were outraged by the law." On the one hand, Coffee thought the couple would make excellent plaintiffs. They were impressive, young, married 2 years, both professionals with advanced degrees, church-going Methodists, active and involved in community life, and most important, they had an excellent reason for using abortion as a method of backup birth control. On the other hand, there were problems with using them, not the least of which would be the need to explain to the court why the woman's own physician had not done the abortion when she became pregnant. Coffee suspected that although the woman's physical condition was serious, it was not really so threatening that she could not bear a child. The biggest drawback to using the couple as plaintiffs was that their case was weak, legally speaking. Like most other states, Texas permitted abortion to save a woman's life, and the present law could easily be interpreted to have sufficient cover for their situation. Coffey believed the case would be thrown out of the court on the grounds that it involved no controversy. Such an evasive action would have particular appeal, Coffey feared, to a judge who was not eager to become involved in something as controversial as abortion. Despite several major disadvantages to using the couple, Coffey decided to go ahead and try and build a case around them anyway, largely because in several months of looking for a plaintiff, she had not found anyone else. Meanwhile, she would continue to search. The young couple were eager to protect their anonymity, so they agreed with Coffey to be known as John and Mary Doe. A few weeks later, Coffey thought she might have found not one, but several other plaintiffs on the local Unitarian Church's women's group. In Dallas, the Unitarians were viewed as being on the cutting edge of social reform, which meant that they were not merely liberal, but active in liberal causes. Their interest in abortion had grown out of a national annual meeting in which abortion had been the topic several years earlier. One member of the group had returned to Dallas with a sense of urgency about the need to reform abortion laws. Some urged the group to study abortion, which they did. Some of the women heard Coffey speak elsewhere on the subject of abortion reform and wanted her to address their group and tell them what they might be doing to promote liberalization of abortion laws. The night she spoke, Coffey talked at length about the case she hoped to develop with the Does as plaintiffs. She had come to the meeting with a vivacious, dark-haired young woman who several of the group members were thrilled to realize must be the Mary Doe Coffey was talking about. As soon as Coffey finished speaking, several women raised the question of whether they as a group might not become plaintiffs in a class action lawsuit. Coffee was interested in class action lawsuits, having worked on several, and she knew they were enjoying considerable receptivity in federal courts at the time. Although she had not been thinking in terms of a class action suit, one might be a possibility. She soon rejected the idea, however. The Dallas women would not make good plaintiffs for the same reason the Austin Referral Service would not. None of the women was pregnant. To appease their disappointment, Coffey suggested that the Unitarian women might want to prepare an amicus curiae, a friend of the court agreed, to support her case, which they eagerly agreed to do. Convinced that she would find no other plaintiff, Coffey decided to move ahead as quickly as possible with the Doe's case. Then, early in summer 1969, just as she was about to file a lawsuit, luck struck in the form of a potential plaintiff who was suitable for the case, if only because she was pregnant and wanted an abortion. Coffey learned about Norman McCorvey through a colleague, Henry McCloskey. The two women met for the first time in McCloskey's office. From the start, Coffey was interested in McCorvey. Within a few days, she met with her once more alone so that she could hear more about Norma's situation and background. I'm on the last paragraph of this chapter. The next time Coffey talked to Weddington, she described Norma McCorvey to her. Weddington was enthusiastic, so much so that she asked Coffey if she might join her in the suit as co-counsel. Coffey was not surprised at the request to join forces officially, since they had in effect been working together unofficially for the better part of a year. She could see the advantages of having someone to work with. As an overworked junior partner in her law firm, she worried that she would not have as much time as she would like to work on the case. She had already rejected the idea of asking to do the work on the case pro bono. It was too radical for that. With two people, the work could be divided. She also welcomed Weddington's thoughts and ideas about how to best approach the issues. And of course, the bottom line was that it would be fun to have someone to share the excitement with. Coffey had a feeling that this case might generate a lot of that. So I'm going to yield to my dear colleague, and you can take on chapter 4.
Thank you very much, sister.
Thank you.
Awakening a nation's conscience. The public attitude toward abortion was gradually becoming more liberal throughout the 1960s, and Coffey and Weddington were right to suspect that the time was right for reform. Not surprisingly, since abortion was permitted in all states to save the mother's life, most people, 90% according to major polls, approved of abortions done for this reason. This figure changed little over the next decade. The most surprising change in attitude was occurring among the Roman Catholic population. In 1962, 36% of Roman Catholic men and women generally disapproved of abortion. By 1969, that disapproval rate had dropped to 20%. Americans of all religious persuasions were less approving of abortions done for reasons other than to save a woman's life, but their disapproval also declined steadily throughout the decade. In 1962, for example, 29% of Americans disapproved of abortion for fetal deformity, and 74% disapproved of those done for economic reasons. By 1969, those disapproval rates had dropped to 25% and 68%, respectively. In effect, between 1960 and 1969, abortion had shifted from a forbidden topic as taboo as incest to a subject that was increasingly discussed and debated in public. Two events, however, served to catalyze public interest in abortion and set the stage for reform. The first, which occurred in the early 60s, was the story of one woman's difficulty in obtaining an abortion. In 1962, Sherry Finkbein was a 29-year-old resident of Phoenix, Arizona, the mother of 4 children, all under the age of 7, and the star of her own local children's television show when she found herself pregnant with her 5th child. She was not unhappy about the pregnancy, but did experience some nervousness, which she treated herself with some tranquilizers her husband had brought home a year earlier from a business trip to England. 20 years and a world of sophistication later, most people would have difficulty recalling the naivete of both laypersons and the medical community with regard to drug use during the 1950s and 60s. Nothing was unusual about Sherry Finkbein's prescribing a tranquilizer for herself or using a drug that had been sitting in her medicine cabinet for 12 months. The fact that she was pregnant also would not have stopped her from using the medication because, like most people at that time, she erroneously believed that the placenta acted as a barrier between a woman and a fetus, preventing the penetration of any harmful substances. Drugs like Librium and Valium were in practically everyone's medicine chest. Why waste time with a psychiatrist when miracle pills existed that could, with one swallow, banish depression, insomnia, and nervousness? The era of heady innocence ended abruptly in 1962, when the first of several major drug dramas unfolded in the European newspapers. First reports indicated that over 5,000 babies were born severely deformed in England, West Germany, Canada, and Australia as a result of their mothers having taken a drug called thalidomide during the early weeks of pregnancy. Eventually, over 10,000 deformed babies would be born in West Germany alone. Thalidomide babies, as these infants were dubbed by the press, had a defect called phocomelia, which meant they had seal-like flippers rather than fully developed arms and legs. They also suffered from serious internal deformities, and fewer than half of the infants born with thalidomide deformities survived longer than a few weeks or months. Finkbein became aware of her problem when she read the reports of deformed babies being born in Europe. Upon reading the label of the tranquilizer she had taken, she learned that it was indeed thalidomide. Based on the reports coming from Europe, she knew the chances that her baby would be born seriously deformed were great. Sherry thought immediately of abortion. She had some reservations about it at first, but within a few days had sorted out her feelings and knew she wanted one. Her husband, Roger, agreed with her. She put in a call to her personal physician, who was sympathetic to her plight and willing to terminate her pregnancy. Strictly speaking, it was illegal for him to do so, since the Arizona law, like most other state abortion laws, permitted abortion only to save the life of the mother. But in cases like this, the law was widely ignored. For example, physicians routinely did abortions on women who had been exposed to German measles, also a cause of serious fetal deformities early in their pregnancies. Finkbein and her physicians would have to obtain medical certification to do the abortion. This typically consisted of approval by a hospital therapeutic committee, which was usually made up of an obstetrician gynecologist, not the one requesting permission to do the surgery, an internist, and a psychiatrist. Sherry Finkbein would have to appear personally before the committee, but she had every reason to assume that the approval would be routine. Therapeutic abortion committees were notably stingy about the number of abortions they permitted at their hospitals, but when they did approve one, it was invariably for someone like Sherry Finkbein, a respected member of the community, married, and the mother of at least 2 and preferably 3 children. Finkbein would not, of course, tell the hospital committee that she wanted an abortion so she would not have to give birth to a severely deformed child. Instead, she would say that giving birth to such a child would be too much pressure on her, so much so that it might cause her to have a nervous breakdown or even to take her own life. Everyone would then agree that this would pose an undue hardship on her and her family. Like the thousands of women who manage to obtain legal abortions each year, Finkbone meekly and unquestioningly acquiesced to this charade, and even went into the committee hearing, as did most other women in her situation, with statements by 2 psychiatrists attesting to the fact that her mental health would be adversely affected were she to be forced to bear a child that was severely deformed. Finkbein fully expected to check into the hospital the day after she met with the hospital abortion committee for a dilation and evacuation, also known as a D&C, the technique then used for abortions done during the first 3 months of pregnancy. At first, everything seemed to go as expected. With little deliberation, the 3 committee physicians agreed with Finkbone's doctor that she should be aborted on grounds that the birth of a severely deformed child would be an undue hardship on a family with 4 other small children to care for. Finkbone's surgery was scheduled for Thursday, July 26th. The process broke down unexpectedly, however, when a routine request for approval from the Maricopa County Medical Association was delayed while their lawyers reviewed the case. Finkbein's physician, realizing immediately that the situation was out of his and the Finkbein's control, told a New York Times reporter, "It is now a legal decision. It is no longer a medical or a humanitarian one. I'm afraid." Without waiting for the Medical Association's official response, the Finkbones hired a lawyer. The situation was growing urgent since she was almost 3 months pregnant. After 3 months, physicians could no longer do a D&C, a relatively simple medical procedure, and instead would have to perform a cesarean section. The Finkbein's lawyer recommended that Sherry go into court to seek a legal judgment that she was entitled to an abortion, so the Finkbeins filed suit against the Maricopa County Attorney and the Arizona Attorney General on Friday, July 27th. Joining her in the suit was the Good Samaritan Hospital. Heeding the urgency of the situation, Arizona attorneys immediately began drawing up a legal response, which they filed on the same day the suit was initiated. By now, the nation's attention was riveted on the Finkbones. Their dilemma was front-page news and a regular nightly story on the national television news, and public sympathy was running high on their behalf. Their situation was undeniably tragic, regardless of one's view on abortion, and thus the state's lawyers can be forgiven for not wanting to play the role of villains. If, as Finkbone was claiming, and as her lawyers and the 2 psychiatrists had attested in the court's papers, she might take her own life if forced to bear the child, then the state of Arizona would raise no objections to an abortion. They asked for dismissal of the case on grounds that there was no legal controversy. Sensing that things were going their way, the Finkbones lawyer pleaded for an early decision, informing the court that if an abortion were not done within the next 2 weeks, his client might have to undergo the more dangerous abdominal surgery. Late Friday afternoon, Arizona Supreme Court Judge Yale McFate postponed his decision, saying that he would rule Monday on the motion by the state to dismiss the case. The Finkbeins' only concern was that they be allowed to get on with the abortion without the threat of legal prosecution hanging over their heads. They wanted the court to issue a clear-cut ruling that Sherry Finkbone had a right to obtain an abortion. Over the weekend, the Finkbeins' attorney, Walter Sheffetz, said he would advise her to drop the suit if the public attorneys would promise not to prosecute her for having an abortion. Arizona officials, not unsympathetic to her plight and despite the obviously skewed facts of her case, did not, however, feel that they could bend the law to the extent of publicly agreeing not to prosecute Finkbone. The matter was resolved, at least so far as the state of Arizona was concerned, on Tuesday, when Judge McFate dismissed the case on grounds there was no real legal controversy. He gave the Finkbone's attorney 10 days to amend the case to show controversy, that is, to build a case around the real reason that Finkbone wanted an abortion, her unwillingness to bear what would almost certainly be a seriously deformed child. If she asked for an abortion on this ground, the state would almost certainly contest her plea, since no provision existed in the Arizona law for granting an abortion on this ground. At that point, the judge would be forced to rule on the case, although he might not rule, indeed most likely would not be able to rule in the Finkbone's favor. Although the judge's personal sympathies clearly lay with the Finkbones, legally his hands were tied, as he noted when he said, "As a person, this judge is impelled to grant a hearing. As a judge, I cannot do it." As the Finkbones mulled over their next step, the by now ravenous public turned its attention to the larger thalidomide problem. After heated debate, in a move that only increased public sympathy for more liberal abortion laws, the British Parliament voted not to change the law to permit abortions on pregnant women who had taken thalidomide. It also refused to grant any aid to thalidomide babies, even though it was clear that the British government had not required adequate testing of the drug before releasing it. Americans, who thought they were safe from this disaster since thalidomide had not been approved for general distribution in the United States, were shocked to learn that the drug had been tested in the United States by one drug manufacturer. First reports indicated that it had only been given to several hundred persons, but within days it was revealed that thalidomide probably had been tested on several thousand people. The drug was distributed to 1,129 doctors in 39 states. If each doctor had tested the drug on only 3 patients, that meant more than 3,000 persons had taken it, and some of those would almost certainly be pregnant women, since nervousness and depression were frequent complaints of pregnancy. On July 21st in Queens, a borough in New York City, a woman gave birth to a thalidomide-deformed infant who lived only 41 minutes, and other reports of thalidomide babies soon began to filter in. Having hinted that they might go ahead with the abortion, the Finkbones now awaited word from the hospital that it was still willing to perform the surgery. After Judge McFate's ruling, on advice of its attorneys, Good Samaritan Hospital announced that it would have to reconsider its role in this rapidly escalating controversy. On Wednesday night, July 31st, hospital officials huddled to discuss the problem. Worried about repeated threats of prosecution, they decided to perform the abortion. The door had now been slammed on the possibility that the Finkbones might obtain a legal abortion in the state of Arizona. And although abortion to save the mother's life was legal in all 50 states, and Alabama, Oregon, and Washington, D.C. allowed it to preserve a mother's health, in the glare of publicity that surrounded the Finkbones' every move, it would not be easy to find a state willing to permit the abortion. Furthermore, although the initial response had been an outpouring of sympathy, the publicity also had brought out the critics of abortion. Hate mail was arriving daily, and the Finkbones were receiving anonymous, threatening telephone calls. They began to realize that their best course of action was to leave the country for an abortion. They could go to Denmark, Sweden, or Japan, where abortion laws were more liberal, and they hoped public attitudes more tolerant. By Thursday, August 2nd, Sherry Finkbone still had not decided where to go. although her doctors had warned her to have an abortion by Sunday in order to avoid a cesarean section. The Finkbeins had booked a flight to Sweden, but canceled their reservations 30 minutes before departure. They said they were leaning toward Japan, where an abortion could be obtained with no red tape for about $50. Their attempts to make plans were hindered by the fact that their every move, including the cancellation of the plane flight to Sweden, continued to be front-page news across the nation. In addition, on Friday, a broadcast by Vatican Radio, obviously referring to the Finkbein case, but not using the name, denounced a mother who desires at any cost to interrupt her maternity for fear that her child be born deformed. The Vatican report never mentioned thalidomide and its role in causing life-threatening deformities. The New York Times, while previously respecting Finkbein's wish that her religion not be reported, revealed that she was Unitarian. Clergy across the country were invited to respond, but seemed reluctant to do so, although a few, such as Reverend Howard Newby of New York City's Judson Memorial Church and a founder of CCS, and Rabbi Israel Margolis, defended Finkbein's desire to obtain an abortion. The clergy's reluctance to speak out was undoubtedly due in part to the fact that so many Protestant denominations had no clear-cut view on abortion, although the leading mainstream denominations, such as the Reform and Conservative branches of Judaism, accepted abortion when done to save a woman's life, and often for other humane reasons as well. When Roman Catholic Bishop Thomas J. Riley of Boston condemned the Finkbeins for killing an innocent boy or girl, only the Seventh-day Adventists replied, stating that they believed the abortion would be therapeutic. On Saturday, August 4th, Sherry and Robert Finkbein were en route to Stockholm, Sweden. Japan had been their first choice, but the Japanese government had also been reluctant to get involved in what was threatening to turn into an international incident. Officials at the Japanese consulate did not tell Finkbein outright that she could not have an abortion in their country. Rather, they spoke of the long delay that would be involved in granting her a visa. She got the message. Even in Sweden, there was no assurance that an abortion would be granted. Government officials had warned that there could be an official delay and were careful to note that Sherry Finkbein would still have to prove she was mentally ill to obtain an abortion right away. Swedes and their government, though, took a more liberal view of abortion than did U.S. citizens and officials, and Finkbein had reason to believe she would be granted an abortion in Sweden. Before leaving, the Finkbeins had granted one television interview to a local station. In it, Sherry Finkbein had revealed the toll that being the center of such an intense controversy was taking on her. "I've tried to keep control of myself emotionally," she said, even though she had awakened at night and her newborn babies crying. She was still determined to get an abortion because it was right and the only thing to do. She revealed how she had burst into a rage when a San Francisco couple offered to adopt the baby. "If it were born, the last thing I would want to do would be to place the burden on someone else." Based on these statements alone, Finkbein, who would never participate in the abortion reform movement, must nonetheless be counted as one of its most articulate spokespersons. The honesty and ambivalence she revealed in the television interview would become rare as pro-choice reformers grew increasingly strident in their defense of the abortion right, and anti-abortionists equally vehement in their view that no abortions were permissible. Yet Finkbein only revealed feelings that are present in every woman, regardless of whether or not she supports the abortion right, when she knows she must make a decision to terminate a pregnancy. The decision to undergo an abortion, except in the most insensitive of women, is not an easy one, nor is it lightly made. By the time the Finkbones were headed to Sweden, the rumble in the United States over the safety of prescription drugs and adequate drug testing had become a roar. New reports surfaced in the New York Times about the increased incidence of thrombosis in women taking an Ovid, a birth control pill. There had been warnings of problems associated with the pill, but before the thalidomide scare, they were never taken seriously. When President John F. Kennedy held a press conference on August 12th, thalidomide was the first topic reporters raised. The administration seemed to have found a clever way, however, to deflect attention from whether the first Roman Catholic president approved or disapproved of Finkbein's decision to get an abortion and whether he thought the abortion laws should be liberalized in light of developments surrounding thalidomide. Instead, one slightly bewildered government scientist, Dr. Francis Olden Kelsey of the Food and Drug Administration, became an overnight heroine for her refusal to approve thalidomide for general distribution. She was invited to the White House and decorated, despite her gentle protests that she was only doing her job. The press, for its part, never removed its kid gloves and asked the president how he felt about the abortion laws in light of the thalidomide controversy. The second week of August, while Senate hearings were being conducted about the need to tighten the drug laws, Sherry Finkbein was experiencing more routine delay in Sweden. By August 6th, she had not yet seen a physician. Swedish officials reiterated that she would be treated like any other woman seeking an abortion, which meant she would be subject to penetrating investigation. The next day, she saw a physician and was scheduled to see him again on Friday. For the second time, the Finkbein's hopes were raised that Sherry would be able to obtain an abortion before the week was out. On August 9th, she completed the psychiatric examination. The Swedish State Medical Board met on August 17th, at which time they unanimously agreed to permit her to have an abortion. She was operated on the next day. According to the physician's report, the fetus was seriously deformed. While the Finkbeins were in Sweden, a trial was being held in Belgium, in which a woman, her husband, mother, sister, and physician were accused of murdering her thalidomide-deformed infant. The mother admitted she had put an overdose of a drug in the baby's milk, and the other defendants were being tried as accessories. Public pressure to acquit the group was so great that on the day the decision was handed down, hundreds of extra police were assigned to the courtroom to control the angry mob that was expected to materialize should the decision go against the defendants. All were acquitted. The Finkbeins returned to the United States a week later and tried to resume life as private citizens. Sherry felt she could not return to her job as hostess of Romper Room, that doing so would, in her words, place the television station in a precarious position. Throughout the last 2 weeks of August, the newspapers continued to report on the numbers of babies that were expected to be and were born with deformities caused by thalidomide, which was now banned everywhere. In November, Sweden's medical board, responding to the Finkbeins case, asked the government to liberalize the country's abortion laws. Abortions should be permitted, they urged, when a fetus was likely to be born with a severe birth defect, so women like Sherry Finkbein would not have to lie to terminate a pregnancy. Finkbein's struggle to obtain an abortion left a lasting impression on the public. It demonstrated the hypocrisy of the present laws and revealed how badly reform was needed, even though it would be another few years in coming. Most important, it personalized abortion for millions of people, few of whom could deny that they would have wanted an abortion badly had they been in Sherry Finkbein's shoes. Ironically, the difficulty Finkbein encountered in trying to obtain an abortion in the United States would not have occurred only a few years earlier, even though abortion was illegal. The controversy was a sign that battle lines were being drawn between two enormous clashing factions in American life. Those who approved of abortion, or could at least condone it under certain circumstances, and those who could not condone it under any circumstances. Had unusual forces not intervened to bring the Finkbein's dilemma to the attention of legal authorities, Sherry's fate would have rested entirely with her physicians, as happened with all women who hoped to obtain a legal abortion in the United States. Physicians have played a major role in bringing about the current restrictive laws which put abortion firmly in their control, and only through an understanding of their role in outlawing abortion can we begin to understand why they were later willing to work, however half-heartedly, to liberalize it. The restrictive Texas abortion law had only been in existence for about 100 years when Coffey and Weddington challenged it. In the long view of history, not very much time at all. Prior to the mid-19th century, abortion was widely available. Many historians and demographers considered it to be the most frequently used method of birth control, there being little else available for most of human history. Abortion is known to have existed for at least 5,000 years, and in fact was once so widespread that it is safe to say there are no societies in which it never occurred, although it characteristically met with varying shades of approval, denial, ambivalence, disapproval, and outright ostracism, as George Devereaux revealed in a study of abortion in primitive societies. Despite its name, the book is a survey of abortion practices in 20 modern and historical societies, as well as 400 primitive ones. Abortion was known to be practiced widely in ancient Greece and Rome. Plato and Aristotle viewed abortion as an acceptable means of birth control. Even Hippocrates, who gave physicians the oath on which they later based their ideological opposition to abortion, reportedly instructed a young woman musician on the best means of self-abortion. Devereaux found that women typically aborted themselves, that abortion was almost exclusively a female activity, which may account for its prevalence, even when it has been outlawed. In many cultures, women have formed networks among themselves to help one another when necessary to obtain illegal abortions. I yield to the sister. Thank you.
Old German tribal law recognized that the right to terminate pregnancy rested with the woman, and in common law nations throughout the world, women were at liberty to obtain abortions when they needed and wanted them. Under common law, a fetus was not recognized as a legal person until birth. This did not mean it was not considered human, but rather that it was made for receipt no legal claims prior to birth. Fetuses could, for example, inherit property, but the inheritance was contingent upon live birth. Similarly, fetuses could sue, but again, settlement was contingent upon live birth. In the United States, fetuses did not have the rights of personhood that were guaranteed in the Constitution. No infringement of the common law right to abortion occurred until 1803, when England enacted the Edinburgh Law, which among other things outlawed abortion. The law was not so much the result of any moral opposition to abortion as it was an attempt on the part of Lord Edinburgh to do something about what he viewed as the increasingly liberal criminal laws. The new abortion statute was merely one part of a crime bill, ominous crime bill. In theory, the Edinburgh Law meant that British women went overnight from a common law liberty to obtain abortions to a situation where they could be prosecuted and punished for aborting a pregnancy. In practice, however, the poorly written and vague law was unclear on such issues as whether a woman, as opposed to the abortionist, could actually be convicted of abortion. No similar action to restrict the abortion right would be taken in the United States for almost 50 years. Throughout the colonial era from 1664 to 1776, the United States followed the common law, which meant abortion was permitted. When the United States became a nation in 1776, most states adopted the common law, and women were still free to terminate pregnancies at will. No one knows why abortion was not mentioned in the U.S. Constitution, but scholars tend to agree that it was not an issue at the time the Constitution was written, abortion being commonly accepted and fairly widespread. The public attitude toward abortion was one of sympathy and understanding. Devereaux has pointed out that society's attitudes toward abortion often display great plasticity and variability of behavior, and seem to alternate between periods of ignoring abortion and bursts of activity designed to do something about it. Doing something about abortion, however, has proven to be a nearly impossible task, since women continue to manage to obtain abortions regardless of whether they are legal or otherwise culturally restrained. Prior to 1820 in the United States, abortion had been ignored for hundreds of years. Between 1821 and 1840, however, a wave of restrictive abortion laws were passed. The effort to change the abortion law was almost entirely the work of the medical profession, or, to be more accurate, a group of physicians known as the regulators. James C. Moore, author of Abortion in America, an excellent analysis of American abortion policy, has attributed the physicians' motives in pushing for restrictive legislation in part to a desire to upgrade themselves professionally and become the exclusive providers of healthcare services in the United States. Physicians mounted a campaign to drive out or bring under their control the irregular medical practitioners, which at the time included pharmacists, surgeons, and midwives. Midwives and pharmacists were special targets, in part because the former were the chief source of women's medical care, and the latter were the chief suppliers of chemicals that caused abortions. By 1841, restrictive laws had been passed in 10 states and 1 federal territory. The content of these laws would seem to indicate that they were intended to limit the practice of medicine to the regulars as much as to outlaw abortion. They seem not to have been based on any moral opposition to abortion. For example, the new laws typically outlaw the use of abortion, like an abortion pill, an abortion.
Medication abortion?
Yes. I guess that's what the term is. But said nothing about abortion done through surgical means. A medical procedure that was exclusive province of the regular physician. When New York State passed a restrictive law in 1830, it included something called the therapeutic exception, which soon made its way into most other states' laws. This permitted abortions done to save a woman's life. New York, like several other states, also mandated that abortion was a crime only when someone, either the woman or the fetus, died. Unsuccessful abortions were not criminal. No state held that the woman who sought an abortion was guilty of any criminal activity. The illegal abortionist was the sole target of these restrictive laws. A striking feature of the new laws was that they restricted abortion only after quickening, the point at which a woman first felt movement within the womb. Juries and judges were reluctant to convict an illegal abortionist or find anyone guilty of causing a miscarriage prior to quickening, and legislatures in the 19th century were similarly reluctant to impose any restrictions on unquickened pregnancy. Among other legal problems with quickening was the fact that the proof of its existence depended entirely on the woman's testimony. These omissions and overall vagueness in many of the new laws were indicative, as much as anything, of the legislators' general reluctance to place any kind of restrictions on abortion. Women continued to obtain abortions without fear of reprisal, and the public remained sympathetic and tolerant of a woman who needed one. Throughout the 1830s, physicians seemed to lose ground in their battle to professionalize themselves, and in the process to restrict abortion. Many of the medical regulation statutes passed in the previous decade were repealed, and concern over limiting abortion receded once again. This time, however, the law was only temporary, and interest in regulating abortion was rekindled around 1840, largely because it had become increasingly common. Like much else in American life in that period, abortion had become a highly commercial venture. Ladies' magazines and newspapers ran countless advertisements for promotions designed to unblock the Nazis, as abortion was delicately referred to. A number of illegal abortionists, among them the infamous Madame Estelle of New York City, sold their potions, and when those failed, provided surgical relief at openly operated abortion clinics. Madame Estelle, who catered to the rich and famous in New York, spent $60,000 annually advertising her potions and also operated clinics in Boston and Philadelphia. Between 1840 and 1860, the states responded in patchwork fashion to the so-called abortion epidemic. Some tightened their laws. Some that had not had any laws restricting abortion now passed them. By 1860, though, 13 of the 33 states still had no laws on abortion, and the reluctance to restrict abortion prior to quickening was still evident from the tone of the laws written during that period. In the late 1850s, the regular physicians decided the time had come to reinstate their campaign against abortion. This time, their campaign, with its decidedly moral tone, began to look like a crusade. While addressing a group of Michigan regulars in April 1867, physician E.P. Christian stated, "It is not sufficient that the medical profession should set up a standard of morality for themselves, but that the people are to be educated up to it. The profession must become aggressive toward those wrongs and errors which it can only properly expose and successfully impose." In The Physical Life of a Woman, a best-selling home medical book published in 1870, George H. Nappy, M.D., wrote that, "Who taken charge of public morals would join him and other physicians in the fight to eliminate abortion, a frequently prevalent sin." The physicians tried and failed to round up support from the clergy, but they did receive help from unexpected sources. Most notably, crusaders led by Anthony Comstock, who almost single-handedly aroused the nation to fever pitch about the obscenity, and several newspapers which campaigned extensively against abortion, dubbing it the evil of our age. Splashed across the front pages of several newspapers, including the New York Times, throughout the 1870s, were lurid stories of women who died in the course of obtaining illegal abortions. The women were depicted not as victims, but rather as moral examples, while the illegal abortionists were painted as true villains, unsavory, uncaring, money-hungry characters. The morality march culminated in 1878 when Comstock arrested Madame Estelle. Her suicide on the eve of her trial in May 1878 did as much as any other single event or strain of crusading to turn the American public against abortion. That was something deluged with a highly inflammatory and not always accurate propaganda about the evils of abortion. People were finally persuaded that something needed to be done, that laws turned out to be the passage of even more restrictive laws. Between 1860 and 1880, laws were written in 40 states and territories, and 21 states revised laws that already had to make them stricter. Many states outlawed abortion for the first time, and by 1900, when the crusade against abortion was finally dying out, only Kentucky had no law against abortion, and even there, one court had ruled it illegal. The second wave of abortion laws was far tougher than the first. The distinction between a quickening and unquickened fetus was removed in most state laws, making abortion illegal at any stage of pregnancy. In several states, such as Indiana and New York, women who had always been seen as the victims of illegal abortions, even when they sought them, lost their immunity, and for the first time could be prosecuted for obtaining abortion or aborting themselves. Even the courts fell under the influence of the evil of the age. Before the mid-19th century, it was difficult to find a jury that would convict an illegal abortionist. So much so that more noted prosecutors did not even want to tarnish their records with abortion cases that they were sure they were going to lose. Courts followed the precedent set in Commonwealth v. Bangs, an 1812 Massachusetts decision, in which a man was acquitted of charges of administering abortion medication on grounds that the fetus had not yet quickened. All that changed as the morality of abortion became a basis for further restriction of the laws. In New York in 1892, for example, the plaintiff's attorney pleaded the inadmissible evidence that had been used to convict their plaintiff of undertaking an illegal abortion. The court upheld the conviction despite the irregularities. It was a case that would have been dismissed a few decades earlier. In an even more startling 1882 decision, Commonwealth v. Taylor, the Massachusetts Supreme Court held that prosecutors did not have to prove a woman had been pregnant to prosecute her abortionist.
May I inquire my fellow Missourians? You yield?
I do yield.
Down there?
Yep.
Okay. Could you actually take the
yes.
binder?
Yeah. Those are fun.
Good morning. I'm going to resume reading Roe v. Wade, The Untold Story of the Landmark Supreme Court Decision that made abortion legal by Marianne Fowl. The restrictive laws stayed on the books, diligently enforced at first and not so diligently enforced after a few decades. But abortion, once again, was not an issue that concerned anyone. Over the years, some accommodation was worked out between women and their physicians, and an accommodation that would ordinarily have enabled a woman such as Sherry Finkbein to obtain an abortion with relative ease. For the next 50 years, doctors seemed remarkably united in their consensus that abortion was morally wrong and should be permitted only in those instances where it was necessary to save a woman's life. It would have been difficult for anyone outside the profession, and even for many inside it, to realize that a crisis of huge moral proportions was looming on the horizon. If the Finkbein's tragic story served to educate the public about the need to change the current state laws, another legal controversy was brewing that would, 4 years later, spur the medical profession into action on behalf of abortion reform. After 1900, medicine began to make progress in reducing the numbers and kinds of situations where pregnancy was life-threatening. Anti-nausea drugs eliminated excessive vomiting, a common reason to terminate a pregnancy. Tuberculosis was no longer life-threatening, and its female victims recovered and could bear children with no ill effects on their health. Advances in the treatment of heart and kidney disease made it possible for women suffering from those conditions to have children, and women with diabetes could be carefully managed through pregnancy. Conservative, mostly Catholic physicians who opposed abortion but accepted it when performed to save the life began to look forward to the day when no doctor would have any reason to perform an abortion because no woman's life would be at risk during pregnancy. More liberal, mostly Protestant physicians, however, saw the situation in a different light. They began to question whether the time had not come to apply more liberal standards to abortion, which was also now a safer procedure. They asked whether an abortion might not be justified when a fetus would be born with gross abnormalities, or because a couple had several children and could not afford another. or even because a mother had borne too many children too close together and would have great difficulty coping with another child. Women continued to ask for abortion, and these doctors were at a loss as to explain why they could not have them. Wasn't it possible that saving a woman's emotional or physical health was as important as preserving her physical life? Were there not perhaps some purely humanitarian reasons for abortion? The threatened schism was postponed in 1945 when birth control expert Alan Guttmacher introduced the idea of therapeutic abortion committees, special hospital boards composed of 3 or more physicians who would supervise abortion services. By 1950, virtually every hospital had one. Because the committees completed the trend toward moving abortions out of doctors' offices and into hospitals, thus making them more public and therefore subject to moral censure. The immediate effect of the abortion boards was to drastically decrease the number of abortions. One hospital that did 11 abortions per year before an abortion board was installed did 1 abortion per year afterward. But this was a typical figure for any hospital after a committee was installed. Hospitals even developed quotas permitting so many abortions per live birth. The committees at least temporarily eased the tension between the physicians who were increasingly uncomfortable with any abortion done other than to save a woman's life, and those who felt that there were other reasons to abort a pregnancy. For the time being, at least, Roman Catholic doctors would not express disapproval of their colleagues who performed an occasional committee-approved abortion for a reason that did not follow the letter of the law, so long as relatively few of these abortions were done. It went without saying that Protestant and Jewish doctors did not pressure Roman Catholics to do abortion, and that abortions would not be performed in Roman Catholic hospitals. The tension between the two factions changed when the number of hospital-sanctioned abortions began to increase. A crisis occurred in the spring of 1966 in San Francisco when the city found itself in the throes of a German measles epidemic. Health professionals had long recognized the dangers of rubella, or German measles, to a woman in the early months of pregnancy. Fully 90% of women who caught the German measles while pregnant could be expected to give birth to a child with serious birth defects, which included blindness, deafness, heart defects, and other maladies. The epidemic brought with it the usual corresponding rise in the number of abortions. But even more alarming to some was the fact that the more abortion requests came from married than single women, a reversal of the usual ratio. Ironically, a perceived rise in abortions among married women had triggered the opposition to abortion in the late 19th century, and history would now repeat itself 100 years later. San Francisco physicians were not unaware that abortions done on a woman exposed to German measles were, strictly speaking, illegal, but they went ahead anyway, confident that public opinion was with them. A survey taken after the Finkbein case had shown that 50% of Americans believed she had made the right decision, that fetal deformity was a legitimate cause for seeking an abortion. Only 32% disagreed with her decision, and 18% were undecided. Reform laws permitting abortion to preserve a woman's health had recently passed in Alabama, Colorado, New Mexico, Oregon, and Washington, D.C., and there was talk of a similar law in California. It had been this spirit of reform that the California Medical Association in March of 1966 had voted to press for reforms in the abortion law. Not everybody wanted the law changed, however. Dr. James McNulty, a Los Angeles obstetrician, Roman Catholic, and a member of the California State Board of Medical Examiners, had responded to the CMA vote by threatening action by the board. McNulty and others who shared his opposition to abortion were acutely aware of the increase in abortion as a result of the measles epidemic, and they disapproved of those too. Hospital abortion committees, once protective of their institution's reputation, seemed even to have colluded by approving the abortions. The action McNulty threatened was not long in coming, and it proved to be far more severe than anyone expected. 8 weeks after the CMA vote, On a Saturday in May, local investigators entered several San Francisco hospitals, and even though they did not have a court order, secured files revealing which physicians had performed abortions because of German measles in the last year. Several physicians who were interviewed readily admitted that they had done abortions on women who had German measles. The confessions were secretly taped, a rather grandiose authoritarian gesture since the doctors made no attempt to deny the abortions. California Attorney General Thomas Lynch announced that the state had prepared charges against 21 physicians and was preparing charges against another 20 for performing illegal abortions. The San Francisco Chronicle broke the story before any indictments had been handed down in an article that noted the law had rarely been enforced. This was considered the largest legal crackdown on doctors in California history, and perhaps in the history of the United States. Since the restrictive laws had been passed, very few licensed physicians had been accused of performing illegal abortions. On heels of the hospital raids came an announcement that the California State Board of Medical Examiners was filing disciplinary charges against two prominent San Francisco physicians, Paul J. Shively of St. Luke's Hospital and Seymour Smith of San Francisco Memorial Hospital, for performing abortions on women with German measles. The abortions they had done had also been approved by the hospital abortion committees. The two men faced revocation of their licenses. Shively and Smith admitted they had performed therapeutic abortions on women exposed to rubella. Overnight, the San Francisco medical community rallied around the accused physician. Dr. George Herzog, president of the San Francisco Medical Society, described Shively and Smith as top obstetricians in town and in the state. And when asked if he had performed any abortion on women exposed to rubella, replied, "I'm sorry I haven't, because this is a distinguished company of doctors. They are humanitarians." Herzog said the doctors throughout the city were in a furor and aroused to a battle-ready pitch. Within days, the city's obstetricians and gynecologists voted 10-1 to support the two accused doctors. The San Francisco Medical Society met soon after, after the indictments were announced, and voted 104-10 to call for broader abortion laws. Despite support within the medical community, the immediate effect of the controversy was to halt all abortions in the city. By the end of May, lawyers for the San Francisco hospitals insisted that abortions be halted until the law was cleared up. Most physicians had stopped doing them anyway. Pregnant women exposed to rubella were forced to go elsewhere for abortions. Those who could afford to do so traveled to another state or out of the country, but poor women who had been exposed to German measles simply had to run the greatly increased risk of giving birth to a severely deformed child. Doctors organized a statewide California Committee on Therapeutic Abortions to fund the defense of their colleagues who had been challenged with illegal abortion. The committee immediately voted to embark on an educational campaign to promote the greater public understanding of the need for liberalized abortion laws. Most committee members were San Francisco physicians, but also serving on the board was the Reverend Lester King-Spalding, a founder of the New York-based Clergy Consultation Service, the group that had pioneered abortion referrals. A reform bill in the works in the California legislature since 1963 had been killed twice in committee, primarily as its current sponsor, Representative Anthony Bielenson, noted, because so little support had been forthcoming from the 22,000 members of the California Medical Society. Virtually overnight, however, Bielenson found himself with the support he needed to push through the bill, and in 1967, a liberalized bill passed the California state legislature. We could say the same here. Meanwhile, the accused doctor received suspended sentences, which they later appealed in court and won. The California State Board of Medical Examiners, after much dilly-dallying, finally reprimanded one doctor and suspended the licenses of 8 others for 90 days. Dr. McNulty's attempt at cracking down on illegal abortions by licensed doctors had backfired miserably, and he soon resigned from the California Board of Medical Examiners. Instead of solidifying disapproval of abortion, his action had spurred a response on the part of those who wanted reform. Physicians across the country, many of whom had bent the abortion laws themselves, were alarmed at the events in San Francisco. For years, so-called legal abortion had been the exclusive domain of the medical profession, and law enforcement officials had confined themselves to going after illegal abortionists. Now it seemed that physicians' unspoken immunity had been shattered. Now no one could feel safe until the issue was resolved. Physicians who 50 years earlier had used abortion to solidify themselves professionally would now break ranks publicly over the very same issue. From now on, they would be at the forefront of the drive to reform the abortion laws. Not surprisingly, given their history with abortion, their support would at times be half-hearted and ambivalent. But, for their own good, they could no longer ignore the growing concern over restrictive abortion laws. At last, the stage was set for reform. Part 2, in the lower court. Chapter 5, suing the state. 8 weeks passed between the first meeting of McCorvey, Weddington, and Coffey and the filing of the case. Not a lot of time in terms of what is needed to prepare a legal case, but too much time for McCorvey, who still hoped against all odds she might be able to get an abortion. During those weeks, Weddington and Coffey found themselves moving from the task of theorizing about defeating the state's abortion laws to the challenge of actually doing something about them. The Christmas holidays of 1969 slowed everything down, and researching the case took time. Before they began their research, Coffey and Weddington met several more times with Norma, McCorvey, and the Does. The Does were no problem, committed as they were to the case, but Norma was somewhat worrisome. She was having difficulty caring for herself and had gone underground, staying, to use her own words, in a succession of flop houses for hippies, and with various female friends. Coffey and Weddington often had trouble contacting her, and they worried that she would change her mind about being the plaintiff, but not bother to notify them of her decision. Theirs was not a family law case where a lawyer needed regular contact with the client to check on the family finances or the children's welfare. Once the facts of the abortion case had been established, there was little reason to be in touch with McCorvey. Still, either Coffey or Weddington, usually Weddington, called her whenever there was something to report, or, as was more often the case, when nothing was happening. They stayed in touch with her mostly to reassure themselves that she was not having second thoughts about the case, and they did that less and less as they became preoccupied with preparing the case. The Texas abortion law consisted of 6 separate articles. Article 1191, abortion. This is reading from the Texas statute at the time. If any person shall designedly administer to a pregnant woman or knowingly procure to be administered within her consent any drug or medicine, or shall use towards her any violence or any means whatever externally or internally applied, and thereby procure any abortion, he shall be confined in the penitentiary not less than 2 nor more than 5 years. If it be done without her consent, the punishment shall be doubled. By abortion, in quotes, is meant that the life of the fetus or embryo shall be destroyed in the woman's womb, or that premature birth thereof be caused. Article 1192, furnishing the means. Any person who furnishes the means for procuring an abortion, knowing the purpose intended, is guilty as an accomplice. Article 1193, attempt at abortion. If the means used shall fail to produce an abortion, the offender is nevertheless guilty of an attempt to produce abortion, provided it be shown that such means were calculated to produce that result, and shall be fined not less than $100 nor more than $1,000. Article 1194, murder in producing abortion. If the death of the mother is occasioned by an abortion so produced or by an attempt to effect the same, it is murder. Article 1195, destroying the unborn child. Whoever shall, during parturition of the mother, destroy the vitality or the life in a child in a state of being born and before actual birth, which child would otherwise have been born alive, shall be confined in the penitentiary for life or for not less than 5 years. Article 1196, by medical advice. Nothing in this chapter applies to an abortion procured or attempted by medical advice for the purpose of saving the life of the mother. Weddington and Coffey decided they would challenge the constitutionality of Articles 1191 through 1194 and 1196. 1195, which referred to the destruction of the fetus during the process of birth, could be read as straightforward malpractice law, so they felt no challenge was needed. The two women were grateful that the Texas abortion statute enacted in 1859 was what reformers referred to as an old-style law, compared with the new-style reform laws that had been written in the late 1960s. The Texas law was unusually restrictive and permitted abortion only to save the mother's life, not even in cases of rape or incest. In contrast, the new reform legislation typically added therapeutic exceptions to preserve the mother's physical or mental health, to prevent serious fetal deformity, and to terminate pregnancies resulting from rape or incest. In theory, these new laws were supposed to make abortion more widely available. In practice, they made it less accessible since complicated administrative procedures such as residency age and consent requirements hindered the abortion process, especially for a woman who did not know how to cut through red tape. I should make an aside here that the Missouri law that just passed the state Senate, tripling the mandatory delay, does not have any exception in the cases of rape or incest, and in fact, the Senate had a chance to include those exceptions and voted them down overwhelmingly. This is 2014, after all, and I'm reading a book about pre-1973. The constitutionality of some of the so-called reform laws was already being challenged in courts at considerable time and expense. With an old law, a court challenge could be straightforward and uncomplicated, or so the two women hoped. They would not have to spend a lot of time and money amassing statistical evidence that the laws were being administered in a discriminatory fashion, nor would they have to pay expert witnesses to testify to the fact that consent or age requirements denied women access to abortion. Instead, they could base their challenge on a single straightforward issue, the idea that the Texas abortion law was unconstitutional. Coffey and Weddington could not have undertaken the case had they been required to spend much money on it. Their only source of funds was personal, and neither woman earned much money. Since both were now working at full-time jobs, Coffey at her law firm and Weddington at the Fort Worth's first women Fort Worth's first woman assistant city attorney, all research would have to be done in their spare time. This was before the internet. The subject of fees never came up with their clients. The Does were employed but did not earn very much and lived in a tiny one-bedroom apartment, and Norma McCorvey had no home and was barely making ends meet working part-time as a waitress or a bartender. Had the case been undertaken by a major law firm, even on a pro bono basis, considerably more money and manpower would have been devoted to its preparation. A law firm would assign several associates or junior partners to do the initial research. The women had no one but themselves. Fortunately, their expenses were minor, consisting only of some nominal court fees. Legal research is not unlike looking for a needle in a haystack. And although it has been made easier in recent years by desktop consumer computers and Lexis, a legal database that provides almost instantaneous results, it still tends to be tedious work. One begins with a theory. In Coffey and Weddington's case, the idea that the current Texas abortion law was unconstitutional, and then looks for material, either in the form of important law journal articles, precedent-setting cases, or in their case, since material was sparse, prior cases of any kind to support the theory. Coffey and Weddington spent hours combing through bibliographies and indexes for clues to cases or journal articles that might be relevant. Use of the courts to attack the constitutionality of a law was a recent development. As a legal tool, it came into widespread use during the 1950s and 1960s, an era of expansion in civil rights. Lawyers who chose to challenge the laws were often required to mine new territory within the Constitution, to seek connections where none had previously existed. It was exciting and even exhilarating work, but it also required creativity and thoughtfulness, and sometimes more than a little daring. Above all, of course, the results had to be persuasive. Both women believed, as did most lawyers working on abortion, that any constitutional challenge to the abortion law would be based on the 14th Amendment, which guaranteed equal protection under the law. Beyond this, Coffey and Weddington had little idea whether there were other grounds for overturning the laws. They began by looking for other abortion cases, ones that might support their theories or provide new ones. The American legal system, based on the English common law system, relies heavily on precedent, that is, previously decided cases. Most judges are reluctant to reverse a body of decisions pointing in one direction. Not all cases, though, are considered precedent-setting. A court pays more attention to cases decided in its own state than to those decided in another state where laws might be different. Although important decisions by another state's high court carries weight, especially if the court is respected for its opinions. Coffey and Weddington found surprisingly little to go on. Few suits have been brought involving abortion, and even fewer were important enough to set precedents. No abortion case had yet come before the Supreme Court, and only a few state courts had dealt with the issue. They found only one recorded case in Texas. Watson versus the state of Texas, decided in 1880, involved a young woman named Maddie Shook, who became pregnant by a man known only as Watson, while living with him, his wife, and his children. Because he was a physician, Watson told Shook he would give her medicine that would cause her to miscarry. Despite taking Ergo, the drug he prescribed, even more frequently than he had ordered, she failed to miscarry. A note describing Maddie's condition was sent to the doctor's wife, reputedly from Maddie's fiancé, but actually from Maddie herself, and this led to the court case. Maddie Shook testified against the physician. A lower court found the man guilty of designedly administering an abortifacient, an illegal act under the Texas anti-abortion law, but a Texas appellate court reversed the lower court on technical grounds. The court's reluctance to punish the abortionist 20 years after abortion had been outlawed in Texas was interesting and even persuasive, but the case was of little help to Weddington and Coffey, based as it was on a technicality rather than any constitutional grounds. Another case, which had been heard by the Supreme Court, proved to be much more important. Even though it did not deal with abortion, it provided them with the constitutional grounds they were seeking to build their case. Griswold versus Connecticut was a challenge to a 100-year-old Connecticut law that forbade the sale of birth control devices. The case was instigated on November 1st, 1961, when Estelle Griswold, executive director of the Planned Parenthood League of Connecticut, and Charles Lee Buxton, a respected physician,
citizen,
Yield to an
Yield
inquiry?
to an
I would
inquiry.
love to yield to an
Hey.
inquiry. Let me just finish the sentence. And Charles C. Buxton, respected physician and head of the obstetrics and gynecology at Yale University, opened a clinic in New Haven, Connecticut, from which they plan to provide people with birth control information and dispense contraceptives. Okay, I finished my sentence. You can pick it up right there at they. And here's a flashlight if you need it.
all right. I think I need my glasses.
Okay. I gladly yield to my fellow Missouri filibusterer.
I'm Cynthia Wilcox. I'm from Jefferson City, Missouri. Within days of opening the clinic, Griswold and Buxton were arrested for giving birth control information and instruction to a married couple. They were tried in the Connecticut courts where they lost and from which they appealed to the Supreme Court. Two respected and talented women, Harriet Pilpul and Catherine Roraback, originally handled the Griswold case, but when it became apparent the case was headed to the Supreme Court, Planned Parenthood acquiesced to the commonly held belief that women should not argue before the Supreme Court and look for male legal counsel. They found Fowler Harper, a law professor at Yale and First Amendment specialist, who believed the case could be argued on the ground that denying a doctor the right to discuss and inform patients about birth control interfered with his right to free speech. The lawyers decided to structure their case around the First and 14th Amendment. They also toyed with the idea that the case involved privacy, but felt it was too shaky and unestablished a right to use it. Even though they were mounting a test case designed to challenge the Connecticut law, they owed their clients the best possible defense. They would have done nothing further about privacy had Fowler not seen a law journal article by the respected New York University law professor and later dean, Norman D. Redlich, entitled, "Are There Certain Rights Retained by the People?" It suggested an alternative interpretation of the Ninth Amendment, which was traditionally read as reserving to the states any powers not specifically ascribed to the federal government. Redlich suggested that the Ninth Amendment reserved unspecified rights to the people, not the state. His thinking meshed neatly with the idea of a privacy right, and after reading Redlich's article, Fowler was convinced they should not use the Ninth Amendment and, more important, should base their defense on the idea of a privacy right. Even though the Constitution said nothing directly about privacy, Fowler, along with many other constitutional scholars, was increasingly certain that a privacy right could be inferred. The grounds of the Griswold case were expanded to include all possible constitutional references to privacy: the First, Third, Fourth, Fifth, Ninth, and 14th Amendments. In two earlier challenges to the Connecticut birth control law, State versus Nelson and Poe versus Ullman, decided in 1939 and 1961 respectively, the issue of privacy had been touched upon. In State versus Nelson, J. Warren Upson, Nelson's lawyer, had filed a pleading in which he had argued that the right to decide to have children and committedly the right to use contraception were natural rights with which the state should not be permitted to interfere. Poe versus Ullman was appealed to the Supreme Court, reluctant to become embroiled in the birth control controversy. After hearing the oral arguments, the court sidestepped the issues and declined to decide the case on grounds that it presented no real controversy. Justice William Douglas wrote a strong dissent that echoed Upson's thinking about natural rights and privacy. It was not until Justice Douglas wrote the Griswold opinion in 1965 that he and the High Court finally articulated the privacy right. The The Connecticut statute prohibiting the use of birth control was unconstitutional, he wrote, because its enforcement violated the zone of privacy created by several fundamental Constitution guarantees. Among the grounds he cited as support for a right of privacy were the First, Third, Fourth, Fifth, Ninth, and 14th Amendments. The privacy right looked good to Weddington and Coffey. If they followed the thinking in Griswold, they would not have one but several solid constitutional grounds on which to base a woman's constitutional right to abortion. The Griswold case seemed so uniquely tailored for the development of an abortion right, in fact, that at the time it had been rendered, it had set off speculation in scholarly circles that the Supreme Court might be using the case as a signal to civil rights lawyers, an indication that after years of rejecting abortion cases, the court was at last willing to hear one. Tom Emerson, the Yale law professor who took over the Griswold case when Fowler died in 1963, argued it before the Supreme Court, wrote about this theory. In an article entitled 9 Justices in Search of a Doctrine, Emerson suggested that no other explanation was adequate to describe why the court had taken a case like Griswold. At minimum, the nation's top court wanted to hear cases of national scope, and the Connecticut birth control case certainly did not qualify. No other state had a law even remotely similar to Connecticut's archaic law banning the use of birth control. Nevertheless, reasons existed not to rely entirely on Griswold to build their case. For one thing, it was at the time and remained one of the more controversial cases the court had ever decided, garnering some of the most unqualified praise and severe criticism of any Supreme Court decision in years. Constitutional scholars were sharply divided over the existence of a privacy right. The decision's defenders applauded the court for having acknowledged a right they believed existed even though it was not specifically written into the Constitution, while its critics were appalled to think that the Supreme Court had created a right where, in their eyes at least, none of it existed previously. They could not believe that a right not mentioned anywhere in the Constitution, and one about birth control no less, could be enshrined alongside such treasured values as freedom of speech or equal treatment under the law. Even some scholars who acceded to the idea that privacy was a constitutionally protected right still felt that the idea of marital privacy, let alone sexual privacy, went too far. It was true, as those local constructionists, those who thought the Constitution was subject to broader interpretation, maintained that the Constitution said nothing directly about marital privacy, birth control, or, for that matter, abortion. For privacy was not an entirely new constitutional concept. Without giving it a name, the Supreme Court had been deciding privacy cases for decades. Many jurists trace the concept of legal privacy to Justice Louis Brandeis's famous dissent in the 1928 case, Oland v. United States, in which he wrote that the American people had the right to be let alone. Douglas seemed to have anticipated this criticism because, in the Griswold opinion, he listed several notable Supreme Court rulings that had supported a right to privacy. Pierce v. Society of Sisters, which established the right of parents to educate their children as they saw fit, and Meyer v. Nebraska, which established the right to teach a foreign language. Another drawback to using privacy was its newness. Even apart from the controversy surrounding it, privacy was a relatively undeveloped area of the law. No one could predict how the right would fare with time, whether it would take hold as an established constitutional principle or fade away within a few years. No one even knew the best way to present in a courtroom, possibly to a judge who was not familiar with it or inclined to accept a new legal concept. Countering this drawback was the fact, revealed in even the most cursory review of family law decisions, that privacy, whether or not it was called for, was still the pillar that held up many family law cases. In a sense, Weddington and Coffey had no other viable ground for the establishment of an abortion right. They decided to use it. As for the specific amendments that Douglas had listed in the Griswold opinion, they too seemed well suited to an abortion case strategy. Coffey and Weddington had originally thought they might base their case entirely on the 14th Amendment, but experts with whom they had talked, especially Harriet Patel, who had pioneered in the birth control area, felt that a better tactic would be to give the court as many potential grounds as possible for deciding the case and let it choose among them, from among them. Prior to Griswold, lawyers had tended to go into court with one solid ground on which a decision could be based. But once Douglas had described privacy as a fundamental right, protected not by one amendment, but by penumbras from several amendments and even the entire Bill of Rights, constitutional lawyers changed their approach and tried to offer as many grounds as they could think of finding a law constitutional. Weddington and Coffey thought the strategy might work equally well in a federal three-judge court. Support for using an array of grounds also came from another source. A young University of Alabama law professor named Roy Lucas, eager to make a name for himself in abortion reform, published an article in the June 1968 North Carolina Law Review in which he described several potential grounds for legalizing abortion, most notably the First, Fourth, Fifth, and 14th Amendments. Lucas was the first to write about the grounds for a constitutional challenge, but it would not be fair to say that this line of thinking originated with him. The idea of developing constitutional grounds to challenge the abortion law was very much in the air, particularly among East Coast abortion lawyers such as Harriet Patel, ACLU lawyer Melvin Wolfe, and the New York Law School professor Cyrus Means, with whom Lucas had contacts. Nevertheless, Lucas' article had become something of a Bible for constitutional scholars working on abortion, one that Coffey and Weddington would have had trouble overlooking in their research since there were so few sources to turn to. In our talks, however, neither Weddington nor Coffey could recall having relied on Lucas's article, but even if they did not use it directly, it seems unlikely they would not have been influenced by it, if only by hearing about it secondhand. Once Coffey and Weddington had decided on the potential grounds, they actually spent little time mulling them over. Theirs was not the kind of case that invited intense scholarly research. Far more important concern was that they get their case underway while Norma McCaffrey was still pregnant. The two women read enough about each amendment to make sure they understood its application and to decide whether or not to use it. The First Amendment protected free speech, including people's right of association. Some jurists felt the abortion law interfered with the freedom of association between a woman and her physician, but many legal scholars thought it was a weak basis for overturning the abortion law, even though Douglas had written extensively about First Amendment rights in Griswold. Patel disliked using the First Amendment, for example, and Emerson thought it was a poor line of reasoning, one that did not provide a favorable opportunity for pressing forward in abortion reform. Coffey and Weddington were not eager to tie an abortion rights to physicians any more than they had to, but they saw no reason to exclude this argument. The Griswold opinion also relied on the Third, Fourth, and Fifth Amendments. The two women decided almost immediately to discard the Third Amendment, although it dealt with privacy by denying the government the right to quarter soldiers in people's homes during peacetime, it had no real tie to abortion. They planned to use the Fourth Amendment, which protected citizens from unreasonable search and seizure, and the Fifth Amendment, which protected people from self-incrimination, largely because both had been mentioned in Griswold. In the opinion, Douglas had questioned the extent to which the state would have to go to enforce anti-contraception law, asking, would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The idea of doing that, he continued, was repulsive to the notion of privacy surrounding the marital relationship. A parallel situation occurred with laws restricting abortion. Coffey and Whittington felt in that enforcement of the abortion laws involved invading the privacy of the physician's office. The Griswold opinion held that the self-incrimination clause of the Fifth Amendment protected the privacy right by creating a zone of privacy around citizens that protected them from government intrusion. Coffey and Whittington would use it. Their own contribution was to include the Eighth Amendment, which forbade cruel and unusual punishment. Both women knew that no judge was likely to rule that denying women abortion was cruel and unusual punishment, but they thought its inclusion made a poignant point nonetheless. They were less certain about using the Ninth Amendment, even though Douglas had included it in his majority opinion, and it had been the focus of concurring opinion by Justice Arthur Goldberg. Their reluctance to use it was based mostly on the fact that they knew so little about it. Often considered the amendment that created states' rights, the Ninth was rarely used. Neither woman had seen Redlick's article that had influenced Fowler to use the Ninth Amendment in the Griswold event, nor did they know that the Ninth was generating excitement in academic circles where constitutional scholars were beginning to talk of putting it in more expensive use. They only knew that Griswold was one of the rare occasions when the Ninth Amendment had been used to overturn a state law, and that did not seem to bode well for their purposes. In Texas, where abortion was already viewed as a states' rights issue, the Ninth Amendment was interpreted as reserving to the states all powers not specifically granted to the federal government. Coffey and Whittington were sure that even if they could prove that the present law was unconstitutional, the state of Texas would still be able to turn a strong claim that the writing of a new law was up to the state legislature. And the state lawyers might even argue that the court had no business striking the law. That is, too, was the province of the legislature. Opponents would always maintain that abortion should be regulated by the states. They viewed any kind of federal court ruling to this issue as benign. Using the Ninth Amendment to strike the abortion law would, as far as the state was concerned, be like waving a red flag in front of a bull. Despite this, both women saw that the Ninth Amendment offered a substantial ground for recognizing the right to privacy and decide they had to use it. The constitutional amendment that offered the most support for overturning the abortion laws, at least in the eyes of many legal experts, was 14. Generally, it guaranteed every person equal protection under the law. Specifically, the Due Process Clause of the 14th Amendment required that laws be written clearly enough for the average person to understand. A law that was vaguely written, for example, was unconstitutional because it caused confusion about who was protected by it and the circumstances under which protection was extended, the very thing physicians objected to about the abortion laws. They argued that they were forced to interpret the laws each time they performed an abortion. Physicians claimed confusion arose over what constituted a life-threatening illness because the laws offered no clear-cut guidelines and, as a result, were unevenly applied. Some physicians interpreted the law in its strictest sense and did abortions only when a woman's life was truly threatened, while others stretched the law to cover situations that might not be life-threatening, instances where a woman claimed her mental or physical health was in jeopardy, for example. From a physician's point of view, therefore, the 14th Amendment offered the best basis for overturning the abortion laws. Coffey was afraid, however, that any ruling based on the 14th would leave control of abortion in the physician's hands rather than in the hands of women, where she believed it belonged. If they got a ruling based on the 14th Amendment, she feared there would be nothing to stop the Texas legislature from writing a new crystal clear law, possibly with the assistance of physicians, that still left the abortion decision in the hands of doctors and undermined the right of women to decide for themselves. Coffey, who wanted at least to make a stab at establishing a woman's constitutional right to abortion, had no trouble persuading Weddington to share her view. Both women had come to believe that a woman had a right to control her own body, which included the decision to terminate a pregnancy, but they were less sure that the general populace or even a liberal court would share that conviction. So rather than risk everything, they opted to follow a more conservative action and include the 14th Amendment with all its potential risks to women. They developed a strategy in which they would stress those amendments that addressed a woman's right to abortion in their oral arguments, but would also be prepared to fall back on the 14th Amendment if necessary. In part, they chose this strategy because it would enable them to use two major decisions that were handed down as they were preparing their own cases. These involved abortion laws that had been declared unconstitutional on the grounds of vagueness, but in each lawsuit, the courts had also had something interesting to say about women's rights to abortion. In People v. Ballous, handed down in September 1969, Dr. Leon Ballous, an obstetrician gynecologist practicing in Los Angeles, was indicted for abortion. The case drew nationwide attention in part because the physician involved was so respected, but also because this was one of the rare occasions when the law interfered with a physician's right to practice medicine. In this instance, the physician had not even performed the abortion himself, but had merely referred a patient to an illegal abortionist. A former Navy commander in the medical corps during the World War II, Ballous was chief of obstetrics and gynecology at Cedars of Lebanon Hospital when he was indicted. He had long thought physicians were hypocritical in their treatment of women who requested abortions, and although he did not perform them, he had begun openly to refer their patients to skilled illegal abortionists. Ballous, who appeared frequently on local radio and television shows, made his reviews widely known. Early in 1967, Ballous was contacted by a couple who said they desperately needed an abortion and threatened to seek one on the black market if that were all they could obtain. Initially, Ballous said he could not help, but then he relented and met with the woman to examine her and confirm her pregnancy. He referred her to a Dr. Carl Laritas, a licensed physician from Mexico who had recently moved to California. Ballous wrote a prescription for an antibiotic and encouraged the woman to see him for a post-surgical checkup. She contacted Dr. Laritas and arranged to undergo an abortion in his office. While she was resting in his office after the surgery, the police, who had been tipped off by another patient, raided the office and arrested Laritas. They seized his notebooks, which led them to an entry naming Ballous as the referring physician. Ballous was also arrested and charged with being an accomplice to an illegal abortion. A 3-year legal struggle ensued, during which Ballous was supported by the American Civil Liberties Union as well as his own counsel. In the first trial, a municipal court judge dismissed the case on the grounds that Ballous's office had been searched illegally. The district attorney then convened a grand jury and re-indicted Ballous on the woman's testimony that he had referred her to an illegal abortionist. Deleuze was convicted by a Roman Catholic judge in Superior Court, and on appeal, his conviction was upheld by an appellate court, in which 2 of the 3 sitting judges were Roman Catholic. Deleuze then took his case to the California Supreme Court. He insisted his defense be made on constitutional grounds, specifically a woman's right to receive medical care. On September 5, 1969, in a 4-3 decision, the California Supreme Court ruled that the California abortion law was unconstitutional on grounds that it was vague under the Due Process Clause of the 14th Amendment. The court decided to say that abortion should be regulated in any way except for the fact that it should be performed by a licensed physician, noting that 178 deans of medical schools had filed a friend of the court brief supporting Deleuze and a more liberalized abortion law. The California court commented that the law had always recognized that the pregnant woman's right to life takes precedence over any interest the state may have in the unborn. The present state law, the court said, must be rejected as an invalid infringement upon the woman's constitutional rights. Proponents and opponents alike were surprised by the unequivocal note struck by the Deleuze decision. No one had anticipated such a broad ruling or such a clear-cut victory for pro-choice forces. From Coffey and Weddington's perspective, however, the most important thing about the decision was that for the first time ever, a court had directly addressed the issue of a woman's constitutional right to abortion. More important, the court stated that her right was based on privacy. The Deleuze case also marked a turning point in abortion reform. Previously, reformers had focused on the state legislatures as a means of changing the abortion laws, but now they read the California Supreme Court decision as a sign that they might make more progress in the courts. Many reform lawyers would jump ship from the state legislatures and chart a new course that would send them sailing straight into the federal courts. Within the next year or so, the Supreme Court was going to receive a lot of requests to docket abortion cases. The other case, U.S. v. Vooch, involved a licensed physician, one who practiced in the nation's capital. C. Milan Vooch, who was licensed in Washington, D.C., Maryland, New York, and Virginia, had been operated several abortion clinics, one within blocks of the White House. Vooch was a flamboyant, essentially anti-establishment character who had performed abortions in Yugoslavia before they were legal there. He immigrated to the United States after marrying an American woman. In 1957, having retrained as a physician here, he performed his first abortion in the United States. Vooch felt that a loophole in the Washington, D.C. law permitted abortion to preserve a woman's health as well as her life, and that the abortionist he was doing were legal. He invited arrest by openly performing abortions in his clinic and by taking referrals from problem pregnancy counseling services and physicians all over the country. So sure was Vooch of his rights that he openly ordered a test case. On May 1st, 1968, while he was operating on a patient in his office was raided. Because Washington, D.C. was federal territory, Vooch was arraigned in federal court. His first court challenge was successful. On November 10, 1969, Judge Arnold Gessel of the U.S. District Court of the District of Columbia ruled that the Washington, D.C. law was unconstitutional because of vagueness. He further declared that the law provided no clear standard to guide either the doctor, the jury, or the court. There has been, moreover, an increasing indication in decisions of the Supreme Court of the United States that as a secular matter, a woman's liberty and right of privacy extends to family, marriage, and sex matters, and may well include the right to remove an unwanted child in the early stages of pregnancy. The Vooch ruling was important because it was the first time a federal court had overthrown an abortion law. abortion reformers across the country took heart because not one but two abortion laws at opposite ends of the country, no less, had been overturned on the grounds that they were unconstitutional. While Coffey and Whittington still had grave doubts about using vagueness as a reason to overturn the abortion laws, they no longer had any doubts about whether the courts were willing to tackle abortion. Ballous and Vooch gave great impetus to their case, and they knew it. Like most pro-choice reformers, and like many women, in fact, Coffey and Whittington tended to dismiss arguments about the fetus's rights, which were, they felt, always inferior to the woman's. Still, they knew that the subject of fetal rights was almost always sure to be raised by the state at some point during the hearing, and they had to be prepared to respond to it. Based upon the Constitution, birth appears to be the point at which a human was entitled to the legal rights of a person. This was also the case in most religions, they knew, but they did not want to broach the issue of religion in court if they could avoid it. The 14th Amendment defined a person as anyone born or naturalized. It was true that property or other rights had been accorded to fetuses, but the assumptions of these rights had always been dependent upon his live birth. There were no cases where rights were granted to a fetus purely on the basis of being a fetus, for the simple reason that, in the eyes of the law at least, it was not yet a person. While the issue of whether or not a fetus was a person was relatively clear-cut from a legal standpoint, it was far less so elsewhere, especially among philosophers and ethicists. On the one hand, Coffey and Whittington worried that the state would raise non-legal and perhaps emotionally explosive issues of fetal rights. On the other hand, if they themselves stayed with purely legal arguments and did not acknowledge the emotional element, they might also lose the support of some women. Any woman who's ever been pregnant, even unwillingly, can attest to the fact that her feeling for the unborn fetus in her womb are far more complicated than any law can possibly allow for. Many people who fully supported a woman's right to abortion were not so clear about whether the fetus had no rights at any stage of pregnancy. Whittington and Coffey were all too aware about the shades of gray that colored the abortion issue generally and the issue of fetal rights specifically. They knew they would have to walk a tightrope while balancing the unemotional stance of the law and the emotional views of those persons. Because of this, they decided to approach any discussion of fetal rights cautiously, using only the broadest possible terms in order to give as many people as possible room to support a woman's right to abortion. In fact, this decision was made out of respect for each individual woman's right to decide when an abortion was appropriate for her. In part, it was done out of political silence. The two lawyers even agreed that, if pushed, they would acknowledge that some limits could be placed on the abortion right. At this early stage of preparing the case, neither woman was thinking in terms of total reform anyway. The idea that the state, or for that matter, physicians, would have nothing to say about the regulation of abortion was still unimaginable to Coffey and Whittington and most other reformers working on liberalization. Everyone seemed to agree that even if a woman's right to abortion could be established, it would still be a limited right, and one government could and would regulate, if only in the woman's best interest. The government, for example, could require that abortions be done only in a hospital or before a certain stage of pregnancy in order to protect a woman's health. As they got deeper into the abortion issue, Coffey and Whittington would each come to believe that the women's rights was unequivocal and should not be infringed upon by anyone, but they knew this was too radical a view to present in court, or anywhere else publicly for that matter. Only one other issue remained to be discussed: the discrimination women suffered because of the restrictive abortion laws. Whittington felt strongly that she wanted to stress this. Imbued with a deep sense of social injustice, she was acutely aware of how unmarried pregnant women were treated in our society, the fact that they were forced to drop out of high school or to attend alternative schools where they could not participate in school activities. Many colleges and universities would not admit unmarried pregnant women. Employers discriminated against them in their hiring practices, and of course, many of these same prejudices applied to married pregnant women. Weddington felt strongly that unless women could control when they bore children, they could not fully control their own lives, and she wanted to emphasize this as she prepared Norma McCovey's case. Coffey readily agreed that these were important issues. The two women worked well together despite the considerable differences of their personalities. Weddington, although not a particularly outgoing person, looked like an extrovert next to Coffey. She also wanted more outside support for their decisions and approached several of her former law professors at the University of Texas, as well as such New York reformers as Harriet Pill and Cyrus Means. Coffey, perhaps because of her greater legal experience, felt less indeed to rely on outsiders and was more wary of doing so. Although Weddington was not naturally given to dealing with all abstractions, the two women soon decided that she would research the merits of the case, while Coffey tackled the procedural legal issues such as standing and mootness, with which she was more familiar. If Coffey minded or even realized that Weddington was taking over the more glamorous aspect of preparing the case, she never acknowledged it, even to herself. Coffey soon determined that their case properly belonged before a three-judge court. These special courts, composed of 3 judges from one federal appellate circuit, had been established by the Three-Judge Court Act of 1910 as a response to the accelerated economic expansion throughout the United States since the end of the 19th century. 3-judge courts were also an attempt to resolve the struggle between the federal government and the states over who would regulate the burgeoning interstate commerce, or, to be more specific, an attempt to thwart the federal judges' powers to interfere with the states. The thinking was that 3 judges would act with greater caution than one and would thus serve as a check on one another's powers. In 1937, another 3-judge court act, as laden with political overtones as the first, required 3-judge courts to hear all cases involving challenges to the constitutionality of state laws. A companion law made them responsible for hearing challenges to federal laws. Although these laws were ostensibly part of the President Franklin D. Roosevelt's efforts to reform the court, in reality, they were a response to fears that federal district judges acting alone would strike down his New Deal legislation. From the beginning, 3-judge courts were an anachronism in the legal system. Shortly after they were established, other laws were passed that eliminated the problem of a single federal judge usurping the state's powers. But the 3-judge courts continued to exist even though they were rarely used until the 1960s. That was when civil rights lawyers discovered that they provided a unique time when the Supreme Court was proving to be especially sympathetic to civil rights suits. The 3-judge courts provided direct access to the top court in the land by allowing, in certain instances, specific parties to lawsuits to bypass the federal appellate court. Between 1955 and 1959, the average number of cases heard annually by 3-judge courts numbered a paltry 49. From 1960 to 1964, as the civil rights movement gathered strength, the average annual caseload expanded to 95. In 1970, at the height of the civil rights movement, 3-judge courts heard 162 cases on civil rights alone. In 1973, the year of Roe v. Wade decision, 183 civil rights cases were argued in front of 3-judge panels. The direct route of appeal to the Supreme Court was not the only reason Coffey and Weddington were happy that their case would be heard by a three-judge court. Once a three-judge court was convened, the judges were obligated to hear the case as soon as possible, even if doing so meant an interruption in their normal schedule. Because the judges were to suspend their regular work, they liked to dispense with cases as quickly and efficiently as possible. They were eager to avoid evidentiary trials and preferred to try cases on the law whenever possible. Short briefs were encouraged. Not everyone in the reform movement was happy with the haze that typically surrounded a three-judge court. In Georgia and New York, where abortion cases were then being tried before three-judge courts, lawyers were fighting a losing battle to force the courts to hear evidence they believed would strengthen their cases. The courts, less than enthusiastic about the political overtones of some of the evidence, depositions taken from women who had undergone illegal abortions, for example, were declining to hear it. But the idea of being able to move quickly through the system up to the Supreme Court, if it came to that, held greater appeal to Coffey and Weddington with each passing week. The Blues and Booch cases, with their widespread publicity, had created a sense of urgency over abortion. The nation's attention grew more intense with each successive decision, and anticipation was building for a Supreme Court decision that would settle the case. Coffey and Weddington were beginning to feel as if they were in a horse race, and having the right to go to a three-judge court seemed a little bit like winning pole position. They were also not happy that their case fell under the jurisdiction of the progressive Fifth Circuit, a bench that had proven particularly receptive to civil rights cases. Legal experts and later law justices of the Fifth Circuit as the real heroes of the civil rights movement, noting that it was they who had assumed responsibility for the day-to-day enforcement of the decisions handed down by the Supreme Court. One small point still bothered Coffey. Now that she had Norma McCovey, who was pregnant, did she still need John and Mary Doe, the young couple who had volunteered themselves as plaintiffs a few months earlier? Weddington thought that the Doe's case was weak because Mary Doe was not pregnant. The Coffey wanted to keep them and file two separate suits, one with McCovey and another with the Does. The two cases would eventually be combined, she realized, but she felt that filing two separate suits would improve her odds at drawing liberal or at least sympathetic judges. The judge in whose court a case was filed was, as a rule, appointed to the three-judge panel. To the extent that she could manage it, Coffey also wanted a well-rounded case. Ideally, she would have liked to have a physician on the case, but none had come forth to offer his services, and she had not pursued this. But at least her plaintiffs would include a pregnant single woman who by herself might be more easily discriminated against, and a married couple who was established and respected in the community. Many jurors thought that only a physician could sue to liberalize the abortion laws, since they and legal abortionists were the only ones who could be punished under the law. The women who attempted to obtain an abortion was, in all but a few states, immune from prosecution. If she could not be prosecuted, she could not be injured, or at least legally by the law. Since no one had to suffer a direct injury under the law in order to sue, lawyers had for years backed off from abortion cases involving pregnant women plaintiffs because they thought such cases could not be won. Coffey and Weddington were convinced, however, that only by using a woman as a plaintiff could they establish that the laws outlawing abortion denied women their constitutional rights. They believed they would make a case that the woman was injured by the state's abortion laws, and that, as she had no other form of relief, the court had no choice but to consider her interests. In late February 1970, Weddington and Coffey were still working on the case, almost obsessively checking and rechecking facts and technical legal points. They might have taken even longer, but Coffey had not received a call from Ruth Iyer, a reporter at the Dallas Times-Herald, one of the two major Dallas dailies. She had heard of their case and wanted to write about it. The fact that the press was about to break the story when they had not yet filed the case set Coffey in motion. She sat down one night after work and typed out the pleading. In one of our conversations, she would muse that she did not know why she had rushed to file the case before the reporter broke the story rather than 1 or 2 days afterwards. But perhaps it was the kind of pressure she needed at that point to prod her into action. The typographical errors stood uncorrected. All legal phraseology was checked and rechecked. Coffey spent every spare minute of the next few days writing the original pleadings, which listed the plaintiff's complaints and the legal action they sought to remedy these complaints. Since Weddington did not live in Dallas and was working full-time, she could not help. On Tuesday, March 3, 1970, Coffey gathered up the papers and carried them to the federal courthouse to file the original pleadings on the 2 separate suits, Roe v. Wade and Doe v. Wade. The plaintiffs asked for a declaratory judgment stating that the abortion statutes of Texas were unconstitutional and an injunction restraining Harry Wade, the chief law enforcement officer of Dallas County, from enforcing the laws. They claimed that the Texas statutes were unconstitutional on grounds that they were vague and abridged their right to privacy under the 1st, 4th, 5th, 8th, 9th, and 14th Amendments. The first reaction came, not surprisingly, from the conservative Dallas Times-Herald, which ran an editorial on Friday, March 6, noting that the abortion laws were badly in need of intelligent overhaul. The paper still found itself opposed to the suit. We have no sympathy with the attempt of a married couple and of a single woman to get the existing abortion law declared unconstitutional by Dallas federal court. Specifically, the paper took issue with the fact that the plaintiffs were disguising their identities with fictional names. The newspaper's real objections to this case, however, seemed to be that so serious a social problem was being tossed in the hands of a few judges. On March 16, 1970, District Attorney Henry Wade was officially served papers notifying him that he was being sued by plaintiff Jane Roe and John and Mary Doe, who were seeking a court order to prevent him from prosecution of future abortion cases. If law enforcement officials could not enforce the abortion laws, then Jane Roe would be free to obtain an abortion from a licensed physician. Wade had been district attorney of Dallas County since 1950, when he had run as a young upstart lawyer. Everyone, politicians and voters, acknowledged that he ran a tight ship. In fact, Wade's staff was unusually good for a district attorney's office. Several of Dallas's crack criminal lawyers had done a stint with the chief at one time or another. His office was considered an excellent training ground for a criminal lawyer. Wade was also famous as the prosecutor of Lee Harvey Oswald, President J.F. Kennedy's assassin, and Jack Ruby, who had killed Oswald before he would come to trial. If Wade, the father of 3 daughters and 2 sons, had any personal animosity against abortion, it never showed. A Democrat, he had supported Adlai Stevenson, and his wife was a professional volunteer whose primary cause was poor and homeless people. Wade was a self-made man with Calvinist roots and values. Like most Texas men of his upbringing and class, he was no admirer of feminists, but there were signs he did not dislike them and may even have had a grudging respect for them. During jury selection for Jack Ruby's trial, another lawyer urged Wade not to accept a woman who is, she was Ms., not Miss, because Wade rejected the idea saying, nah, she'll be just fine. Little woman's livers want to be tough as men. For several years, Wade's office, like many district attorneys' offices across the country, had instigated virtually no abortion prosecutions. District attorneys typically prosecuted an abortionist only when a complaint was filed by a police department, and that only happened when a woman showed up, usually at a large metropolitan hospital with a badly bundled abortion, and was willing to talk to the police about what had happened to her. Few women, even those who were seriously injured or maimed, were willing to press charges and risk having their plight become public knowledge. In the 1960s, most women who underwent illegal abortion were unmarried, and pregnancy for an unmarried woman carried social stigma for her and for the child if she chose to bear it. When a woman did press charges, the case invariably became a cause célèbre, and one such case every few years served to keep the illegal abortion under control in a community. These notorious suits also serve to paint an image in most people's minds of illegal abortion as a dangerous, risky procedure, a notion reformers did little to refute. When I began to look into this aspect of abortion, several pro-choice reformers suggested that illegal abortion was not as dangerous as had been depicted during the reform movement. Admittedly, an image of tens of thousands of women being maimed or killed each year by illegal abortion was so persuasive a piece of propaganda that the movement could be forgiven for its failure to double-check the facts. The exaggeration was also a safe one. Since these were illegal activities, no records were kept, and the death and injury rate was an impossible statistic to pin down. When a woman required medical treatment as a result of an illegal abortion, her physicians often disguised the facts on her medical record so as to spare her any embarrassment.
Would the citizen recognize the sister for a question?
Yes. Right there.
My name is Sue Gibson. Birth control expert Linda Gordon has investigated the idea that the rate might not even have been as high as the 8,000 to 10,000 deaths that were attributed annually to illegal abortion. She concluded that abortions done after the mid-19th century were not particularly safe or life-threatening, largely because women had stopped using abortifacients, toxic chemicals that affected the body's entire system to terminate pregnancies. Abortifacients were the most popular as well as the most dangerous method of abortion. By the end of the 19th century, few women were using abortifacients, largely because the regular physicians had successfully driven the midwives out of practice and bought pharmacists under their control, to the point where medicines were administered and sold only under the direct orders of a physician. Another factor that may have reduced the dangers of illegal abortion was suggested to me by several physicians. As abortifacients fell into disuse, surgical abortions replaced them. The restrictive laws passed between 1860 and 1880 did not alleviate abortion so much as drive it underground. And if one stands by the accepted medical belief that the surgeon who does the greatest number of operations and is thus able to maintain and even hone skills is the best qualified, then women have probably been better off in the hands of competent but illegal abortionists who did hundreds of the minor surgeries every week than with the family doctor who did one abortion a year. Even the new techniques, such as antisepsis in the mid-1800s and vacuum aspiration in the mid-1960s, found their way to the offices of illegal abortionists. The failure to strictly enforce the abortion laws then was at least partly a reaction to the public's changing perception of abortion. People heard less about disastrous abortions because fewer women were subjected to them. Fewer cases were prosecuted, and people became more receptive as a result. to the idea of liberalizing the abortion laws. The change in the public's attitude, in turn, contributed to a growing disinterest on the part of law enforcement agencies, who had never been very concerned with pursuing what was essentially considered a victimless crime. Even though it was not actively enforcing the Texas abortion law, the district attorney's office could not be described as receptive to a challenge to it. In the 1960s, most states' law enforcement agencies, including the Dallas District Attorney's Office, looked upon the numerous civil rights challenges that began coming their way as frivolous. They resented the time they took up. Nonetheless, given the times, Henry Wade's office had been expecting some kind of attack on the laws that discriminated against women. They thought perhaps women would strike out against protectionist labor laws. No one thought the abortion law would be challenged, and it came as a shock when it was. There had been no sense among the conservative, mostly male lawyers in the DA's office that any major discontent had been building among women regarding abortion. Besides, they tended to view the state's abortion law not as discriminatory against women, so much as a statement about the moral standards society wanted to uphold. As a result, just as Weddington and Coffey had hoped, Wade's office was totally unprepared for their attack on the state's abortion laws. And from the minute Roe v. Wade and Doe v. Wade were filed, Wade and his staff recognized that these were serious challenges and therefore potentially significant cases. The Attorney General's office quickly learned that Coffey and Weddington were reputable, capable lawyers, and that Coffey had clerked for Judge Sarah T. Hughes on the Fifth Circuit. The pleadings were carefully thought out and well written. However, this is not to say that anyone in the district attorney's office thought for a minute that the abortion laws stood a chance of being overturned. They did not, and they were sure they would prevail in any courtroom. Still, it was clear this was no frivolous lawsuit. None of this helped anyone's mood in the DA's offices when Henry Wade was served the papers. Wade's lawyers, who usually went to trial for murder, armed robbery, or rape, did not want to waste their time on a challenge to a nearly defunct, century-old state law. It was typical of Wade, however, not to slight the case, not least because a federal lawsuit against him had recently slipped through the department's hands. Henry Wade had learned of it only when a judge called him and asked if he knew he was being sued for $50,000 and that no one in his office had responded to the complaint. After that, Wade assigned one of his brightest assistant DAs to work full-time on federal lawsuits brought against county officials. The abortion suit went to John Tolley, handpicked by Wade to handle the federal cases. After what had happened to his predecessor, Tolley knew that Wade was looking over his shoulder. To add insult to injury, Wade always pretended to confuse Tolley, who had straightened out the whole mess, with the assistant DA who had created it. Wade never let an opportunity pass to remind Tolley and anyone else within earshot of the day when he, Henry Wade, District Attorney of Dallas County, almost had to pay $50,000 out of his own pocket because one of his employees had not taken care of business. With Tolley at the helm, Wade was not in any danger. Tolley, who would later become a federal magistrate in Dallas, was one of the more competent lawyers in an office that was not suffering from incompetency. A native Dallasite, he only decided to go to law school at age 30 after serving in World War II and working for a few years in his father's tavern. He attended Notre Dame as an undergraduate and Southern Methodist University Law School. Recalling that the Catholic Church had not yet actively begun its anti-abortion campaign, and his own feelings were not well enough formed to influence him one way or the other, Tolley told me that being a Roman Catholic did not affect his handling of the case. Lower key and seemingly less aggressive than most prosecutors, Tolley was nonetheless an accomplished trial lawyer. He was a blunt-spoken man of wry humor, someone who was capable of asking the woman he loved to marry him during the summer he graduated from law school, because as he noted during the proposal, what with law boards and job hunting, the summer was shot anyway. Tolley thought he could build a case around the right of the fetus to legal protection. He would cite tort cases, ironically, the same tort cases that pro-choice lawyers relied on to build their cases, showing how postnatal damages had been awarded to prenatal fetuses. On occasion, when a fetus was presumed to have been injured in the womb, some courts had awarded them damages, although the payments and inheritance rights were always conditional upon live birth. Tolley also believed, mistakenly as it turned out, that the abortion restrictions had been around for a long time in the common law, and that however much they were ignored, there was a long-standing precedent for their existence, one that a court of law would not find easy to overturn. It was one thing, he believed, to ignore the abortion laws, another to eliminate them. He did not think public morals had changed so much that people would be willing to enshrine abortion among our nation's protected rights. The idea of a privacy right had not sufficiently permeated the district attorney's consciousness, and it never dawned on Tolley to prepare a defense against a claim that women were entitled to abortions on that ground. Besides, privacy was not exactly the kind of legal right to which prosecutors were inclined to pay much attention. Their lives were much more affected by the Miranda ruling, for example, which touched on every single criminal proceeding they handled, than by a ruling that overturned an obscure Connecticut law on birth control, and thereby, in the eyes of a few legal scholars, created a new right of sexual privacy. Privacy would strike most prosecutors as a soft, sissified kind of law when compared with the hard-hitting, reality-filled law they dealt with every day. Illegal search and seizure they thoroughly understood, but the idea of a right of privacy, for the most part, eluded them. To prepare the case, Tolley surveyed the medical literature on abortion. He concluded there was nothing new that would lead him to believe an attack on the abortion laws would succeed. The physicians to whom he talked always agreed that the fetus was a separate being from the woman. Indeed, if that were the question, there was little chance that any physician would disagree with Tolley's thinking. The fetus was indeed a separate being from the woman. No serious scientist would dispute that biological fact. Tolley did not think, as many women did, that such a simplistic question only begged the issue, which was the degree of control a woman was entitled to exert over this being that existed inside her body. After surveying the issues that he saw as defining the case, Tolley came to the conclusion that the best approach was to argue that the fetus was a separate human being with every bit as much right to live as the woman in whose uterus it was carried. Once the fetus's right to live had been established, he thought, then the woman obviously had no right to control it. If he had to give ground anywhere, he might yield to the point of admitting that the rights of the fetus had to be balanced against the rights of the woman. Never did he think, nor could he imagine, that any court would accept the notion that the woman's rights might prevail over those of the fetus. On March 18th, Judge John R. Brown, Chief of the United States Court of Appeals for the Fifth Circuit, named the justices who would form a three-judge panel to hear the two cases, which were consolidated. On March 23rd, On March. That's all right.
Well, that's fine.
No idea when.
Start from the beginning?
Do you mind taking my glasses?
No, of course not.
Thank you. Okay. In what he called Wade's original answer, Tolley wrote that the facts of the case were unproven, that the defendant did not know that Roe was unmarried, that she wanted to terminate her pregnancy, that she suffered from economic hardship, or even that she, as far as he was concerned, was a real person. The district attorney also stated that the plaintiff, Jane Roe, lacked the standing to sue because the Texas abortion statute affected only those persons who performed abortions, not the women on whom they were performed. No woman could be prosecuted under Texas law for obtaining an abortion, legal or illegal. Only the person who performed an abortion could be prosecuted. As a result, the district attorney's position on what might turn out to be the most controversial issue in the case. As far as the state of Texas was concerned, Jane Roe might have a complaint about the restrictions the abortion laws placed on her personally. But under Texas law, she had no government official or agency or court to whom she could complain legally.
I'll go grab the podium.
Finally, Tolley contended that the Texas abortion laws were not vague or unconstitutional. Implied but not stated was an assumption widely held by law enforcement agencies and others who opposed legalized abortion, that if the abortion laws had been on the books for a century without a serious challenge, that alone was proof that they were not vague or unconstitutional. The next day, the state of Texas, sister, would you like to be recognized for a question?
Okay, I was going to hold it up for you, but yes, I would like to be recognized as a citizen. May I be recognized for a question?
Certainly, my sister.
And where we should do stuff. Okay. Finally, Paul contended that the Texas abortion laws were not vague or unconstitutional. Implied but not stated was an assumption widely held by law enforcement agencies and others who opposed legal abortion, that if the abortion laws had been on the books for a century without a serious challenge, that alone was proof that they were not vague or unconstitutional. The next day, the state of Texas, a party to any suit in which a state law is challenged, moved to dismiss the case involving the married couple on grounds that no actual justifiable controversy existed. Interestingly, the Attorney General did not file a similar motion in Roe, Norma McCovey's case, presumably because it was not so sure that she, who was at least allegedly pregnant, did not have standing to sue the state of Texas. The charge of no controversy was the same one employed by the Maricopa County lawyers in the Finkbein case 6 years earlier. For a lawsuit to be valid, it must involve some actual legally recognized controversy. People cannot sue simply because they do not like a law. They must be able to prove that a law injures them directly in some way. Courts do not waste their time and taxpayers' money on suits that do not involve real injuries. The charge was that plaintiffs had no standing to sue was the one that Coffey and Weddington most feared, primarily because it would end their challenge to the abortion law because it even reached the court of argument, before it even reached the court of argument. It was with some relief then that they learned someone wanted to intervene in their case. An intervener is someone who, because of a related interest, asked to join a lawsuit already in progress. If permission to intervene is granted by the court, the intervener is then given full status as a plaintiff. The prospective intervener was a licensed physician named James Halford, who had been indicted by District Attorney Wade on 2 criminal counts of abortion. Halford, then in his 40s, was a graduate of Southwest Medical School. At some point in his career, Halford's medical practice became devoted entirely to abortion. No one I talked to about Halford knew for sure why he started doing abortions. He told one of his lawyers that he had become concerned about illegal abortion in 1958 when, as a medical student at Parkland, a large metropolitan teaching hospital in Dallas, he had seen several women brought in each week suffering from illegal abortions at the hands of unskilled abortionists. He observed that most of the women were poor and could not afford a good abortion. Halford observed that most women had already made up their minds to get an abortion by the time they had come to him. So for him at least, the issue boiled down to whether he would provide his patients with an abortion that was safe and antiseptic, or let them risk an unsafe, possibly septic surgery at the hands of an untrained abortionist. I could not ask Halford personally about his life as an abortionist because he left the Dallas area without a trace about 10 years after the case. No forwarding address could be located for him. His lawyers no longer had contact with him, although one had successfully defended him against drug charges brought by the local medical association a few years after the abortion case, and no professional association knew his whereabouts. Whatever his motivation, word had gotten around Dallas that Halford would do abortions, that he was a licensed physician, and that his fees were reasonable. As one of the city's primary sources of illegal abortion, he was a prime target for a legal crackdown. Halford was indicted on charges that he had performed abortions illegally on 2 occasions about the time that Coffey and Weddington were preparing to file their abortion suit. In such cases, it was usual for the district attorney to file multiple indictments. That way, if one did not hold up in court, there was a backup. The doctor was not given any notice of an impending raid, which many people read as a sign that the district attorney was getting ready to crack down on illegal abortions even before the case was filed. Although law enforcement agencies did not generally go out of their way to let hardened criminals know they were about to be arrested, they sometimes took a gentler tack with licensed physicians who discreetly ran private abortion clinics, giving them warnings so they could close down temporarily if they chose to do so and thereby avoid arrest. Halford's attorney was Fred Bruner, a man who knew his business well after having worked in the DA's office for several years. Assisting him was a younger lawyer named Roy Merrill, who had worked at the district attorney's office in Lubbock, Texas. Halford's lawyers were planning to mount the defense that most physicians used when charged with abortion, namely that the abortion law was vague and therefore unconstitutional. Halford would claim that he was unable to differentiate between these cases that fell outside the law. Outside the Article 1196 of the Texas law, which stated that abortion could be performed on medical advice from a physician in order to save women's lives, and those that were not covered under this section. Nothing less than Halford's medical license was at stake. If found guilty, he would lose not only his medical license, but also his professional standing within the community. To exonerate him, therefore, his lawyers were seeking any tactic short of permitting their client to plead guilty. Merrill, who did most of the legwork in the case, was engaged in a series of ongoing talks with prosecutor John Sparling, which were held in the judge's chambers. At first, Merrill hoped he and Sparling could cut a deal, and to this end had suggested that constitutional issues might be at stake. He implied that he might ask for an injunction to stop District Attorney Wade from further prosecution of the case until this was cleared up. State Judge Jerome Chamberlain, who was in charge of the case, told Merrill that he had no chance of getting an injunction to prevent Wade from prosecuting any more abortion cases. Merrill thought the judge and the DA's office were taking an unusually tough stance on this case, a fact he found painful because he had become close to his client. Merrill had spent hours with Halford going over the case. He found the doctor quite likable, and most important, the young lawyer believed his client's motivation for doing abortions was honorable. He hated to think that there was little he and Bruner could do to save Halford's license, or worse, keep him out of jail. Having pulled all the strings he could to save his client, he was becoming resigned to the unhappy outcome when Bruner called him one day and said he had a new strategy in mind that they should discuss. A few weeks earlier, Bruner had suggested to Merrill that constitutional issues must be involved, but had not spelled out what they were. When the judge dismissed the notion in so peremptory a manner, Merrill considered the issue settled. Now he was pleasantly surprised to learn that his boss had been doing some research on his own. It was clever, but not uncharacteristic of Bruner to make a suggestion like this. Unlike most criminal lawyers, who had relatively little law outside their specialty, Bruner liked to look at the big picture and took pride in keeping up with the theoretical side of the law. Now he had obtained copies of Peoples v. Belos and U.S. v. Spooch, the same two abortion cases Coffey and Weddington had found. Bruner briefly described the two decisions to Merrill and then handed him the opinions he could read so he could read them for himself. If Merrill agreed that they formed the basis for an argument that the charge against their client was unconstitutional, they would reopen the issue with the judge. Bruner particularly liked the Belos decision because it came from the California Supreme Court. Like many other lawyers, he admired that court for its forward-looking decisions and considered it to be a sharp shaper of political policy in the United States. If the California Supreme Court thought abortion was a ripe issue, Bruner believed that the U.S. Supreme Court could not be far behind in its thinking. Word was out that the U.S. Supreme Court brethren paid attention to the opinions of the California Supreme Court. And with these two decisions, Bruner no longer had any doubts that abortion was a constitutional issue. Merrill studied the cases and got back to Bruner right away to tell him that he agreed with his idea. The more he read about the circumstances of the two cases, in fact, the more he saw a parallel between their plaintiffs and his client. Confident there was a good chance that the crime of which his client was accused was unconstitutional, he called Judge Chamberlain's chambers to request a meeting with the judge and the prosecutor. When consulted this time, Judge Chamberlain agreed that the case properly belonged to a federal court. Although he knew it would infuriate the prosecutor to see an indicted abortionist slip through his fingers, Chamberlain said he had no choice but to pass this case on to the federal court rather than hearing it as a criminal case. Feeling that a majority victory had been won, Merrill was elated. The next day, while preparing a request, a three-judge court for their client, Merrill heard about Roe v. Wade on the radio. As far as he was concerned, the fact that another case had already been filed was his second break. As soon as he arrived at work, Merrill talked to Bruner, who agreed that they should at least talk to the lawyers on Roe v. Wade. Within minutes, Merrill was on the telephone talking to Coffey about their cases. He pointed out something she was already well aware of, namely that she did not have anyone representing the medical profession, let alone anyone accused of abortion. Merrill did not have to plead his client's case very strongly. Coffey saw the merits of Merrill's proposal to have his client join her cause as an intervener. She said she would have to check with her co-counsel since both women had discussed this problem at great length. it would only be a formality. As it turned out, their arrangement suited everyone. Coffey and Weddington had a stronger case, and Bruner and Merrill had found their way, temporarily at least, to stave off a jury trial for their client. But even if Coffey and Weddington had declined to let Halford intervene, Bruner and Merrill would have filed a petition challenging the Texas state law, and their case would have probably have merged with Roe v. Wade. On March 19th, 2 weeks after the original complaint was filed, Halford officially applied to intervene in Roe v. Wade. 5 days later, he was granted permission to do so by the court. Merrill and Bruner requested and got a postponement of the trial against their client, pending the output of the federal case. Even from the district attorney's point of view, Halford's entry into the case changed things little. Toll still did not think he stood a chance of losing, and if you polled the average person on the street in Dallas, he or she would have agreed. Although Toll did not think Coffey and Wellington would file a false affidavit or sue without a real plaintiff, he still wanted to depose Jane Roe. The more he could learn about her, the better his defense would be. In any lawsuit, parties try to force disclosure of information, facts, deeds, or papers in the other party's possession so they can better defend their position. This often drawn-out process is called discovery. One frequently used technique of discovery is deposition, in which a witness is questioned under oath by the other party's lawyers. Toll's primary motivation for deposing Jane Roe was to see for himself how pregnant she was. He was not overly confident that McCovey had no standing to sue, but if he could establish that she was too pregnant to undergo an abortion, he could ask for the case to be dismissed on those grounds. Given the time it took to prepare a federal case, Toll thought it reasonable to look into this. He knew he was supported by many legal experts on both sides of the abortion debate in his belief that such cases were inevitably moot because pregnancy was a self-terminating condition. His other motive for deposing Roe was that he might uncover something in her character that would make her an unsuitable plaintiff. Perhaps she was not as poor as she claimed, or perhaps she lived with a man who was willing to support her and the child. If he deposed her, her true identity would probably be revealed, not only to him, but to the news-hungry press corps. If they were nosy enough to follow up the case, they would do his dirty work for him, and if she were unwilling to have this happen, she might order her lawyers to drop the suit. Either way, he came out ahead. On March 27th, Toll filed a formal request to depose Jane Roe on April 11th in his office. For a week, while Judge Sarah Hughes privately weighed her response, in this request, Coffey and Weddington stewed. They were afraid they might not be able to get in touch with Norma if she had to be deposed. A bigger worry, though, was that she would back out rather than risk having her identity revealed. The two women began to feel that the case was slipping through their fingers before it had even begun. They contacted Norma to explain what is happening and were pleased to hear that she felt strongly enough about the case to be willing, if there was no alternative, to be deposed and to take the consequences. Coffey and Weddington promised they would try to arrange something short of a deposition. They decided to ask for a meeting with the district attorney in the judge's chambers and submit information regarding their client's identity. If the information were officially revealed in camera, to use the legal expression, it was still possible that McCovey's identity could be kept secret. Both lawyers hoped that would satisfy everyone. The district attorney's request to depose Jane Doe ultimately did not carry much weight with Judge Hughes, who saw no reason to force a woman suing for an abortion to reveal her identity. Although she denied Toll's request to question Jane Doe, Judge Hughes did express concern about the use of an alias. While not unheard of, they were somewhat rare. Believing she should satisfy herself, her fellow judges, and one presumes the historic record by ensuring that Jane Doe is a real person, Hughes ordered Linda Coffey to submit an affidavit in which Rowe testified under oath that the facts of her case were as presented. Linda Coffey interviewed her client in her office. The affidavit, a telling document for as much as what it does not say, still stands as one of the few definitive biographical statements about Norma McCovey. Later, when Norma began talking to reporters, it was sometimes difficult to sort out the different versions of her life that emerged in the press. The affidavit remains a poignant report, not only for her, but also for the plight of all poor unwed mothers. The facts. 1. Plaintiff Jane Doe is an unmarried woman. 2. Because of economic hardships and social stigma involved in bearing an illegitimate child, plaintiff wishes to terminate her pregnancy by means of an abortion. 3. Plaintiff's life does not appear to be threatened by the continuation of her pregnancy. 4. Plaintiff has been unable to secure a legal abortion in Dallas County because of the existence of the Texas abortion laws. 5. Her inability to obtain an abortion has caused plaintiff to suffer emotional trauma. 6. Plaintiff cannot afford to travel to another jurisdiction to seek to secure a legal abortion under safe clinical conditions. 7. An abortion performed by a competent licensed physician under hospital or clinic conditions is a safe and simple procedure which presents less danger to the pregnant woman, particularly in the first trimester, than does ordinary childbirth. 8. An abortion outside of criminal settings by an unqualified personnel is extremely dangerous and often results in death, maiming, sterility, and infection. Nowhere in the record is Jane Doe's true identity revealed, nor is any mention made of her claim that she was raped. Once the crisis of whether or not to depose Jane Doe was resolved, the case moved along fairly smoothly from the points of view of both parties. In mid-April, Coffey wrote a motion asking for a summary judgment. Such a motion is a legal pleading to the effect that in the absence of any factual disputes, there is no need for a jury trial, and thus no need to call witnesses or hear evidence. Such a judgment could only be issued when there is no dispute over the facts of the case. That is, when questions raised are purely legal and can be decided on the issues involved. Coffey had determined that the motion for a summary judgment was in order because of a rumor she had heard. As a former law clerk in the Fifth Circuit, she had maintained a pipeline to the court. Her primary source of information was a clerk of Judge Hughes, who kept her abreast of the scuttlebutt on court cases. He relayed the information that Judge Irving Goldberg, a panel member, reportedly had been heard to say that he did not want a lengthy trial and saw no need for expert witnesses or indeed witnesses of any kind. He wanted to review this case purely on the issues involved. Coffey and Weddington were pleased to pick up this bit of court gossip since it reinforced their belief that they need not go through the time and considerable expense of providing expert witnesses. They also read it as a sign that their client would probably not have to testify. And even though most legal experts would say this was wishful thinking on their part, they also chose to take it as a sign of encouragement, believing that the judges might be predisposed toward their case. Although Coffey wrote the motion as a summary judgment, it was filed in Halford's behalf, probably a bit of subterfuge designed to allay any suspicions regarding the source of the information. If so, the ploy was unnecessary because it was not at all unusual for a three-judge case to be decided on the merits without hearing evidence. The motion of a summary judgment was denied and a hearing was held, although no witnesses or further evidence was presented by either side. Dr. Halford's lawyers filed a short brief in his behalf in mid-April. In it, among other things, they issued a plea for damages, a ridiculous request for someone charged with criminal activities. This irritated John Toll, who, in response to what he considered one ludicrous motion, filed another ludicrous motion, a request for a jury trial. It was impossible to have a jury trial in a federal appellate court, but then Toll thought it was impossible for Halford to hope to be awarded damages. As far as the district attorney's office was concerned, Halford was lucky not to be in jail already. Judge Goldberg, in whose court these requests were filed, was amused by them both and equally quick to recognize their preposterous nature. He denied Toll's motion for a jury trial. On April 22nd, Coffey reluctantly amended Roe v. Wade to a class action suit. Although she loved class action suits, she did not feel that the abortion case needed to be a class action. The advice to amend the suit had come through Sarah Weddington from some New York abortion reformers to whom she had occasionally talked. They had expressed their concern that a federal court might hand down an important abortion ruling that would not apply to all women. Coffey felt that any ruling would have to apply to all women, since the courts could hardly rule that Norma McCovey could have an abortion, but no other Texan could. Usually mild-mannered, Coffey resented what she deemed to be an intrusion in her case. Perhaps she sensed it was an omen for the future, or perhaps she was merely being possessive about what she thought belonged to her. All that remained now was for parties to file briefs. Briefs written for three-judge courts are only a few pages of straightforward, factual material, unlike the longer, more detailed, and occasionally brilliant briefs that are delivered to the Supreme Court. Toll prepared a brief representing the views of the district attorney, while Coffey stayed up several nights typing her brief. On the same manual typewriter in which she had prepared the original proceedings, she picked out 18 pages in which she merely related the facts of the case and the arguments for overturning the restrictive law. The women's group at the Unitarian Church submitted a short amicus curiae brief in support of Roe and the Does. All avenues of legal dispute having been used up by both sides, an oral hearing was set for May 22, 1970. When Coffey and Weddington began working on Roe v. Wade, they did not know anyone else in Dallas or even Texas who was working on abortion reform. In fact, she had no contacts anywhere in the country with other reformers. They did not know about any national groups organized around abortion reform, although one, the Association for the Study of Abortion, ASA, had been in existence since 1964. An educational rather than lobbying group, it focused its early attentions mainly on doctors and other professionals whose lives would be affected by reform. Another group, more oriented to the average woman, was in the early stages of organization. The National Association of the Repeal of Abortion Laws, NARAL, held its first public organization meeting in February 1969 at the Drake Hotel in Chicago, just as Coffey and Weddington were most immersed in preparing their challenge of the Texas law. Grassroots groups working to pass reform laws had come and gone in several states, most notably Colorado, North Carolina, and California, all of which had passed liberal reform laws in 1967. Liberal meaning that for the first time abortions could be done to preserve a woman's health as well as her life. A year later, in 1968, Georgia had passed a reform law, and a repeal bill was introduced in New York in December 1969. In only one neighboring state, New Mexico, were reformers actively involved in reform, and New Mexico's recently passed reform law would go into effect in 1969, shortly before the Dallas reform movement took root. Although abortion reform was in the air across the country, Texas was hardly receptive to it. Texans were too chauvinistic and firmly entrenched in their own ways to seek any kind of social change. In the state, they had eagerly sought annexation to the United States during the 10 years from 1836 to 1846, when it was an independent republic. It was not surprising to find a large number of citizens who maintained a fierce loyalty to states' rights, and abortion was viewed from the start as a states' rights issue. If changes were to be made in abortion laws, states' rights advocates argued they should be made through the legislatures and not through the courts, especially not through a federal court that had no business meddling in the state's affairs. Coupled with this was an equally portentous feeling that the emerging women's rights movement, even though feminism, which like abortion reform was more an ideal than a reality in the late 1960s, had barely made its way to Texas, the mostly male legislators who ruled the Austin State House did not like it. No one would catch them catering to a liberal cause. All over Texas cities, politically and fiscally conservative Dallas, best known to most Americans as the place where John F. Kennedy was assassinated, was least likely to give rise to a reform movement. For years, it had been viewed as a breeding ground for the most unbending and radical kind of political conservatism. Despite its outward image, though, inner changes were occurring, changes that were mostly promoted by concerned Dallasites who were embarrassed over the city's image in the wake of the assassination. Liberals, who had long since abdicated political control to the conservative establishment, now thought the time was right for a swing to the left politically. And although they were not looking for a radical cause, as abortion was considered to be in 1969, they were more open than they had been in years to the kind of social reform that typically accompanied a swing to the left. As nearly as any of the participants could recall, abortion reform in Texas began in late fall 1969, when Virginia Whitehill, a Planned Parenthood board member, responded to a request from the local Unitarian church for someone to speak to them about abortion. At that time, the Unitarians were the only Protestant denomination to have taken a strong stand on abortion. In 1963, their General Assembly had passed a resolution condemning the restrictive abortion laws as an affront to human life and dignity. They supported legalized abortion to protect a mother's life and physical or mental health in cases of rape or incest, serious fetal deformity, and whenever a compelling reason, physical, psychological, mental, spiritual, or economic, existed. Despite their early concern, little happened in Unitarian circles until 1969, when abortion became a more pressing church concern. Another church-like resolution had passed that year in support of the clergy, many of whom were Unitarian, who were working with the Clergy Consultation Services on Abortion, a New York-based organization with local branches that provided counseling and referrals to women with problem pregnancies. In keeping with the growing sense of militancy about abortion rights, many Unitarian clergy also began to preach about women's rights and abortion. The Women's Federation, the National Unitarian Women's Group, voted to make abortion a #1 priority in their programs. The Women's Auxiliary of the Dallas Unitarian Church had been studying the issue of abortion for about a year when these resolutions were passed in 1969. Linda Coffey had been one of their great guest speakers, and now they wanted to hear from a representative of Planned Parenthood. Virginia Whitehill had never before given a speech, but she was naturally gregarious and interested to learn more about abortion. So she volunteered to talk to the Unitarian women. Her interest in abortion stemmed from her volunteer work at Planned Parenthood and her equally active membership in zero population growth. She had been unable to interest the local Planned Parenthood in the abortion issue, and this she attributed to fear of their losing the public monies they had been pouring in during the past few years if the organization began lobbying for a political cause. In fact, neither Planned Parenthood nor any other group involved in population control had ever shown any support of abortion rights for women. However logically aligned the interests of birth controllers and advocates of women's rights seemed to be, the interests and goals of the two groups were essentially incompatible. Feminists promoted individual choice. They believed women should control their own reproduction, including having whatever means were available to terminate an unwanted pregnancy. In contrast, the highly influential birth control and population activists who believed the world population was growing at an alarming rate sought stability above all else. Their goal could be, and eventually was summed up, in one despicably jingoistic slogan, zero population growth, which meant that the birth rate should correspond directly to the death rate. Where feminists wanted to redefine and reshape men's and women's roles, birth controllers firmly supported the nuclear family, which they saw as a key to maintaining stability. Putting control of reproduction in the hands of individual women was the last thing they wanted, since they advocated national and even worldwide controls on population growth. As a result, even though birth control and population activists supported the use of various forms of birth control, abortion was never one of them. For example, during the 1960s, non-military foreign aid went only to countries that followed a stringent program of family planning, the guidelines of which were established by the State Department. Abortion was not part of the package. Population and birth control was believed a relationship existed on the one hand between poverty and a high birth rate. If women had fewer children, poverty would vanish and be diminished. Feminists, on the other hand, thought better health care, especially prenatal health care, would help women and children who lived in poverty-ridden areas. They thought it was discriminatory to ask or expect poor women to have fewer children because they were poor. Despite her active membership in Planned Parenthood and zero population growth, a popular population control group throughout the late 1960s and 1970s, Virginia Whitehill still found herself interested in abortion. She did not see any conflict between granting women the right to obtain abortions and attempts to regulate population growth. In fact, she feared that the drive to reduce the population would reach only the educated, more aware women. She thought poor women would pay no attention because they were not consciously attuned to anything as sophisticated as a movement to control population. Yet these were the very women Whitehill thought should have access to birth control and abortion. Whitehill prepared a speech that consisted mostly of statistics on the number of illegal abortions, the number of abortion-related deaths as high as 10,000 a year, according to some experts, all of which pointed to the need for abortion reform. Pat Cookson, another Planned Parenthood volunteer, agreed to accompany her on her first public speaking engagement. Whitehill proved to be an adept public speaker. She had a natural talent for persuading people to her point of view and spurring them to action. Not that the Unitarian women needed much persuasion. While Coffey had talked to them in relatively abstract terms about the legal action that was needed to overthrow the state's abortion laws, Whitehill made the issues surrounding abortion personal. She had declared any one of the Unitarian women, or one of her daughters or sister or a good friend might desperately want and need to terminate a pregnancy and be unable to do so, except under fighting, unsafe, and humanitarian circumstances.
Would this sister recognize another citizen for a question?
Yes, thank you. This has been Cynthia Wilcox, Jefferson City, Missouri.
And I am Sue Gibson. Most women, especially poor women who did not know how to operate within the system, were unable to terminate a pregnancy, even when it occurred under the direst of circumstances, such as rape or incest. It is the personalizing of an issue like abortion that leads to grassroots activity, and White Hill managed to make abortion a very personal issue indeed as she talked to the Unitarian women. The Unitarian women responded enthusiastically to her cry for reform, but they also knew they had gone as far as they could with abortion within the confines of the church. Her invitation to speak had come at the end of a year of study of abortion, and besides, the Unitarian Women's Group was neither a single issue nor a political organization. Still, a few women within the group could not give up the idea of taking some action on this pressing issue. They clustered around White Hill after her speech to ask what could be done. Someone suggested that they organize a new separate group around the issue of abortion. The idea produced great excitement. Telephone numbers were exchanged and promises were made to call immediately and begin setting up the new group. Within days, the telephone lines were buzzing as the women began to organize. They were not inexperienced at this. Most of them had volunteered considerable time for various liberal and civil rights causes. Also, they were not typical abortion reformers. What set them apart was that they were all middle-class housewives, and not particularly disgruntled ones at that. Supported by their husbands, they were women who chose to volunteer rather than work at paying jobs. Although intellectually sympathetic to many elements of the equal rights movement, feminism per se held no appeal for them. In fact, some of them opposed it. They had read Betty Friedan's book and found it thought-provoking, but it did not enrage them. It did not provoke them, as it did some women, to leave their husbands and children and embark on the search for a lost identity. True, their marriages seemed to be breaking up at the same rate as everyone else's, and they rejected the exaggerated sex roles thrust on them in the 1950s. But their rebellion against the feminine mystique was much gentler than most feminists experienced. They firmly rejected the radical path, not because their husbands would object or because they were ignorant of it, but because they truly were middle-of-the-road reformers. Yet it was women like these who formed the broad base of support necessary for a theoretical issue like abortion to be translated into action. They formed a true grassroots movement, one that was neither radically oriented nor professionally organized. In large part, their success could be attributed to their being in the right place at the right time. When they began to organize, the time was right, and they were in the right state to make the most of their mainstream attitudes. At the nucleus of the group was Virginia Jenny Whitehill, whose petite, delicate blonde looks and beautiful clothes belied her political savvy and intellectual toughness. She had graduated from Mount Holyoke College in 1950 with a degree in history, to which she attributed her lifelong interest in current and historical events. Left with two small daughters to rear after an early marriage ended in divorce, she had moved in with her parents in Pelham Manor, New York, a Westchester community north of New York City, and had taken a job in the city with the Rockefeller Foundation. She worked there about 2 years until 1959, when she married an old high school friend, James Whitehill, a Princeton graduate who worked as a manufacturer's representative. It was while working at the foundation that she formulated many of her ideas on population control. John D. Rockefeller had always been interested in population control, and he could be said to have bequeathed his interest, along with the funds to do something about it, to the Rockefeller Foundation, which subsequently and peripherally handed it on to Jenny Whitehill. Her experience at the foundation, better than a master's degree, she would recall, left her with a strong continuing interest in population control and philanthropic work. Jenny and James Whitehill settled in Dallas after their marriage. Shortly after arriving, they joined a local Presbyterian church as a means of getting acquainted, and Whitehill was invited to join the women's group. To her horror, the group's primary activity consisted of rolling bandages for cancer patients, a task Whitehill found condescending. She was sure that a machine could better perform the task anyway. Miffed at being asked to do this kind of work, she withdrew from the church group and began volunteering at Planned Parenthood. When the women's movement began to organize in the 1960s, Whitehill was interested in action. She believed in equal treatment for all people, and her husband supported her in that belief. She joined the National Organization for Women when it formed. The president of the Unitarian Women's Group also played an active role in organizing the new abortion group. Ellen Kalina, an attractive dark-haired woman, was reared a Roman Catholic and had 5 children by her first husband before she joined the Unitarian Church and began to reevaluate her attitude toward women's rights and contraception. Another Unitarian, Pat White, the mother of several children, also helped with the initial organizing and offered her house for the early meetings. As program chair of the Unitarian Women's Group, she had been responsible for inviting the guest speakers who came to talk to the group about abortion. Within a few weeks, Doris Hinsarling, who would in 1976 divorce and take back her middle name of Middleton, had joined the core group of reformers. Middleton, whose can-do spirit made her a female counterpart to President Jimmy Carter, would have been one of the founding members of the Dallas Reform Group, but for her love of music. Her husband and 3 children attended the Unitarian Church, while she stole off to the Episcopalian Church because she enjoyed the ritual and the music. When she learned about the group that was forming around the abortion issue, she joined immediately. More than anyone else in the group, she was sympathetic to the feminist philosophy. But at the same time, Middleton firmly believed that radical politics alienated legislators and that in a state like Texas, they would not work. Well aware of her power, she nonetheless proudly viewed herself as a behind-the-scenes worker. The group's most immediate needs were for money to operate and a place to meet. But before the women could work on these things, they had to settle on a name for their fledgling group. They spent many hours trying to find just the right name, one that would not, they hoped, irritate people before they had a chance to present their case. The name would go through several incarnations, but in the organizing stage, they settled on the Dallas to Study Abortion, which bore a marked similarity to the oldest and most prestigious nationwide abortion reform group, the Association for the Study of Abortion. It was fitting, since both ASA and its smaller counterpart in Dallas had as a common goal a desire to interest and inform people about abortion. Of course, the members of both groups were also optimistic that anyone who studied the abortion issue closely would conclude that liberalized laws were needed. Whitehill took it upon herself to try to raise money for the fledgling group, an effort that met with success almost right away. Within a few weeks of the night when she spoke at the Unitarian Church, she had 2 pledges, each in the amount of $50. One came from the Council of Jewish Women and was arranged by Carolyn Tobian, a member of a prominent family active in political and religious circles in the city who would also join their group. The second came from the Women's Auxiliary of the Dallas Unitarian Church. Unused to raising money, Whitehill soon realized that getting the first contribution was the hardest part. After that, she got braver. Thumbing through her address book, she began calling anyone she thought might be remotely interested in helping out. Since she was, by her own admission, probably the only woman in Dallas who belonged to both NOW and the Junior League, Whitehill had many contacts on all levels of Dallas society. Furthermore, Although a firm believer in liberal causes, she nonetheless maintained memberships in several conservative groups. Partly she did so because conservative memberships helped her stay in touch with what other people were thinking, as well as what the opposition was doing. But she also joined these groups because she was a firm believer in single-issue politics and believed, accurately as it would turn out, that even within the membership ranks of the more conservative groups, she might muster support for some of her more liberal causes. When Whitehill began soliciting funds for the abortion group, she called liberals and conservatives alike, confident of the abortion issue's broad appeal. Whitehill did manage to raise $500, a lot of money in 1969, from one conservative contributor, a Dallas Society matron not known for her interest in either liberal or radical causes. Whitehill talked to her about the need to support abortion reform because it would help control the population and prevent famine in third world countries. In contrast with her approach to the Unitarian women, she was careful not to put the issue into personal terms. The woman agreed to contribute $500, but within moments of hanging up the telephone, she called Whitehill back. In the high-pitched, girlish voice for which she was known, she whispered, "Jenny, this is not one of those women's liberal groups, is it?" "Oh, no," Whitehill replied. "I think it's just about one issue. Now, if other people who are working on this want to work on other issues in other groups, we can't stop them, but this is just for one issue." Thus reassured, the woman put her check in the mail. Once Whitehill saw that she could raise money from people who would not necessarily support women's rights, but would support abortion rights, she determined to do what she could to keep the Dallas Committee to Study Abortion a single-issue group. Finding a place to meet proved to be more difficult than raising money. People could donate money anonymously, but the organization that offered a meeting room to an abortion rights group would be perceived as being firmly in the pro-choice camp, and abortion was rapidly becoming a highly controversial topic. During the first few organizational meetings, the women stored their files and supplies in their dining rooms and met in each other's living rooms. Eventually, Pat White's home became the group's headquarters, and their mailings bore her return address on Ridgeview Circle. But the women knew, or hoped, the day would soon come when they would need a public meeting place. They had begun to plan their first public meeting for February 1970, and already believed they would turn out enough interested persons to require a public hall or meeting room. The women found out just how controversial abortion was when they began calling various local organizations, Planned Parenthood, Zero Population Growth, the churches, to ask if the groups could donate a meeting room and some office space. Many of the people they talked to whispered support, but were unwilling to take so public a stand in them a meeting space. Reverend Dwight Brown, the Unitarian minister and a man who would prove to be one of their staunchest supporters, offered a meeting room and an office in the Unitarian Church. By January 5th, 1970, enough money had been raised for the fledgling group to draw up a budget. The women had raised $1,022 in dues and contributions and had spent $203.96 in printing costs to prepare their first mailing. Whitehill had donated $31 in postage. They had also begun to establish important contacts with politicians and were regularly recruiting new members. Among their important political contacts was Texas State Senator George Parkhouse of Dallas, who in 1967 introduced a Senate bill to reform the Texas law. As was the case in most states that passed reform laws between 1967 and 1968, it was modeled after an abortion law written in 1959 by the prestigious American Law Institute. as part of a proposed model penal code. The ALI law, which became known as the Therapeutic Abortion Law, was conservative, conforming to the kind of abortions that many doctors were doing anyway. The fact that it permitted abortion only in cases of rape, incest, severe fetal deformity, or when the woman's physical or mental health was threatened, meant that many women who needed abortions would be denied them. No attempt was made to establish or protect a woman's abortion right. There was no suggestion, for example, of abolishing the Hospital Therapeutic Abortion Committee that kept control of abortion in the hands of physicians and away from women. In addition, many of the states that passed laws modeled along ALI lines added residency and consent requirements. Although Parkhouse managed to get the bill out of committee, he was unable to muster the 2/3 vote needed for consideration by the full Senate. Interested as the senator was in abortion reform, he was not especially receptive to the newly formed Dallas Committee. He had initiated reform long before the ladies, as he thought of them, came along, and he saw no reason to go out of his way to curry their favor. When Parkhouse retired after the 1967 legislative session, the women thought there might be no one in the Texas legislature interested enough to work on abortion reform. The legislature met in 1969, before the group had gotten organized, but the women had noticed that a relatively new member of the House of Representatives, James Clark, was sponsoring an abortion bill in that chamber. Elected to the legislature in 1966, Clark had taken over an abortion bill from a departing colleague. It was just the kind of bill that junior legislators got stuck with. But Clark's interest in abortion proved to be genuine, tied as it was to his more general interest in family law. His willingness to work in abortion reform stemmed from a visit to a state school for severely retarded persons, which had left a deep impression on him. Clark saw a connection between those poor souls and abortion rights that he described in the following way. I don't think that the same God that gave us rationality to learn these things, how to do abortions, intended us to do nothing with the information. The Catholics would jump on me. They would say we must work to take better care of the children. Well, we've had thousands and thousands of years of Christian tradition, and we haven't done it yet. Clark was handed an ALI-type bill, now viewed by most reform groups, including the Dallas women, as too conservative, primarily because it did little to give women any greater access to abortion. The bill had restrictive provisions involving residency and consent requirements that were not part of the ALI model bill. Clark made a few changes to liberalize the bill even further, so that it would provide more women with access to abortion than was the case with the ALI-type bills. And even though he suspected the bill was doomed from the start, he submitted it for committee review. He was warned by fellow legislators that even if his bill made it out of the House, the Senate intended to substitute the less liberal and more favored ALI format. As it was, Clark's bill never made it out of committee. When the Dallas Committee learned about Clark's efforts in behalf of reform, they contacted him. I certainly will, my fellow Missourian. Okay.
Thank you very much. For as long as there have been humans, there have been stories. The stories in this book chronicle what makes us human, the ability to shape our destinies. For as long as there have been humans, we have tried to determine our reproductive destinies, to have children when we want to, and not to have children when we are unprepared or unable to care for them, just as Chrissy has done. If it weren't for you guys, a lot of people's dreams would never come true. Becoming pregnant is a scary thing. I've learned a great lesson, and I never want to have to go through something like this again. I now realize that doing one little thing can ruin your entire life and mess up all your dreams. You have given me a chance to go for my dreams and succeed in life. If I ever have a child, I wanted to have the best that I could possibly give it, with a father and mother who love it. I was an unexpected child that perhaps shouldn't have been born, but since I'm here, I'm going to strive to make things better. You have given me the chance to make my life the way it should be. Thank you. Chrissy, age 16. To me, this letter says it all. I have kept it since the day I received it from Chrissy years ago. I read it often. It reminds me why reproductive rights are so important. It gives me courage in the face of attacks. It inspires me to remember that beyond every choice, there's a story as unique as the human being who makes it. Today, quiet, small voices like Chrissy's, which express very personal and conscientious childbearing decisions, are too often drowned out by the public roar of those who deny women the moral standing, the legal right, and the practical access to reproductive self-determination. I have written this book because I believe we owe it to these women to let their voices ring in testimony to the fundamental human and civil right to make their own childbearing choices. In order to retain the unique voices of the contributors, I have left the quotes from letters largely unedited. Names and other identifying factors have been changed, except where the authors have kindly allowed me to identify them. Ages were known as are actual. The issues of sex and reproduction and the reality of our individual lives reach far beyond childbearing into every corner of our hearts, minds, and souls. To express sexual love, to nurture a family, these acts are the essence of our humanity. I have learned from the 3 decades of my work with Planned Parenthood Federation of America, and from my own experience as a mother, that in a woman's life, these issues take on another, almost unfathomable layer of meaning. The choices we make manifest themselves in our bodies, define our lives, and become our stories. I have also learned from reading thousands of letters and listening to so many real stories that the issues are broad and complex. They include the relationship between reproductive choices and other life choices, the moral dilemmas that arise when worthy values compete for preeminence, and the ultimate question of who, by law or social convention, gets to make these decisions. If you think this is a book about abortion, think again. Many stories in this book are about abortion, to be sure, but most are about many other, often unacknowledged facets of reproductive life. Here's what reproductive choice means to women in the words of Alyssa, a 26-year-old mother. Reproductive choice gives me the opportunity to give myself totally to the kids I already have. Not having more children by choice allows me to be a bigger part of the lives of the children I have. People tell me they wish something as personal as childbearing decisions were not so polarized and politicized as they have become today. So do I. Telling our stories can help lead us to that place. For when we open our hearts and listen carefully to real-life experiences, we come to understand that even the hot-button abortion issue isn't about abortion, really. Opening our hearts and minds to these experiences forces each of us to examine what we believe about the nature and purpose of human sexuality, whether women should have an equal place at life's table, how children are valued, how women's lives and bodily integrity should be respected, and how individual liberties and social justice are defined. It's about the whole person in the fullness of our lives. In short, it's about a worldview. Yet in real life, whatever your worldview, sexual and reproductive issues beg to leave the political arena. Real human life is a lived one person at a time, one choice at a time. Not since Margaret Sanger, the mother of the birth control movement and founder of Planned Parenthood, published Motherhood in Bondage in 1928, have stories like these been told in this way. Like the women who wrote to her desperately seeking the knowledge that would give them control of their own lives, people today write to the organization that carries on Sanger's legacy with their heartfelt, compelling stories of despair and hope, fear and courage, defeat and triumph, ignorance and awakening. Today there are many similarities with Sanger's day. The basic human concerns of sex, love, health, and wanting a better life for one's children are timeless. Yet there's a profound difference. Then, women already had more children than they felt able to care for, and they wanted to know how to stop. Today, most women start using birth control before they have their first child, giving the term family planning full and joyous meaning. The writers of today's stories are exceedingly diverse in age, ethnicity, geography, and more. They include men as well as women. Some write long and involved letters, others write single phrases. Letters come daily from various sources. Many arrive on my desk unsolicited. Some are from people who write after they've used reproductive health services. Some come via the Planned Parenthood websites. A few are from individuals who I knew I was writing this book. What they have all in common is this. Each is seeking to make her or his life's dream come true. I found that the stories group themselves naturally, first into personal reproductive life cycle issues, which make up the first 2 sections of the book, and then into the personally political issues that become the last 2 sections. Perhaps it is not surprising that while I was assembling other people's stories, I realized my own life had followed the same pattern of personal experience. succeeded by, or perhaps triggering, political awakening, and so I decided to share my story with you too. I became convinced that the telling of our personal stories is the most powerful antidote to political assaults. One of the women who wrote to me is Bobby Osley, a mother of 4 from Austin, Texas, who with her husband, Tom, decided to share with her college-age children, and then with her community, the story of their abortion decision. You'll read it later in the book, but here she tells us why she speaks out. Why have I taken the risk to share this personal experience? My story is not unique. It is the story of many women and their families who walk among us. Hopefully, by putting a face on this issue, people will more fully understand the human element involved in this controversial debate and thereby be renewed with courage and compassion to continue fighting for a woman's right and need to make that decision. Reading these stories from my vantage point as Planned Parenthood's leader today, I can see Margaret Sanger as I am standing in a kaleidoscopic mirror with her. Our images blend with the writers of these letters. We are all reflected from a myriad of angles, just as the realities of our individual lives reflect a myriad of choices, both universal and infinitely unique. But ominous shadows lurk in the background. They threaten to overwhelm the hopes and dreams of the people who share their stories with us. That's exactly why I feel such urgency to tell the stories now. First, we're a long way from a world where Chrissy, Lisa, Bobby, and others like them can realize their dreams. Sex is still too often treated like a dirty word in this country, and sexual health is not discussed, to the detriment of our children and even adults. Many people in the U.S. and abroad lack access to the most basic reproductive health care. Our culture is only slowly learning to value girls and women as it does boys and men. And each new generation needs something different from this movement as technology and society change. Second, the gains we have made face unprecedented challenges from those who oppose reproductive self-determination, and they're aided by a president, Congress, and state governments aligned to take our choices away. We face a political crisis of monumental proportions. The Copernicus web of assaults on reproductive rights and access to reproductive health care. The global gag rule, the building of a legal platform to overturn Roe v. Wade, and dramatic increases in abstinence-only sex education, while family planning appropriations decrease. Roe itself is held tenuously by a razor-thin, one-vote margin, and anti-choice President George W. Bush will almost certainly appoint the justice who will cast a deciding vote that either sustains reproductive choice or sends its death knell. In the 30 years since we legalized abortion and affirmed, once and for all, we thought, the woman's right to make her own childbearing choices, the vast majority of Americans have had the luxury of taking our reproductive freedoms for granted. But in our post-September 11th world, we have all learned, tragically, that freedom's champions must be ever vigilant. And so it is with the champions of reproductive freedom. I hope this book will serve as the clarion call before it is too late to say what has been won. But more importantly, my message is one of great hope and an exhortation to advance our unfinished 21st century agenda. We must settle the legal right to reproductive self-determination and create a supportive social climate which includes universal access to reproductive health care services that make those rights meaningful. I am utterly convinced that the most compelling voice of this clarion call will be our stories, not the braying of the anti-choice politician or the shrill pontifications of the talk show hosts. We must go back to the source, to the stories of the people, like you and like me, whose lives are so profoundly affected by the freedom to choose. Today, I stand by Margaret Sanger's side in the mirror. I see great hope and huge advances. But I also see my anguished faces among the people who write me. And I was there once. My own choices have defined my life, fueled my passion for social justice, and led me to devote my life's work to this mission. I married at 15 and was the mother of 3 at 20. My gradual awakening to the injustices that occur when women are denied fundamental human and civil rights are the services that make rights meaningful, and my concerns for the well-being of children here in the U.S. and abroad have opened my heart even wider to the stories and choices of others. And on the most visceral level, I know I would not be here sharing these stories with you today were it not for the birth control pill that enabled me to live my own fertility and begin to make my dreams come true. Perhaps you too have a story, and if you do, I will hope you share it with me so that together we can ensure that future generations will experience the great blessings in motherhood and freedom. I don't think adults realize the constant pressure put on teens today. Besides the fact that you always seem to have homework, extracurricular stuff, and work, most of us normal teens have these crazy little inevitable things called emotions. I think most adults believe that the majority of teens just have sex and don't even think about it. But for the most of us, deciding to have sex is a big decision. Teens and adults need to take responsibility. Teens need to remember that even though it may be hard, talking to adults to get proper birth control and condoms is the safest way to ensure your health in the long run. And adults need to remember that the reason why teens feel so uncomfortable talking about these things with them is because they look down on teen sex so much that teens are scared to talk to them about it. Cindy, age 16. My mother visited me in New York a few years ago. One day as we were walking home from Rockefeller Center, she said to me out of the blue, "You know, I don't think I have ever said the word sex to you in my life." I thought for a minute. Because of my job, I probably spend more time talking about sex than any woman in America. "You know," I said, "I think you're right, and as best as I can recall, that constitutes the sum total of our decisions of the subject." So I could feel for Tamika. My mother was not at ease talking about sex or even about the female body. I was at Girl Scout camp when I woke up to a sleeping bag full of blood and thought I was dying. I was too afraid to even talk to our troop leaders. A week later, my mother discovered from looking at my laundry what was going on. She never talked to me about exactly what happened, but she did provide a pamphlet. I just thank God I did not end up a statistic, a pregnant teen. Tamika at age 28. When I was 13, my father handed me a slim paperback titled The Facts of Life and Love for Teenagers. Not that he ever said anything else to me, but at least I had some accurate biological information, in a larger sense, acknowledgement that I was growing up and therefore entitled to know these things. He probably felt pleased to have fulfilled his duty as a parent. My little book became the hottest item at that summer's campfire camp. By the end of the 2-week stay, the book was in shreds. Like most children, my campmates learned about sex from a peer. Me, or at least my book. And my career as a sexuality educator was unwittingly launched. The only problem, other than the fact that my little book was trashed, was I didn't understand much of what I had read, and I was too embarrassed to ask questions. No one in my home said sex. Ancient history? I wish. Not enough has changed. From Jenny now, 19, and in college. The frustration, the pain, the shame and guilt. I was only 15 and I didn't know what else to do. My little sister was pregnant also. We both had just recently lost our virginities and still didn't know what an orgasm was. In my house we talked about everything, but that one topic seemed to stay out of all conversation. Jeremy, 21, says it even more specifically. As a teenager, I was not informed of sex, but by my parents or schools. I had to learn it all on my own, the hard way. In public today, battle lines about sex are drawn all the time. Over condoms, over sex education, over what services a teen courageous enough to go to a family planning clinic can get. Comprehensive, medically accurate sex education gets painted as promoting sex and promiscuity. Contraceptive ads are banished from Fox TV's sexually explicit Temptation Island. At the same time, in private, parents retreat from honest talk about sex. Doctors fail to take sexual histories. School nurses power. Talk is perceived as risky. A parent who merely teaches a child proper terminology for body parts can get into trouble, as Marion found out when her daughter was in daycare. The little boy said, "Do you want to see my Peter?" My daughter replied, "That's not called a Peter, it is a penis." I was called in by the school principal because the boy went home and told his mother that my daughter told him he had a